Calling case number 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Grumander, Ryan McBride, David Sturgill, Lauren Hunt for the state, Jeff Gray, the county attorney, as well as Chris Miller are also present.
Good morning.
Good morning, Judge.
Good morning, Your Honor. Good morning, Your Honor. Good morning, Your Honor.
All right.
Kathy Nestor, Michael Burt, Richard Novak, Stacy Visser here for Mr. Robinson, who's seated to my right.
Good morning, counsel. Good morning, Mr. Robinson. And for the record, the court also recognizes the presence of victim representative, Ms. Erica Kirk. Good morning. First, with respect to courtroom protocol, to maintain security and decorum, any individual who exits the courtroom during proceedings will not be permitted to re-enter until recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices. All right, is it the audio working?
Sorry, Judge, the WebEx audio is not working.
All right, well, let's just take a brief moment. And just let me know when it appears to be working. While we're waiting, if you have any water bottles or such, feel free to drink them. It is a little bit warm in here today, so I will be drinking from my water, so don't hesitate to use that if you need to. Is it working?
It's not working, but we can just keep going.
Can you send them a link to the where this is being streamed so they have something to look at? I see. All right. All right, let's go ahead and continue. And let me repeat it just because the audio may have cut out. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, the court will address the camera operator and still photographer, and I will invite you to come forward. right. The purpose of this is to ensure clarity regarding the expectations governing today's proceedings. Could you both state your name for the record?
Yes, Trent Nelson with the Salt Lake Tribune as the pool still photographer.
John Wilson from KSL Television, video photographer.
Good morning to you both. Have you reviewed the court's standing decorum order?
Yes, Your Honor.
Yes.
Do you understand the requirements set forth in that order as they apply to your activities today?
Yes.
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
No.
Okay. Do you anticipate any difficulty complying with the order or with the court's instructions?
No.
All right. Well, thank you. I appreciate your
Thank you.
cooperation today. As we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with the court's standing decorum order, all spectators shall remain quiet, civil, and orderly during all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or other visible reactions during today's hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or opposing to any person connected with this case, or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, orderly, and faithful to the rights and dignity of every person involved. Turning now to counsel. Before we begin, I wish to acknowledge the professionalism, civility, and competence demonstrated by counsel for both the defense and prosecution during yesterday's proceedings. It is evident to the court that each of you approach this matter with seriousness, preparation, and a deep commitment to your respected responsibilities. The court appreciates the care which you have taken in advocating for your positions and the respectful manner in which you have done so. Thank you. Do either party require the benefit of the record before we proceed?
The state does, Your Honor. Mr. McBride will address the court.
All right. And just as a reminder, the microphones at counsel table are turned off to prevent the inadvertent capture of any communication. So if you would like to come forward, thank you. And turning to Mr. McBride.
Thank you, Your Honor. Before this hearing, the defense moved to find Article 1, Section 12 of the Utah Constitution, Rule 7B, and Rule 1102 unconstitutional as it relates to the admissibility of hearsay and reliable hearsay at this hearing. The issue was extensively briefed and argued. The court denied the defense motion to exclude the use of reliable hearsay at the preliminary hearing. That ruling is at docket number 631. In addition, defense counsel filed a standing objection on July 3rd. That's docket 678. The standing objection reasserted the arguments made in defendant's previous motion. Defendant continues to make these same objections throughout the testimony of each witness. I believe both the state and the court and everyone present knows that the defense objects to the use of hearsay or reliable hearsay at this hearing. On the point of preserving the objection, that has been done. Defense counsel has filed their motion, they filed their standing objection. Throughout the proceeding, they have continued to make objections. At this point, further objection is unnecessary to preserve the record and causes undue and unnecessary delay. This is needless delay, and we'd ask the court to acknowledge and the record to reflect the standing objection. And we also ask the court to give an instruction that continuing objections on this ground are unnecessary. Of course, if it relates to some other ground or is some item that's particular to a particular statement, that objection may be appropriate. But at this point, we feel that the repeated objections that have been made and already been ruled upon are unnecessary and cause undue delay.
Thank you, Mr. McBride. To defense.
Good morning, Your Honor. Michael Burt for Mr. Robinson. We have no objection to that procedure as long as the court makes a ruling that the objections are preserved. We do think it would expedite matters if we didn't have to repeat the standing objection. There may be particular objections that are not covered by the standing objection we've made, and so we ask permission to be allowed to make those objections as needed.
Thank you, Mr. Burt. Thank you to both sides. I appreciate the presentation and your argument about this. The court takes no position in regards to whether the objection is made again and again or not. I leave that to the parties. I recognize the need to expedite this, and if both sides stipulate, I will adopt the request that the standing objection as it relates to 1102, Article 1, Section 12 of the Utah Constitution, and all relevant authorities that have been cited have been noted, and the standing objection by defense is in place. However, if defense feels the need to do that in order to protect the constitutional rights of Mr. Robinson, the court will not prevent that, nor stand in its way. This court is not is acting in the role of a magistrate and will allow the parties to move forward as necessary. But as noted, I will make that note that the standing objection has been noted for all of the yesterday's proceedings and will be in place throughout the rest of the preliminary hearing. Anything further or any need for the record given the court's statement?
Not from the state.
No, Your Honor.
All right, thank you. All right, the court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. And again, I will leave it to the parties to monitor the courtroom to ensure that if a witness has come in and they shouldn't be, that they are redirected. I invite Agent Hull to return to the stand to resume direct examination. And Agent Hull, you are still under oath. Mr. Sturgill?
Thank you, Judge.
And before we begin, is there a way to dim these lights just a tad like we did yesterday? Perfect. Thank you. All right. As of yesterday, there is also a water bottle to your left. And if you wouldn't mind just making sure that microphone is directly in front of you, we want to make sure that the record picks up your testimony today. Mr. Sturgill, your witness.
Thank you, Judge. Agent Hull, we're going to return to what has been marked State's Exhibit 12.1. There was reference to it yesterday. And I'd like to ask you again, have you reviewed that exhibit?
Yes.
And if you wouldn't mind, just briefly remind us what that exhibit consists of.
The exhibit is a compilation or a running of a summary of videos or UVU campus security footage.
Okay.
Your Honor, excuse me, we can't hear the witness.
And that's what I hear. So let's go ahead and
Yeah.
stop. I'm not hearing it, so I'm going to have you repeat. Let's test it. Go ahead.
Check.
All right, I believe that.
Thank you.
Mr. Sturgill, if you wouldn't mind restarting.
I can do that, Judge.
Thank you.
Maybe bring the mic from the base a little bit closer to you. If that'll help. All right, let's go ahead and go back to what's been marked as State's Exhibit 12.1. I'd asked you a moment ago if you'd reviewed that exhibit.
Yes, I have.
Okay. And would you just remind us what that exhibit consists of?
It's a compilation of videos that were part of the overall footage that was obtained from the Utah Valley University as part of the investigation.
And does that compilation video, from your point of view, capture Mr. Robinson arriving to and visiting the UVU campus?
It does, yes.
On September 10th through the 11th, 2025?
Correct.
Okay. And again, I asked you this question yesterday, but did you prepare that video compilation?
I did not.
Okay. Do you know who did?
The Utah County Attorney's Office.
Okay. Does that video, and I'm referring to 12.1 exhibit, State's Exhibit 12.1, does it include all of the footage collected by the SBI from UVU?
It does not, no.
Does that video, again, 12.1, include all of the footage you collected from UVU that captures who you believe is Mr. Robinson walking around campus?
Not all of the footage, no.
You reviewed this compilation with Mr. Olson, correct?
Correct.
Okay. And in its entirety?
Yes.
And he actually, and then you collected an 1102 statement from him?
I did, yes.
And I believe that has actually been admitted into evidence as State's Exhibit 12.3. Did Mr. Olson refer to that exhibit, 12.1, in his statement?
He did, yes.
Okay. 12.3. I'm going to put on your monitor State's Exhibit 12.3, and I'd ask that it be scroll down towards the very bottom. And I would ask that you read from the statement specifically what Mr. Olson said about State's Exhibit 12.1. And I want to narrow your focus, so I'm going to draw your attention about 3/4 down the page. There's a sentence that begins on the left margin, "I have reviewed." Do you see that?
I do, yes.
Okay, would you please read that sentence?
I have reviewed State's Exhibit 12.1, and the recordings are true and accurate, including timestamps, dates, and camera labels. The only changes are some zooms and red highlights, which were not part of the original recording.
Okay.
Would you
Have
like me to-
you, I'm sorry?
Sorry, I didn't know if you wanted me to continue. Or...
No, that's good enough. Have you had a chance? Well, you review the raw footage yourself. Is that correct?
Correct.
And does that comport with your viewpoint of that exhibit?
It does, yes.
Have you had a chance to review what's been marked as State's Exhibit 12.4?
Yes.
Okay, and when did you review that exhibit?
This morning,
And who did you review that exhibit with?
with Kimberly Durfler.
Okay. Was there any conversation about that exhibit?
No, I was just shown the video.
Okay. Nobody asked you questions or suggested anything to you?
They did not know.
Okay. Did you prepare that exhibit?
I did not.
Do you know who did?
The Utah County Attorney's Office.
All right. And I'm referring specifically to what's been marked State's Exhibit 12.4. What is depicted in that video?
That video is, again, a compilation of videos from the overall footage that was obtained from Utah Valley University for September 11th and September 12th.
And how does it compare to what's been marked as State's Exhibit 12.1?
It appears to be the same footage. However, on this particular version, there were no circles or blurs that had been made to the video.
How about zooming in and zooming out?
No, there was no zooming or zooming out.
Does it appear to be identical to the raw footage that you've seen that portrays this particular part of the UVU surveillance video?
It does, yes.
Judge, the state would move to admit what's been marked State's Exhibit 12.4.
And
Your Honor, we just object to the publication of this for all the reasons we argued yesterday. We think this video is going to play a big role in the trial, and to allow the public to see it now would seriously impact our ability to get a fair trial, and we're asking the court not to publish it.
thank you. And Mr. Sturgill, and to all counsel, as it will apply to all counsel, when you are moving a piece of evidence, it's the three parts, whether admissibility into the record,
Right.
to be published in the courtroom, and captured by the media. So, Mr. Sturgill, as it's your request, what are you requesting?
Judge, first of all, clearly I'd move to admit the exhibit. I'd ask, and Judge, the presumption is that this is a public record and should be published. And so the state's position is that it should be published here in the courtroom, and it should be published in such a way that the media can capture it on video.
All right.
Your Honor, can I be heard on that very briefly?
You may, if you would approach the lectern, please, and state your name.
I'm David Ryman. I represent the news media. I didn't make an appearance because the news media technically aren't parties, but as you know, they do have the right to be heard on issues like this, and I've tried to keep that to a minimum. But since this is the first one coming up today, I thought it might be helpful to just address it again. There is a presumption not just that it be published in the courtroom, as we talked about yesterday, because the participants or the spectators in the courtroom have a right to know what the court is viewing so that they can understand how you're making your decision. This seems like a very important piece of evidence. It doesn't seem like there is a basis to keep the people who are in the courtroom today from understanding why it's being introduced. It is not like the videos yesterday, my understanding at least is, in fact, you can correct me if I'm wrong, but we didn't object to the videos that weren't published yesterday that were graphic. We didn't object to the non-publication of the autopsy report. The argument here that Ms. Nestor just made is this seems really relevant, and that is precisely why it needs to be public. With the last thing I'll address is just EMC. There is a presumption, it's a rule presumption, not a constitutional one, that EMC is allowed. And I think that for all of the reasons that we've briefed this for Your Honor several different ways, there needs to be a really good reason why. You know, if it's being published in a public proceeding in the courtroom, it should not also be, it should not also be allowed to be published to the media. So,
Thank you.
thank you.
Mr. Sturgill, did you wish to respond or perhaps give a little bit more detail on what this video purports to show?
Okay. Well, do you want me to proffer that, Judge, or have the witness?
I'll defer to you.
Okay. Well, first of all, if I could take one step back. Let me ask you, I may have misheard, but let's just be clear about this video, the compilation video. It includes video surveillance from UVU campus from what dates?
September 10th, 2025 into the morning of the 11th, 2025.
And if you wouldn't mind just describe in a bit more detail what this compilation includes.
The compilation shows the movements of the individual believed to be Mr. Robinson on Utah Valley University campus, arriving and leaving in a vehicle, arriving and leaving on foot, and then returning and leaving, and then attempting to gain access again in a vehicle. And his movements throughout the day are included in the videos also.
Is there any footage of the alleged shooting?
There is not, Judge.
Okay, I just want to clarify that. Ms. Nestor, given that additional information and anything further from defense?
Your Honor, Mr. Burt's he's the one who's been litigating all of the First Amendment issues, if he could address Mr. Ryman's argument.
Yes, Mr. Burt, if you wouldn't mind coming forward.
Judge, I wanted to clarify one argument that was made by counsel for the media yesterday, and that was the rules, the Rule 4-202.02 does not apply to the situation we're in right now, and that is wrong. The rule says that this rule applies to the judicial branch, and 4-202.02J says the judge may regulate or deny access to exhibits to ensure a fair trial. So I think that rule does apply to our situation, and the Supreme Court in the Algier, A-L-L-G-I-E-R case, 258 Pacific 3rd, 589, applied the rule in the context of an evidentiary exhibit. And I know the court has not mentioned, since counsel made that argument, this particular rule, but I think it does apply here. And also applicable is the Supreme Court's decision in the Kearns case, which we talked about when we argued the motion for denying access to the cameras. And that case, Kearns versus Tribune Corporation, 685 Pacific 2nd, 515, says that the standard the court ought to apply in determining whether an exhibit at a preliminary hearing should be sealed is one of a, quote, realistic likelihood of prejudice. And we rely on the evidentiary showing we've made in connection with our motion to exclude cameras, that there is a realistic likelihood of prejudice in this way. The court knows and has access to the media coverage up to the time when we litigated the motion concerning closing this hearing to the cameras. And the court knows that one feature of the media coverage has been a very pro-prosecution bias of every story that has been published on this account. The court also knows from that coverage that information is being widely disseminated, and you have found in connection with the shackling issue that the publicity in this case is likely to reach jurors who will be part of our jury pool. And we've also submitted to the court a public opinion survey which shows that the prejudicial publicity that the media has already generated in this case has affected the jury pool. And so those are all factors the court can point to and rely on and conclude that publication of this particular exhibit should not be allowed because there is a realistic likelihood of prejudice to Mr. Robinson's right to a fair trial. So under that standard and under the rule, the court ought to deny publication.
Thank you, Mr. Burt.
Thank you.
Any final argument from the parties before the court issues its ruling?
Your Honor, can I be heard on that briefly?
Yes, you may.
Thank you, Your Honor. David Ryman. I just wanted to clarify. I don't know that Mr. Burt and I necessarily disagree about what he said about the rule. What we were talking about yesterday was something different. That is the portion of the rule that classifies records that are in the court file. You know, it's not the same as what happens in a public hearing. And Mr. Burt referenced the portion of the rule that essentially just tracks the constitutional standard, which of course, you know, controls here as to whether in this public proceeding it can be closed in any way, and non-publication of exhibits as a form of closure. So I don't necessarily disagree. I would just underscore a lot of what Mr. Burt just said has been briefed ad nauseum at this point. Their position that publicity is incompatible with a fair trial. The Allgaier case he mentioned, you know, I know that case. I litigated that case. It involved a confession that the court found public because you have so many other tools to seat a fair and impartial jury. And we have cited that case repeatedly, and so has Your Honor, I think, recognized it in your ruling, saying pretrial publicity can coexist with the defendant's right to a fair trial. So the last thing I'll say is just that the constitutional standard that I think we're all agreeing applies here is weighty and difficult to overcome. And it is never satisfied, as we've explained, by just generalized assertions that there's a lot of publicity out there. It's got to be something really specific, and they just haven't made that showing. And I certainly don't think that a video that apparently just shows the defendant walking around the UVU campus qualifies.
Thank you. Anything further?
Judge, from the state, no, but I think I'd like to be crystal clear. You asked if there's any portion of this video that captures, and I believe you asked of the actual shooting. There's no video of that. There is video, however, and you've heard testimony related to this, where the shooter goes to the top of the low-C building, goes out to the edge of the building, low crawls, and then leaves after what we assume is the shot being fired. That's as close as it gets. I don't know if that makes a difference, Judge. I just wanted to make the record clear, and I want to be crystal clear with Your Honor.
Thank you. I appreciate that clarification, as it is guiding for this court and making its ruling. I turn to Utah. Well, let me pull this up. So Rule 4-202.02. I go down to, well, first it says statement of the rule. 1, presumption of public court records. Court records are public unless otherwise classified by this rule. 2, public court records. Public court records include but are not limited to, and I'm going to go down to 2J, exhibits. But the judge may regulate or deny access to ensure the integrity of the exhibit, a fair trial, or interests favoring closure. And the court recognizes the importance of the constitutional rights of Mr. Robinson being upheld and protected. At the same time, the court also recognizes the importance of transparency and a proper balance to ensure that the constitutional rights of all parties are upheld. As it relates to this exhibit, I believe it's 12.4.
12.4, yes.
Based off the representation of what is in that, the court differentiates this exhibit from the exhibits from yesterday, namely Exhibit 7, Exhibit 8, and Exhibit 9, as those are different in nature. And those go to issues relating to Utah Constitution, Article 1, Section 28, as it relates to the Declaration of the Rights of Crime Victims. And the court also recognizes Utah Rule of Evidence 1102, as that is the foundation that's being laid for the admission of this exhibit. Having taken in consideration all factors, the court rules that Exhibit 12.4 is admitted into evidence and shall be played in the courtroom and may be broadcast by the media. And we can proceed.
Thank you, Judge. Agent Hall, before we actually watch State's Exhibit 12.4, I have just a few questions. Yesterday, you testified at the very beginning of your investigation that you focused on the video that captured the shooter on the top of the Low-C building. Is that correct?
Yes.
I believe you also testified that you began by working your way, and this is what I remember you saying, so correct me if I'm wrong, but you in essence testified that you began with that video and you started working your way backward and forward with the UVU surveillance video in an effort to trace the shooter's steps on campus. Is that right?
Correct.
Okay. Would you mind explaining just in a little bit more detail what you meant by that, tracking forward and backward on that video?
Yeah, we had a known when the shooting occurred, and as the officer testified, there was a video of an individual on the roof at the time of the shooting. And so the philosophy that we applied was to take what we knew and then work that forward through the timeline and backwards through the timeline to try and establish where the individual had gone from the rooftop or how the individual had come to be on the rooftop.
And did that, for lack of a better term, did that bear fruit?
It did,
you
yes.
Actually see from, at least in part, where he came from and where that shooter went?
Yes, more so where he came from. It was very limited after the fact.
Okay. You testified yesterday that in reference, I believe, to what's marked State's Exhibit 21, that you believe Mr. Robinson visited campus at least 4 times on the 10th and the 11th.
Correct.
And I think you reaffirmed that today. Did you do the same attempt, that is, to track Mr. Robinson through UVU surveillance video during each of those 4 visits?
Yes.
Or those other 3 visits, I guess?
Yes, on each occasion we attempted to follow the movements of the individual throughout campus.
And did you in fact see Mr. Robinson on campus in surveillance video that is not included in State's Exhibit 12.4?
Yes, there is additional footage of him on campus, yes.
Okay. I'm going to have displayed on your monitor what you're going to see is a paused or a still image. And I'm going to ask if you recognize what you see that now, Agent Hall?
I do, yes.
Okay. Do you recognize what's displayed on your monitor?
Yes, it's footage from the university that was provided to us, particularly of the parking structure.
Okay. Does it appear to be State's Exhibit 12.4?
It does, yes.
So I'm going to go ahead and I'm going to have this video run And then if you don't mind, as it's running, I'm probably going to be asking you some questions. And so this video has no audio, is that right?
No, there's no audio on the cameras.
Okay. Let's go ahead and start the video.
Your Honor, it's just not up on the screen yet. Maybe
Oh.
Let's go ahead and put it on all screens. No, I appreciate it. Is so it is admitted and may be published to the screens. And just want to make sure it's on your screen, Agent. All right. All right. Mr. Sturgill, you may proceed.
Appreciate that, Judge. Thank you. Go ahead. Okay, what are we seeing here, Agent Hall?
That's the vehicle that is believed to belong to Mr. Robinson arriving in the parking garage on campus.
At what time in the morning? What time of the day?
It's approximately 8:30 in the morning on September 10th, 2025.
And what leads you to believe that this particular vehicle belongs to Mr. Robinson?
Information that was provided regards to driver's license and Department of Motor Vehicle records. The vehicle fits the description of a vehicle owned by Mr. Robinson.
Is there anything unique about that vehicle that stands out to you?
The shape of the vehicle is very distinct, but predominantly the wheels were very distinctive on this version of the vehicle.
Now what do we see?
The driver of the vehicle exits the vehicle and then walks on foot to exit the parking garage. It's the individual in the red T-shirt and the shorts and the shoes.
And do you believe you recognize who that person is?
Yes.
Who is that?
I believe that's Tyler Robinson.
All right, and where does he go from there?
He heads out of the parking garage on foot into the campus and actually goes to the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
By quad area?
Sorry, the amphitheater is what I've previously referred it to.
All right. So he goes up on campus, visits the amphitheater area, the courtyard or quad.
Correct.
And then what do we see here now?
He returns on foot back to the same vehicle.
And what time is he returning back to the vehicle?
It's about 9:25 a.m.
And where is this parking structure located on campus?
It's just off of Campus Drive. It's a short walk from the amphitheater.
What do we see now?
That's the vehicle exiting with Mr. Robinson driving the vehicle.
Now what do we see?
This is Mr. Robinson returning to the campus on foot from the neighborhood to the northeast. You can see he's wearing the same clothing as in the previous video. And he's carrying a blue backpack.
Describe the clothing.
It's a maroon-colored T-shirt with gray or olive-colored shorts and then Converse shoes.
And what time did he return to campus?
Just after 10 a.m.
And does he leave the parking structure eventually?
He does, yes.
Okay. And during this visit, do you know where he goes after he leaves the parking structure?
Yes, we were able to track his movements on campus. He went to Chick-fil-A in the Sorensen building and purchased some food, sat and ate the food. Then, I'm sorry,
Where did he purchase the food from?
Chick-fil-A in the Sorensen Center.
And where is that in relation to the amphitheater or the courtyard?
It's kind of on the northeast side of the amphitheater. It would be on the upper back edge of the amphitheater, furthest away from where the tent was that Mr. Kirk was in.
And from there, where does he go?
From there, he moves across campus, out across Campus Drive into a wooded area on what would be kind of the northeast side of Campus Drive. Then returns back onto campus We noticed at this point that he's no longer carrying the backpack that he was originally wearing. He moves through the Gunther building and the computer science building.
And then goes
I'm sorry?
And then goes where?
Then goes across to the railing that gives access to the roof of the Losi building.
And from there?
From there, he comes back down the stairs and walks off campus from that point.
And about what time was that he left campus that second time? Do you know?
I believe it was approximately 11 a.m. or just after, if I recall. I could verify from my notes if you need an exact time.
Yeah, if you don't mind. That'll help you remember, refer to it. Don't read it out loud. Just let me know when you've had a chance to look at that, would you? Were you able to refresh your memory as far as the time?
I was, yes.
Okay, and what time was it?
It was just prior to 11 a.m. when he walked off campus.
Okay. And before we go any further, the parking structure that he left initially, where is that parking structure in relation to the LDS Institute building?
I'm sorry, in relation to?
The LDS Institute building on campus?
I think it would be just to the north of the LDS Institute building, if I recall.
Do you recall whether it was adjacent to the LDS Institute?
Yes, it is.
Okay. All right. What do we see displayed here now? Go ahead.
This is a video of Mr. Robinson returning back to campus the same way that he did previously on foot.
And this takes just a moment. And why, well, let me ask you this. You believe this is Mr. Robinson returning to campus?
I do, yes.
Okay. And why do you believe it's Mr. Robinson?
The shoes are the same, and the images that we have are from my viewing and seeing Mr. Robinson on the video, it's the same person.
He's noticeably wearing different clothing.
He is wearing different clothing, and he also is walking with a gait or a limp in this video.
With a gait or what?
A limp.
Okay. Now what do we see?
This is Mr. Robinson coming up the stairs of the parking structure. Again, he seems to be having issues walking.
And again, were you able to track Mr. Robinson when he leaves this parking structure?
Yes, we were able to.
Okay. So when he leaves the parking structure, where does he go?
He comes up around Campus Drive. As you can see on the video here, there is a cut through there north of the Losi building, and that's Mr. Robinson coming up the sidewalk. He has the noticeable gait or limp in his walk. And then he moves south across the front of the Losi building.
On the sidewalk?
Yes, correct.
Okay.
He would be the rear of the two individuals in this particular video.
All right. So right now, if you were to break this picture into quadrants, where would he be?
He'd be in the top left quadrant, walking to the left of the image.
Now what do we see?
This is an image looking across the parking lot to the Losi building, and Mr. Robinson is appearing on the exterior staircase, which gives access to the Losi building roof and the area where the railing was.
And again, let's break that image into quadrants. Where would he be located if you broke it into quadrants?
It's in the top right, and the individual can be seen moving under the notations that are on the video.
Okay. And what time is this?
It's just afternoon, about 12:15.
On what day?
On September 10th, 2025.
Okay. What just happened, or what did we just see happen?
The individual actually kind of rolls over the railing onto the roof of the Losi building.
All right. Go ahead, sir.
And again, in the top left corner, the individual is now seen running across the rooftop of the Losi building to what would be the southwest corner of the building, crouching down and then crawling to the corner of the building.
And this is at what time?
Around 12:23. I think the timestamp on the video is 12:22.
On the 10th.
On September 10th, yes,
So we're
2025.
clear, this is the roof of the Losi building.
Correct.
Can you still see that individual?
Yes, you can, laying prone.
You believe this to be Mr. Robinson?
I'm sorry?
You believe this to be Mr. Robinson?
I do, yes.
And how long is he out there on the edge of the building?
Just until the reported shot was fired at 12:23 and 28. The individual then stands up and then moves across the building to the north.
Is that what we're seeing happening right now?
It is, yes. They move behind the atrium area on the rooftop to the northeast corner where the white triangle is.
Do you see Mr. Robinson now?
I do, yes. He's just arriving at the corner of the building, the almost top center of the image.
What are we seeing now?
And Mr. Robinson lowering and jumping off of the roof of the Losi building onto the grass area, and then moving away towards Campus Drive. And he appears to be carrying some kind of an object in his hand at this time.
So he's approaching,
Campus Drive.
and again, broken into quadrants. Where is he currently?
Be in the top right quadrant.
And the time?
It's 12:24 and 42 on the timestamp.
What do we see now?
He then crosses Campus Drive and drops down into the wooded area on the far side of Campus Drive.
And that is located in what part of the video? What quadrant?
It would have been just off center on the top left side.
What do we see now?
This is the intersection of Campus Drive and 800 South. There's a vehicle attempting to turn right onto Campus Drive. That's the vehicle that's driven by Mr. Robinson.
Okay. And on the screen, where is that vehicle that you're referring to located? If you broke it into quadrants.
It's on the left side, on the upper side, the upper quadrant.
Now what do we see?
And that vehicle's now pulling away and heading east on 800 South.
And why do you believe that that vehicle is Mr. Robinson's vehicle?
When that vehicle was stopped, it actually made contact with an officer who was doing security detail.
Okay, and do you know who that officer is?
Officer Goforth,
Okay, and do you know which department he works for?
Spanish Fork Police.
And did you have a conversation with Mr. Goforth regarding this interaction at that intersection?
I did, yes.
Okay, and what time was that interaction? I'm sorry, did I ask you that?
It was approximately 12:30 a.m.
Okay. On the 11th?
on September 11th, 2025.
So you talked to Officer Goforth about that contact on the corner on that, or during the early morning hours of the 11th.
Correct.
And what did Officer Goforth tell you about that interaction?
It was an interaction that, I guess cop intuition, but there was something about the interaction that made him make a note of the license plate of the vehicle. And then subsequently, when information was available that vehicle or a vehicle matching the description of that was involved in the incident, he ran the information that he had obtained from the stop and was able to identify that it was registered to Mr. Robinson, and he had in fact had contact with Mr. Robinson on the morning of September 11th, 2025.
The information that he ran, do you know what information when you say that, he ran information,
Yes, he ran a partial plate.
okay, a license plate?
Correct.
And based on that partial license plate, he was able to identify the owner of that vehicle?
Yes.
And did he tell you who the owner of that vehicle was?
He did, yes.
Okay, and who did he tell you that it belonged to?
Said there were two registered owners of the vehicle, Tyler Robinson and an Amber Robinson.
Did he say anything about the person that he actually interacted with?
Yes, it was a male that he believed to be Tyler Robinson.
Okay. Let's return again to what's been marked State's Exhibit 12.1. Again, you've reviewed that video.
Yes.
And the difference between 12.1, or what's been marked as State's Exhibit 12.1 and 12.4 are, if I understand you correctly, are these enhancements that we've been talking about.
Yes.
And specifically, be specific about the enhancements, and let's go one at a time.
Okay.
I think there's a reference to either red circles or red highlights. I think
Correct.
That's how Mr. Olson described it, red highlights.
Yes.
Do you know what he's, or what is he referencing by the red highlights, or what do you believe he's referencing?
I believe he's referring to red ovals or circles that were placed over the image to identify specific individuals of note.
And these red circles, are they permanent red circles? Are they temporary?
I'm
Different.
I would assume they are temporary. I'm not very technological, but I believe they would be overlaid over the image.
And that is a bad question. What I mean by that is do they appear and disappear quickly, or do they linger or last for a period of time?
They're there for a notable period, but I believe they come off the video. But
All right. And other than, well, and you said that the circles, what do the circles do?
they identify an area or a person of interest within the video.
And other than do that, do the circles or the highlights, do they do anything with regards to the video itself as far as its accuracy?
Not to my knowledge, no.
Okay. I think the next enhancement that has been mentioned that we've talked about is there's some blurring.
Yes.
Do you know what that? Tell us what that is. What blurring do you see in what's been marked as State's Exhibit 12.1 that you now don't see in 12.4?
If I recall, there were some individuals in the parking garage footage, and their faces were blurred. Excuse me.
Is anything other than faces being blurred?
Not that I recall, no.
Okay. And how often do you see the blurring throughout the video?
I believe it's just in the original sequence in the parking garage.
The other than the blurring, does the blurring, other than obviously blur out part of the image, does it change or impact the accuracy in your mind of that part of the compilation video?
Not to my knowledge, no.
And then the last thing is, I believe, is there's some zooming in and zooming out that's in 12.1 that has been removed
Yes.
from 12.4. What can you tell us about the zooming in and the zooming out?
Predominantly, it's in the area that was referred to as viewing the Losi building rooftop.
Mm-hmm.
I believe it focuses on the area where Mr. Robinson comes up the stairs and onto the rooftop. Those portions of that particular footage were zoomed in for clarity.
Okay. Other than zooming in and zooming out, does at least that enhancement to the video, does it change the content of the video?
No.
The accuracy of the video in your mind?
No.
Okay. Are the enhancements in State's Exhibit, well, it's been marked as State's Exhibit 12.1, are they helpful in any way, or what do they add or take away from that video?
I think for people who are not familiar with the area and what's trying to be shown, they allow an opportunity for people to look at an individual who we believe to be Tyler Robinson, and also specific movements with more clarity than the original focal point gives.
So let's talk about the zooming in and the zooming out. It sounds like it's specific to the low-C rooftop, if I understand you correctly.
Yes.
Okay. And I think we've all watched that exhibit.
Correct.
Before. And although you can see Mr. Robinson and his movements, is it fair to say that it's difficult to really see what's going on?
That would be fair, yes.
Okay. And the version that's in 12.1, does it facilitate at least that part of the video, seeing Mr. Robinson and tracking, I guess, his steps?
I believe so, yes.
Okay. Judge, at this point, I think in combination with yesterday, the foundation that was laid yesterday, including the written statement from Mr. Olson, which has been admitted into evidence and is, well, it's already been admitted into evidence. We believe there's enough foundation that at this point we'd also ask the court to admit what's been marked State's Exhibit 12.1. We think it would be well, beneficial for Your Honor to view it.
Ms. Nestor.
Thank you, Your Honor. We renew our authenticity objection, and we also object to for admission purposes. And then we also object to the publication for the same reasons, the fair trial issues that we raised with the unaltered version that was just submitted.
And Judge, sorry, I neglected to mention the other two. Again, Judge, we believe that the presumption is that this is a public record, that it should be not only admitted, but it should be published here in the courtroom, and it should be published in such a way that the media can have access to it.
All right. I do have a question, and just directing your attention to the Utah Rule of Evidence 403, to the last phrase, the last 4 words in that. Do you wish to address that?
Judge, I'm going to have to look at 403 specifically for those last 4 words.
I can read that. Or
Okay,
needlessly presenting cumulative evidence. So the court may, let me just read the whole rule for completeness. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issue, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. I'm not looking at anything else other than that last portion. I recognize there is no jury. I am the magistrate. I am the fact finder, but just addressing that last point of Rule 403.
Right. Judge, well, I don't believe that the evidence is cumulative. I think that each of the 2 videos, although they portray basically the same footage, there's characteristics of the one that has been enhanced that I think makes it easier for Your Honor to truly see what's going on, and for the public to see what's going on. I mean, we've displayed 12.4 on the video, and unless you have very, very, very good vision or you've zoomed in on that monitor, you really can't see what Agent Hull has just described. The character of 12.1 is it enhances that at least important parts of that exhibit, and it just makes it easier to see, not only by Your Honor, but also by the public. And specifically as it relates to the zooming in and the zooming out.
Okay. Anything further from the parties as it relates to 12.1? All right. Well, I will admit 12.1 into evidence, but as it relates to playing it in the courtroom or on the television, well, for the media, I find that it is, well, as the fact finder, I will look at the evidence and weigh it as a magistrate is required to do, but I do not find it is I don't find it's necessary to replay this video, given the representation that's the exact same video, the difference being enhancements made If it was different in any way, or if it added to or subtracted from, that would be one factor. But because it's simply the same video, simply zooming in with circles or notations, the court does not find that the interest of justice requires it being played again. But it is received into evidence and will be reviewed by myself in determining a probable cause determination.
And I appreciate that, Judge. And just so we're clear, State's Exhibit 12.1 has been admitted.
It is received into evidence, yes.
And your intent is to review it in its entirety, but not here in the courtroom.
Yes.
Can I make one suggestion, Judge, or maybe one request? I believe the most important part of the most helpful part of this video is the zooming in and the zooming out. And that is a portion that, if you want, we could isolate that and only play that portion of the video if you'd be willing to publish that portion of the video. And that's really the thrust of why we are trying to introduce that exhibit, because we believe that it's helpful to see it up close. And unfortunately, because of the way it's formatted and the way it's been recorded, there's no way any of us can zoom in and zoom out on this video to get a better look at what's going on. And that's the reason why we did what we did, but we had to memorialize it and save it, and then present it in that way rather than just present it in its raw form and then have the ability to zoom in and out, if that helps Your Honor understand why we're doing what we're doing.
All right, Ms. Nestor, to the second request of not playing the whole video in its entirety, but simply the portion with the zooming in, how long is that, Mr. Sturgill?
I think it's a couple of minutes.
All right, Ms. Nestor.
We object to the prejudice of that, Your Honor, and ask the court to stand by your previous ruling on that.
All right, thank you. I appreciate both parties. What I will do is review this video in court, and it will be displayed to the monitor's counsel table and to the court's monitor on any portion that you wish to play for me to look at, so all parties can see clearly that the court is reviewing it in court. But I do not find that it is necessary for its publication, because this is the exact same video. I recognize it's zooming, but in balancing constitutional rights, there is nothing on this video from what's been represented that the public hasn't already seen. It's simply zooming in, and I don't find that that is necessary, or and so in balancing the constitutional rights of all parties, I'll view it on the monitor. Counsel's free to view it with me as I'm looking at it, but it will not be broadcast in the courtroom or by the video camera.
Right, I appreciate that, Judge. I respect that. I think there's a natural break where we can start. And what I'm going to ask is just we simply play the You will have this entire exhibit in evidence, though.
Thank you.
Is that right?
Yes, I will. All right, whenever you're ready. Counsel, as it relates to your monitors, just as a caution, if you don't want it to be wished to be picked up, and I'm not saying it will, I know there are camera operators being diligent in ensuring they're complying by the rules, but in abundance of caution, this is just your moment to take care of your screens if you feel the need to do so.
So if I could just have one moment. Hold on, Kimberly. I'm not sure where the power button is on this. There we go.
All right, counsel for defense, are we prepared? And for the state?
Yes, Judge.
All right. Thank you. Having heard from both counsel, I'll go ahead and review it on my screens. It is not being displayed in the monitor in the courtroom. And you may present 12.1, the portion you wish for me to view. And just for the benefit of the record, do you want to put on the record the timestamp of what you're playing, at what point you're starting and stopping, as we go, or when we finish is fine. I just want the record to be complete.
Just the difficulty in doing that is because we've zoomed in, it's removed the timestamp on it. And so-
Well, you can just give me the
count
The
on the
count
video?
on the bottom. There's a timer at the bottom of the total length of the video, so that's fine. I'm just trying to create a record of what exactly I'm looking at.
Whenever we pause on the court system,
Oh, I see. No, it's limitations of technology sometimes. Thank you for letting me know.
So the count on the video is just before 6-minute mark, Judge.
All right.
And just so the record's clear, this is State's Exhibit 12.1.
Thank you. I have it on my screen. It's so it looks like it's been paused at 6 minutes and 9 seconds.
Agent Hall, can you see it?
Yes.
Okay, well, let's just, I'm good with playing it. And we'll play it. Go ahead, Kimberly.
It's playing.
All right, and it's been paused, it looks like, at 6 minutes and 23 seconds.
I'm sorry. Judge, at 8:23, we stopped the video.
Oh, 8:23, okay.
8:23. That's the count on the video itself.
Thank you.
Okay.
All right. Thank you, Mr. Sturgill.
Agent Hull, you were able to watch that zoomed-in version, is that
Yes, sir.
right? Okay, and was there anything that stood out watching that zoomed version?
For me, on the zoomed version, it's apparent that Mr. Robinson, the individual jumping off the roof, is carrying an item.
Okay. And you can see clear the clothing that he's wearing?
Check to leading.
Strike that.
Mr. Sturgill, do you want to respond to the objection?
Judge, it is leading.
I'll go ahead and sustain the objection and that you may move forward.
Is it easier to see? Well, strike that, Judge. I'll let the video speak for itself. Judge, I have nothing further with Agent Hall.
All right. Ms. Nestor.
One moment, Your Honor, if
Of
I may
course.
have the court's indulgence. Thank you. Do you want to take your...
And I was just going to suggest that. It seems like right now is a good time to take our morning break. Is 10:15. Let's come back at 10:30, and we'll resume with cross-examination of Agent Hull. Court is now in recess.
Officers were dispatched to a residence where a 39-year-old woman claimed she had been assaulted.
Hi, ma'am.
He had a head come in the house to try to clean and stuff. The lady drunk and high off and stuff. I'm on the phone talking to my sister on the phone because she called me wishing me happy birthday. She's not on the phone now.
Oh, okay.
That was the police. So the lady comes in the room going like this with the freaking blade. She's walking out the house, still trying to attack me with a knife. So I called the police trying to follow her. But the girlfriend, his daughter, told her to get into her boyfriend's vehicle and drive. That go to the vehicle right there.
Where?
Is that the police or?
That's us.
Huh?
That's us.
That's her?
That's us.
Oh, okay.
Ma'am, do you know who that was?
Huh?
Do you know who this person was?
What?
Do you know who this was?
Do I know her address?
No, do you know who it was? Do you know her name?
I don't know her name. She's a she come by from him.
How did she get in your house?
Because he let her in.
He let her in the
He
house?
let her in and then drove off.
Who is he to you?
Huh?
Who is he to you?
He's my boyfriend.
And what is your name?
My name is Nadia.
And you've seen her before?
Yes, I've seen her plenty of times coming to buy off him. And the lady pushed the bedroom door open and she was like, I'll kill you. I'll kill you. And I was like, you're going to jail. I'm calling the police.
She did not do that. That's
so...
What night she had?
Whatever. You wasn't here, sir. You let her in the house.
All right, Regina.
I live here.
Okay. Don't worry about it. Let's just deal with him.
I thought so.
Norm, let's just talk. Yeah.
Whatever. Y'all can be against me all y'all want to. I was trying to be attacked. I was about to be attacked by a head with a freaking box cutter in her freaking hand.
Ain't nobody saying that to you, my
You wasn't here.
Okay. Okay, listen. They're not handling this. You're talking to us, all right? You understand? They weren't here when it happened either. And if he wasn't here, we'll get to that. Do you understand you're here to talk to us? Because if you're not going to talk to us, we'll leave. Okay? Talk to us, not him. How far was she from you?
She was like...
As far as I am from
you?
you?
She was like right here.
Okay.
And I'm right here by the window. But she's going like this.
Okay, what prevented her from hitting you?
Huh?
What prevented her from hitting you?
When I got off the phone, calling the police.
So she was threatening you. She didn't actually try to hit you.
Swinging it at me.
Okay, but she never actually tried to hit you?
No, she never even touched me.
She could have hit you if she wanted to, right?
What?
She could have hit you with the knife.
Yes,
if she wanted to, right? She could have hit you, but she didn't.
No, I didn't video it.
Did you think she was actually going to cut you?
Of course, the lady's drunk and.
Okay, you were in fear?
Yes.
Okay, you didn't get any videos?
No, I don't.
There's no cameras.
I just have an old
That's
video
okay.
of her boyfriend beating up.
No, that's not. That has nothing to do with this. We're talking about what happened today. There's no video cameras inside the house.
No.
No. Okay. All right. Well, just give us a minute, okay?
If it didn't happen, why would they leave?
No, yeah, if you could just stand over there. Just stand over there in the shade for me for a couple minutes, okay?
While Medea gave a solid story, her boyfriend Anthony thought otherwise. What he revealed would turn this open and shut case into a complicated one.
She's very blatant, argumentative, very. She's been here since when she moved in here. She moved in just for temporary spot because her sister still lives here. She kicked out. She came over here. I said, well, I'll give you a place for temporary. But you cannot send your mail here because I know how people play. My people are mad at me because I filed an injunction. And then when I did file an injunction.
Against her?
Yeah, the cops didn't come.
How long ago was that?
Right here.
And
It was
it
an
wasn't
interview
served?
thing.
And it wasn't served?
It was never served because she wasn't never here.
Do you know the lady that came in? That's how I got interrupted. Lady?
No, that's my god sister Tiffany.
The one that was here?
She said she did something. Man, you see her, man, she don't have voice, that she don't have no heartbone in her body.
Is that who she's referring to?
Yeah, Tiffany can't even body, she barely can watch it. She's not a kid.
Okay.
You see her, look, you see her, she's like,
Okay,
come on, really? And all that time, somebody got a name, that's why I hid them from her. That's why she can't tell you the name right now because they all hid.
Oh, so Tiffany didn't leave with your daughter?
No, she didn't leave with her daughter.
Okay.
Tiffany.
And how long has she lived with you?
Who, her?
Yes.
2 months and a half. On and on because she been big ragged. We were getting rid of her and she coming back on. She's talking about the damn site was about a month. The only reason why I felt bad about her because when she left normal. Then when she came back, she
Okay.
She was up and she didn't have nobody to help her. So my heart was I have a big heart. So my own heart was to open the door for her to let her back in to try to help her get back stable because I did call to get some help for her. And that wasn't the type of help I was looking for her to get.
How did you guys meet?
We had smoke together, and that was it. She was a friend I talked to, whatever, Now she come back over here, she moving in shit. She get a address, mail here for cash out. Then that's how she stays. She's smart. She's smart to do some dumb shit like that, though. But I told her not to do this. I found out this ain't the first time she did this. She did this several times, other different times and occasions with other people.
Just ignore it. Anthony, don't just...
She's not.
You're good.
She obviously doesn't understand what I'm telling her. So
Ma'am?
which isn't voting.
Ma'am?
It ain't registered. It ain't registered.
Ma'am, stand over there.
I don't care. Do you understand me? I don't care. Did I already tell you to sit down and mind your business? Was there something you did not? No, stop talking. I don't care. Stop talking. Is there something you did not understand about the fact I said, let me come and talk to you when we're ready? I don't care. Stop talking.
Now you see, it won't be stopped. It's constantly continuing. That same thing she's doing that is continuing.
Heart's too big. Stop it.
Yeah, I know.
Okay? He might
You trying to attack me and I did.
No, listen. He might have thought everything that was coming out of your mouth was a lie. We're going to hear your side. We're going to hear his side. We'll make our decision. Do you understand me? Everything is being recorded. Do you
She's
understand?
talking to another guy in my bedroom. In my bed.
Have you guys had any relationship at all?
No, I hit her a couple times, you know.
Okay.
But for like that, I ain't lying.
So you weren't here for anybody, any knives, any swinging of anything. You don't know anything about that, right?
Yeah, I was here. There wasn't no
But there was
knife.
not. All right, cool.
The reason for that because she know that's her MO. And that's what if she was a grab knife or something, she know we're gonna tell her.
Okay.
And her usually time it'd be her the one that grabbing knives is going on.
Officers ran a background check and found that the injunction Anthony had filed against Medea had been dropped because he failed to attend the Zoom hearing. However, they also discovered that Medea was under a strict no-contact order with Anthony, and that was enough for officers to take her into custody. But Medea decided she wasn't having any of it, especially on her birthday.
Ma'am, can you stand up for me, please? Can you stand up for me, please? Hands behind your back.
I'm gonna make my own fine.
Ma'am, put your hands behind your back. Listen to me. Do not resist. Do your hands behind your back. Listen to me. Do you want me to spray? Put your no, stop kicking. No, we're not doing this. We're not doing this. If you do not bring your hands out, I'm gonna spray you. Just bring your hands out. Bring your hands out. Where's she being arrested? Don't let her bite. Back off, and I will explain everything later. Back up. I'm backed up, but I need to see what's going on.
I called the police.
You got my sister's face on the ground up. Stop resisting us. Stop resisting us. Get her hand up. Get her hand. Thank you. Stand up. Go ahead and get in for me. I'll put the AC on.
This wrong.
Ma'am, get in.
I didn't do that, sir.
Ma'am, get in. Get in the car. I'll turn the AC on.
I need some water.
All right. No. Listen, take a seat. Get in. Just sit down. You're going to make this easier on everybody.
I didn't do anything. I didn't do nothing.
We're going to do this again. Get in. You want us to tell your sister what you're being arrested for? You want me to tell her?
I called her. I called my sister. I was on the phone with my sister when that lady tried to attack me.
I'm asking her. She's not wanting me to tell you why she's being arrested, so. You'll have to look up her booking stuff, okay?
What did she do?
Just get her to the station. We'll meet you there.
Wow. God don't like ugly. It's my birthday, and I gotta go through this. Only God knows I'm not lying. Only He knows. He knows what's good and what's bad. And He knows I'm a good person, and He's an evil spirit, nasty, controlling, using mankind, womankind.
We're going to arrest you for pretrial release. Violation of pretrial release, okay?
No, I was on probation violation. I got bonded out for my probation violation.
I don't know what that's about, but this is a different charge. Hey, if you start that again, I'm going to pepper spray you.
I don't care about that.
You will. It sucks. I've had it done. Straight in my eyes. It's horrible. Now please stop. Please don't do that. Don't hit your head.
After learning the reason for her arrest, Medea became overwhelmed with stress and confusion, slowly spiraling into madness until...
Alpha, I'll be pulling over on the exit 25. Hey, get me rescue 1018, please. She seems to. I saw that. Let's see if we can get her out on the route. Ground. Hey, hang on, we got you. We're here, relax. Yeah, it's real. Huh? It's real. Yeah. May I step it up? No, she's up. Got a pulse. Put up. She's breathing, just not conscious.
Yeah, still see her breathing. I see her pulse in her neck.
Yeah.
Very thready. I'm gonna get the AED out just in case.
She's seizing again. Let me roll her back down. Okay. Just breathe the handcuffs right now.
Yeah, because at least the handcuffs are keeping her arms still.
Here.
We're right here.
We're right here.
Right here.
It's okay.
Second round. Starts seizing again. At least the handcuffs are keeping her arms from flailing around. You okay, Miss?
I got a pulse.
Okay. Can we go left side recovery?
Yeah. Let's unhandcuff her if we can. Got it?
Yep. Oh. Go again.
Just get one off.
This one.
All right, cool. Roll her back over.
Left side we still got the...
Okay.
Now let's...
Anytime we roll her on our side, she starts seizing.
All right. Feel her arms tensing up. Yep, here comes another one. I lost pulse.
Going nuts in the back of the spinal.
Yeah. That's agonal breathing. I got pulse again. I got it.
You got it?
Got it. Left side, left side. Oh. Oh, is that, oh. That's agonal breathing. Let's get this on. Yeah.
It is safe to touch the patient.
Hey.
If needed, begin CPR. For help with CPR, press the flashing blue
Hey,
button.
there you are. Hey. We got medical on the way. Hey, open your eyes and look at me. I see the
15
heartbeat in the neck
seconds
still.
until
Yeah.
analysis will resume.
Another seizure. This is 4? 3 or 4?
No, I think we're up to 5 now.
If needed, begin sequence.
Calm down. We're right here.
The 45 seconds until analysis will resume.
Kind of video paramedics that seem.
The strict no-contact order against Medea stemmed from a felony battery she had committed against Anthony, the same person she had been arguing with earlier. During her arrest, she also bit an officer's middle finger, though fortunately it did not cause any serious injury. After Medea was taken to the hospital, she was transported to jail and charged with battery on a law enforcement officer, resisting without violence, violation of pretrial release, probation violation, and violation of a pretrial release condition for domestic violence. YouTube thinks you'll love the video on screen. Click to watch now.
Know that I excused you, but you may leave. Oh, you may leave. Dude, go, because you are so rude. Haverhill and Clark, where's this Tracy Roberts?
Timothy Bracco, P59214 for the plaintiffs.
She on?
I'm that.
Yes, you are. Hello, how are you doing?
I'm well, Tracy Robertson.
All right. And where are we on her case?
Your Honor, current rent to retain is $5,590, cost $170 for a total redemptive amount of $5,760.
All right. How are we going to get this paid?
Okay, we have several issues. Last time we was here, we were supposed to work out a deal. They never got to me because we were behind or whatever. However, I did hear back from Social Security. They are reinstating my disability benefits. However, I went all winter, no heat. Management knew, previous management knew. She knows now because she's had maintenance come out twice, and I have on video stating that the AC doesn't work correctly, nor does the heat. The last time we were here, you advised them to have HVACs come out. No one has came.
I advised them to have what come out?
You told them to check onto why the unit wasn't being heated up.
I advised them, my notes reflect that I advised
no one came.
Somebody out to look at the...
No one's come.
Well, didn't you just say somebody did?
Maintenance came, not HVAC.
Well, HVAC is a type of system.
Well, but I also have it on video, 2 different maintenance men stating that the AC and the heat is not working, that it's not flowing.
Okay. All right. I get all that. But then the question becomes, are they going to repair it?
That's the question. And also, just a little note, as according to the CARE Act, since I didn't receive a 30-day notice, I received a 7-day notice. I'm also asking that the judge dismiss this case as according to that act.
So you want them to give you a 30-day notice?
I do.
Ma'am?
She wants to make my life difficult. I'm going to make hers difficult.
Well, I don't know if she's trying to make your life difficult. She's got her
on several.
Got her job to do.
I understand that.
Hey,
I do.
What? Here's what I'm going to do. I ruled on the CARES Act. I don't know that you properly asserted it.
I wasn't. Never got to me.
Yeah, you're going to keep interrupting me because if you interrupt me one more time, it's done. And if you interrupt me after that, you're going with him. Am I clear?
Crystal.
Counsel, in the past, I issued an order that the CARES Act can be an affirmative defense for those units that would be covered by that. I'm not sure if Haverhill and Clark is federally subsidized in any way. It is. So that may entitle tenants rather to a 7-day notice to a 30-day notice. My position is that my order indicates that it must be asserted as affirmative defense. Another court, 14B, the same way I did, was the circuit court overruled that. I realized there were different bases upon which the district court's decisions came in. The circuit court overruled that. Quite frankly, it's a circuit court order. This court is not bound by that, but I have not had to rule on that at that point. So what she's asking is that the case be dismissed. You'd have to issue a 30-day notice to her. But at that time, you know,
May it please the court, thank you. Good afternoon, Agent Hall.
Good morning.
You and I have met before, but just to remind you, my name's Kathy Nestor. I'm one of the attorneys representing Mr. Robinson. So, when did you leave the SBI?
The State Bureau of Investigation?
Yes.
March of this year.
March of this year?
Yes.
So you were involved in this investigation from September to March, basically.
Yes.
And your new position at Post, what is your new position?
I'm an investigative sergeant.
So you investigate potential wrongdoing of police officers?
Correct.
Okay. So when you were first brought into this case in September, is it my understanding from your testimony that you were not engaged in any way with this event prior to getting a call after the shooting? Is that correct?
Correct.
Does the SBI on occasion assist other agencies with preparing for big events like this or not? Is that not typically something you do?
Not something that I've ever been involved with, no.
Okay. And what time did you arrive on campus that day?
I believe it was shortly after 1:30.
So approximately an hour after Mr. Kirk had already been removed from the...
Approximately, yes.
Okay. And were you involved in putting up any drones into the air? Were you part of that, or were you not involved?
It's not, no.
So how quickly after you arrived on scene did you become aware that you were actually going to be in charge of the scene?
I believe it was approximately an hour after, so what would have been approximately 2:30.
So for the first 2 hours, you were not in charge?
For the first 2 hours, I didn't arrive till 1:30, so no.
Okay. And once you came from on high that you were basically going to be in charge of the scene, what was your first priority? What were you focused on?
We were focused on, through our major crimes team and our lieutenant, putting together an investigative team and developing initial assignments and a plan as to what we were going to do moving forward.
And part of that is protecting any potential forensic evidence that may be found on the scene. That's clearly important, right?
Correct.
Preserving the scene, right?
Correct.
But it sounds like that's not really your area. That was more maybe Agent Falmina's area.
Agent Falmina was assigned to process and document the crime scenes. It was my understanding that the known scenes at that time, amid the chaos, had been contained and had been secured by the on-campus officers who were already on scene.
And what's your understanding of what the known scenes were? In other words, the area where there might potentially be evidence that you needed to process.
I know that the amphitheater area was cordoned off and managed as best it could with the number of people that were there. I was also made aware that there was a rooftop area that had been secured, and also an area off of the side of that building that had been secured by an officer.
And that building was the Losi building?
Correct.
Wasn't there also a bullet found on another building?
I believe an unfired bullet had been found on another building at some point during my time there on September 10th, yes.
Which building was that, sir?
I don't recall.
Was that considered a scene that was worth preserving?
It was not. My recollection is that that was accounted for as an ejected cartridge from an officer who had cycled his rifle.
Okay, I thought you said it was an unfired bullet, and now you're saying it was a
That's correct.
cartridge?
When a weapon is cleared, an officer would make his rifle ready, which would chamber around.
Oh, I got you.
My understanding was that that's how that was accounted for.
So an officer claimed that bullet belonged to him or her?
That's my recollection, is that was how it was accounted for.
And when was that accounted for?
I don't know specifically.
Do you remember what type of bullet that was?
I don't.
Was it a 30-06? Do you remember?
I don't.
Okay. Do you know where that bullet is now?
I don't.
Okay. So you had the amphitheater area that had to be preserved. And how far out did that stretch? The entire amphitheater or just the area around the tent or what?
My understanding was the entire amphitheater area was cordoned off, and there were attempts to secure the campus itself with a perimeter of officers who were monitoring or preventing people coming and going.
When you arrived on the scene, were you aware that an individual had been taken into custody?
I had heard that, yes.
Did you ever have any interaction with that individual?
I did not.
And were you advised at any point that that person was no longer a person of interest?
Information was passed down that the individual was not considered to be a suspect in the shooting.
And when was that, time-wise?
I don't recall specifically, but I know I was on campus when I had heard.
So whoever arrested him as a potential suspect got that wrong. He wasn't the actual suspect, right?
Sorry, got what wrong?
That he was the shooter.
The person I believe to be the shooter was not the individual who was taken into custody, correct?
And then was there anybody else taken into custody as a person of interest?
There were several people who were detained for questioning and who were interviewed throughout the investigation.
And none of those people were all ultimately cleared by you or somebody connected with you?
Correct.
And were there any other guns confiscated on the scene that day?
There were other firearms that were located on the scene, yes.
How many guns were confiscated that day?
I don't know specifically confiscated, but I know that there was a firearm found in a backpack that was accounted for during the day.
What type of firearm was that?
It was a handgun.
Any other guns that were found on the scene?
Not that I recall.
Do you recall an individual named Noah Gonzalez being interviewed?
I don't recall that name specifically.
Let me see if it refreshes your memory that he was an off-duty, I think maybe trooper that was on the scene that day and that was involved in recovering the holster. Does that refresh your memory?
I know that a trooper was interviewed having been on scene. I don't recall if it was Gonzalez. I don't recall the name, but I do know there was a trooper that was interviewed, yes.
Okay. And just a moment, Your Honor. And do you recall the trooper that was interviewed saying that there was actually a gun found in that holster?
I do not.
You do not?
No.
Okay. Can we pull up? Exhibit Hole 13 and just show it only to the witness for right now? All right, can we go to page 2 of that report? Do you recognize this report? Have you reviewed it as part of your investigation duties?
I do recognize the report now, yes.
Okay, and this is a report prepared by actually Mr. Davis, who's going to testify later in this matter. Is that right?
Correct.
Okay, and on page 2, this is the interview of Noah Gonzalez. Is that right?
That's what it stated on page 1, yes.
And he's an off-duty trooper who happened to be there that day?
Correct.
And do you see on the second paragraph, does that refresh your memory about whether Trooper Gonzalez believed there was a gun found in a holster in that area of the amphitheater?
Trooper Gonzalez included in his report that there was a gun, yes.
Okay. Thank you. Okay. When did you first personally go up to the roof of the Losi building? Do you remember the time of that?
I don't recall. I know it was dark when I went up to the roof, so it would have been later that evening.
And at the time you went up there was already crime scene tape that had been placed around it?
There was an officer standing security.
Right. And to your knowledge, as the head of the investigation, did they ever find any bullets or casings anywhere on the Losi roof?
Not to my knowledge, no.
Did they ever find any bullets or casings anywhere around the Losi building?
When you say around the Losi building, you mean how close? Like immediately around the Losi building?
Correct.
Not to my knowledge, no.
Okay. And then you've been talking a lot about a timeline here that seemed, you talked about it when you were watching the video, but you also talked about the fact that you developed a timeline, is that right?
Correct.
And can you pull up hole 1, please? I'm pulling up on your screen your report that you prepared. Do you recognize that?
I do, yes.
And what's the date that you drafted that report?
Looks like September 14th. It says date created.
And that's the place where, if you could go to page 2, please. Do you see down at the bottom where you summarize Sergeant Bricker's report listing the timeline?
Yes.
Okay, and so it was actually Sergeant Bricker that prepared the timeline, is that right?
He prepared a timeline.
And you incorporated that into your report?
No, I created a timeline.
You created your own timeline?
Yes.
Separate from the one that's in this report?
Yes, using information obtained in the investigation.
And when did you create that timeline?
Over the course of the investigation, over a long period of time, after a lot of reviewing video and investigative time.
Okay. So, as of September 14th, Tyler Robinson had already turned himself in to the authorities. Is that right?
Yes, I believe he turned himself in on September 11th.
So, prior to the time that Tyler Robinson turned himself in, had you all prepared a timeline?
A documented written timeline?
Yes.
Not to my knowledge. I don't know when Sergeant Bricker produced his specifically.
And isn't it fair to say that as of the moment that Tyler Robinson voluntarily surrendered to authorities in Washington County, as of that moment, you all did not know who the shooter was. Is that right?
We had identified a person of interest, but we did not specifically know who the shooter was at that time.
Okay. And you became aware that Mr. Robinson was voluntarily surrendering how? How did you become aware of that?
That information came originally, I believe, from the Washington County Sheriff to the administration at the control center at the university on the evening of the investigation, or the second evening of the investigation.
All right, we're going to get back to that in a minute, but I just wanted to get the timeline down. All right, now I want to go back to the videos that we've seen and the question that I just asked before, which is it fair to say that nothing about the video of the individual on the roof revealed to you, you couldn't see facial features, you couldn't see what they were wearing, correct?
Of the individual on the roof?
Correct.
I know that there was a meeting to discuss perhaps a pattern on the front of the shirt that was observed when the individual was jumping off of the roof.
Okay, that's fair. But at that time, as of the 11th, before Mr. Robinson turned himself in, you all had not been able to determine that. Is that right?
Excuse me. Determine who he was or
No.
determine distinguishing features?
Determine distinguishing features of the video of the person on the roof.
Yes, we had a person of interest, and those images were released to the press.
You're talking about the ones in the stairwell from the
Correct.
from the parking garage.
Correct.
But the video on the roof was not distinguishable. Fair?
That video as a standalone?
Yes.
Was not, no.
Okay. And in fact, the video on the roof, well, strike that. Is it true that you had some spectators that you interviewed that had gotten a photograph a few seconds before the shooting of someone on the roof?
Sorry, I'm not sure I understand the question.
Did you, at some point in your investigation, collect from two young men who were present at the event a video that they had taken of someone on the roof about 10 seconds before the shooting?
Yes, a video, yes, not photographs. A video was collected from an individual who had a video.
And ultimately, some screenshots were taken out of that video, is that right?
By
you?
Not by me, no.
Okay. That's fine. It could have been someone else.
Okay.
But did you see the video that those young men took?
If you're referring to the video that is looking north and shows an individual dressed in dark clothing on the corner of the roof,
Yes.
if that is the video, I have seen that video, yes.
Did you review the interview of those young men?
I did not.
Do you know how they described the person on the roof?
I don't know if I read it or if I heard it, but my understanding was they believed it was Overwatch or some kind of a police Overwatch for the event.
Okay.
If that's my recollection.
And do you remember anything specific about the person's build that they discussed when they described the person on the roof?
I do not know.
Okay. There is a portion of the video after the individual jumped off the roof, which we all saw here, where the individual crosses, I believe it's Campus Drive. Is that right?
Correct.
And there's a moment where the individual waits and there's two cars that pass in front of him, right in front of him.
Correct.
And is this the moment where you are submitting that he was holding a gun in his hand?
As across the road?
Yes.
From my observations, would show that he's carrying an object in his hand that's concealed or in a bag, and it is long and has the appearance, based on my training and experience, it could be a firearm.
But do you see a gun anywhere? The actual gun?
In the video?
Yeah.
No.
All right. And did anybody that was driving by on Campus Drive that day report to you or any other investigative entity, hey, we just drove by a guy with a gun who was leaving campus and he was standing right by my car?
We did not receive any reports to that effect, no.
Okay. Also, when you were revealing the timeline, exactly how long was there between when the person was prone on the roof and when the shot was taken? Do you recall?
If you would like to replay the video, I can time it for you, but I don't recall. It was my guess, I would estimate between 15 and 30 seconds.
So between 15 and 30 seconds to lay flat, take a shot, and get up and run off, right?
I think you asked how long he was prone.
Right.
I think it took longer for him to crawl into position.
Okay.
And then establish a position, and then take the shot. He appeared to be in prone for approximately 15 to 30 seconds, but the video would verify that.
Okay, thank you. All right. I want to talk to you for just a minute about the video that was taken. And I'm not going to get into I'm not going to show it, just so that in case anybody's concerned about leaving the courtroom, I'm not going to show it. But there was a video that was taken by Mr. Ty Phillips from behind the individual that was speaking to Mr. Kirk.
Correct.
And it showed like a dead-on view of Mr. Kirk and his parts of his security team. Is that right? And then you also have video that you described that shows the back of the tent at the moment the shot happened. Is that right? Behind Mr. Kirk.
You're referring to the UVU video in the breezeway?
Yes.
We have that video, yes.
Okay, and can we pull up the last video, the last clip, 49? I want to show you, just you, this clip. That is a little clip from that video under the breezeway that's behind the tent, right?
Correct.
And just to be clear, this area behind the tent would not have been visible to anybody that was on the Low-C building. Is that fair?
I can't answer that question.
Yeah, sure.
And Ms. Nestor, as you're playing this, are you just being cognizant if the sound is on or not?
I don't want the sound. Please.
Okay, I just wanted
not-
to
Thank you for
clarify.
bringing that. Thank you.
All right.
No sound. I just want only the witness to look at it. So can you just watch this clip for just a minute? This one little clip of behind the breezeway at the time of the shot.
That's fine. And so just as a reminder to all the parties, if it's on your monitor, please be cognizant of that. It will not be displayed on the main monitor. Ms. Nestor, you may proceed.
Thank you. Is it playing? Okay. Do you remember that? Does that refresh your memory of what's in that clip?
Yes.
And having reviewed that, at the time the shot was fired, there was no one standing directly behind the tent. Is that correct?
You'd have to show me it again. I wasn't specifically looking for that.
Okay.
But I can answer that question if I can view the video again.
Okay. And just before you do that, I think you testified before that Mr. Kirk would have been dead center behind that banner. Is that right?
Approximately.
Okay, so what I'm asking is if anyone behind that banner, dead center behind Mr. Kirk, if there was any people standing there. Go ahead.
So there's a videographer on the right side of the tent, and then I can only see as far as the video allows me to, so I can't speak to whether there's anybody out of frame who could have been behind the tent.
But what you can see, is there anyone directly behind the middle of the tent?
Yes, there's a videographer stood behind the tent.
To the right?
Yes, behind the tent.
Correct. But directly in the middle of the tent, is there anyone standing?
There's no one stood in the middle behind the tent, no.
Thank you. All right, I want to talk now about the TP. You can take it down off of the screen. Thank you. I want to talk now about the TPUSA video that you got. That was the angle that was taken from behind Mr. Kirk while he was talking, looking out at the audience when the shot was fired. Do you remember that video?
The visual impulse videos?
Yes.
Yes.
All right. Is it true that Visual Impulse provided 4 videos?
Yeah, I believe there were 4 total videos that encompassed everything that they provided to us, yes.
But the one that you showed, that's only one of the 4 that they provided to you?
That one that was shown had a Bates number. It was an item that was provided by Utah County Attorney's Office.
Okay, but were there more that you haven't seen in this courtroom, in this prelim, that you got from?
There's the original footage.
Okay. But were there other angles that are not shown here in this prelim?
Yes.
Okay, that's what I was trying to get to. Thank you. All right. Were you involved when the gun was located in the forest area?
I was not involved in the search for the gun, no.
Did you get notice when it was located?
From the footage that we reviewed, we identified an area that we believed could be potentially of evidentiary value, and then it was secured, and then I was notified that as a result of that search, a gun had been located, yes.
Were you involved in the processing of that gun? In other words,
I was not.
boxing it, shipping it, sending it wherever it was going to go to be
I
analyzed?
was not, no.
Okay, thank you. All right, now I want to shift to the autopsy for just a moment. You were not present at the autopsy, is that right?
I was not.
Okay. So anything you know about the autopsy was not from personal observation?
No, other than from my meeting with the medical examiner and his report, no, I was not present.
Did you meet with the medical examiner after he had conducted the autopsy?
I did, yes.
And when you met with him, did you provide him information about what you all had learned in your investigation so far?
We didn't have any reason to provide any investigative information to him. The purpose of the meeting was to establish what information he could provide to us.
Well, in fact, on the front page of the medical examiner's report, he talks about the investigation and information he learned. Did he learn that from you, or did he learn it from someone else?
Would be my recollection that he did not learn that from us, but I couldn't speak to how he did learn about it.
Okay, so you didn't share with him your conclusions about what happened or how Mr. Kirk was injured or anything like that?
That's my recollection.
Okay, thank you. And isn't it also true that fingerprints that were taken from Mr. Kirk and autopsy photos were provided to you on a CD?
Yes.
Was there anything else provided to you from the autopsy other than that?
Other than the CD and the report?
Yes.
Not to me, no.
Okay. You did mention not to you. Were you aware of anything else from the autopsy going to anyone else?
I believe standard practice is anything of evidentiary value that the medical examiner collects is transferred through a chain of custody.
And are you aware of anything that was transferred after Mr. Kirk's autopsy?
I'm aware that there were items transferred for evidence, yes.
What items?
I believe some fragments of a bullet casing. I know Mr. Kirk's personal items to be returned to the family. That's all I can recall off the top of my head.
Do you know how many fragments from the bullets?
I don't.
Now, I'd like to talk a little bit about the Ring camera that you obtained, and you interviewed a woman named Ms. Noble, is that right? To get that Ring camera that we watched with the car on the outside?
We interviewed her to verify the authenticity of the video, yes.
And were you involved in that interview?
With Ms. Noble, yes.
And do you recall what they told you about what they remember seeing in and around that car that night?
I don't recall. I just know we were there to verify the video. I didn't conduct an interview with Ms. Noble at that time.
Okay. Can we please bring up whole... Sorry, just a moment. Let's see. Whole 48. This is Ms. Noble's interview. Do you have it? All right, do you remember that? Looking at that interview, does that refresh your recollection?
I remember reading the report at some point, yes.
And do you remember that the Nobles told you that the driver of the vehicle was bald?
I do remember that being in the report, yes.
And you didn't mention that today when you were talking about that Ring camera, did you?
I did not.
And did they also tell you there were 3 other people in the car?
Yes, I believe they thought that was the case.
Okay. I want to go back, if I can, to the scene itself, the preservation of the actual scene where Mr. Kirk passed. Did you all have canine dogs at any point that sniffed that area?
I don't know specifically that area, but I do know that canines were present, or a canine was present on the day.
But you don't know what task the canine was given?
My understanding was that it may have been used in an effort to track an individual that had jumped off the roof, but I don't know for certain.
And obviously that didn't produce any results, or we would have heard about that, right?
Yeah, not that I was made aware of.
Okay. Do you know when the tent and the stuff was actually removed from the scene?
I don't. I would imagine it had been at least a couple of days, if not longer than that, before anything was removed from the scene.
You didn't have to give permission to remove the tent?
Me, personally?
Right.
No.
So you're not sure when it was removed?
No.
And were you involved in the decision to pave over the dirt that was under the tent?
AUVU?
Uh-huh.
No,
Did you know that happened?
only because it was in the news.
All right. But you don't know when or who ordered that?
Nope.
And it's true that during the time before Mr. Robinson turned himself in, you all received lots and lots of tips from the public. Is that fair?
Correct.
You received tips of death threats that Mr. Kirk had received before, the day before the shooting. Is that right?
I'm sorry, did we receive threats that Mr. Kirk had received before the event, or?
Let me clarify. That
Thank
was
you.
a confusing question. As you were going through tips that the public was giving you, did you receive tips about online death threats that had been made against Mr. Kirk prior to his death?
There was a huge variety of tips and information and suggestions that were being provided by the public.
Okay, and a lot of those, some of those filtered through you, right?
Some of them filtered their way down to us, but predominantly that was being handled by our State Information and Analysis Center that had been set up.
Okay. And you also got multiple tips about potential suspects, people who thought they recognized people in the picture, right?
Yes, there were different calls and information provided by the public.
And you had quite a few of those.
Correct.
And then Mr. Robinson turned himself in, right?
Yes.
And is it your understanding that the individual they used to facilitate Mr. Robinson turning himself in was someone known to Mr. Robinson personally that had been connected to law enforcement?
I know he was known to the family. I don't know his connection specifically with Mr. Robinson, but I am aware that someone was used to facilitate Mr. Robinson turning himself in.
And were you aware that he was one of his Boy Scout leaders? Did you know that?
I think I had heard that at some point. There was a connection. I didn't recall specifically what it was.
And Mr. Robinson, in fact, no police went to go arrest him. He drove himself, or he was driven with his parents to the Washington County Sheriff's Department, correct?
That's my understanding, yes.
And he voluntarily walked in.
That's also my understanding, yes.
And that was the first moment you ever knew his name connected with this case.
Yeah, aside from the image that we had, that was the first time that we had a name of an individual who had taken responsibility, yes.
And did you personally ever meet with Mr. Robinson?
I did not.
And as far as you know, Mr. Robinson did what he said he was going to do. He told the police he was coming peacefully, he was coming with his parents, and that's exactly what happened.
I don't know any of the specifics of how he was arranged to turn himself in. Okay. In terms of what you've described, I just know that it was being facilitated with the sheriff's office.
Okay. Court's indulgence for just a moment, Your Honor.
Yes.
Thank you, Agent Hall. I tender the witness, Your Honor.
Thank you. Redirect by the state.
We're going to go back to a few things that Ms. Nestor asked you about. First of all, the unfired bullet that you referred to. Is your understanding that that bullet was accounted for?
That's my recollection, yes.
Okay, and it possibly belonged to an officer that could have maybe been clearing his weapon.
Yes, that's what I recall being told about that particular item, yes.
Are you aware of if on the 10th there were police officers present that were actually securing buildings and securing rooms there at UVU?
I know prior to my arrival, it was a dynamic and active scene that I believe was originally being treated that there was an active shooter on campus. Mm-hmm. So there was a large, rapid response of law enforcement who were actively trying to clear and secure and ensure that the campus was safe, if that answers the question.
The entire campus?
Yes, correct.
Okay. And what types of officers were there clearing the campus?
Originally, there would have been probably local units who would have responded, but subsequently specialty teams would have been deployed to do a more methodical search of the campus and what we would call a clearing of the campus.
And those specialty teams and any other officers, how were they equipped? Like what type of equipment were they
I
carrying?
believe most officers carry a sidearm, a handgun, and most officers in this day and age are equipped with a rifle platform as well.
Okay. When you said that it was possible that round was from an officer clearing his weapon, what exactly do you mean by that?
Our standard practice in our department is to carry a rifle cruiser ready, which is we carry our rifles in a situation which is called cruiser ready.
What does that mean?
It means we don't have a round chambered. So if an officer deployed with his rifle, he would chamber a round. Once he had done whatever task it was that he was doing in order to put that weapon back, he would eject the magazine and eject the round. Sometimes in doing so, rounds are dropped or not accounted for.
Okay. Have you personally done that yourself?
We do that at training, and I've done that in the field as well, yes.
Okay. And you're aware of, is that something that's common among police officers in this situation?
I believe for most agencies that's how they carry their weapons, but I can't speak specifically to agencies outside my own.
Do you have any idea how many officers were dedicated or sent out to clear the campus?
I can tell you I had to park on University Avenue and walk all the way onto campus between hundreds of police cars, so I would say hundreds, if not 1,000 officers, high hundreds would have responded to the campus that day.
Now I'm going to ask you about, Ms. Nestor asked you about your observation of seeing Mr. Robinson with something in his hand. And I think she was asking you about Mr. Robinson just prior to crossing Campus Drive, following the shooting. Do you remember that question?
Yes, I think I was asked whether he had a gun in, or I had seen a gun in his hand in the video.
And you said that you did see something in his hand?
Correct.
Okay, I want you to go back as far as you can remember. At what point after Mr. Robinson stood up on top of the Losi building and ran across, I believe to the northeast corner, when did you first notice in that video something in his hand?
The first time you can clearly notice he has something in his hand, without a doubt, is when he's on the white triangular portion on the northeast corner of the Losi building preparing to jump. It is very apparent he has an item in his hand.
Okay, and that's based on your observation of the videos?
Correct.
Okay. And is it easier to see in that enhanced video?
The zoomed version of the video makes it a lot clearer to see, yes.
Okay. And then after he drops down off of the roof of the Losi building, is there any time between that point in time and making his way to Campus Drive that you believe you see, again, something in his hand?
As Mr. Robinson lands on the grass, it's almost like he either drops it or goes into a crouched position, and then when he returns up from that, it is again clear that there is some kind of an item in his hand, yes.
Okay. Can you be more specific or describe in more detail?
It appears to be black, and it appears to be longer.
Okay, anything else about that item?
No.
Okay. I believe it was Exhibit 9, State's Exhibit 9, that Ms. Nestor pulled up on the screen, and she had you look at that. And I believe what you looked at was beginning a still image, but then a few moments or a few seconds of that video. And that's the UVU tunnel video. Is that right?
The breezeway underneath the Hall of Flags, yes.
And the view is from behind, where I believe you testified that Mr. Kirk was on the other side of what appears to be a banner.
Sure.
In that tunnel view.
Yes.
And on the other side of that banner is the tent, and then the rest of the courtyard. Is that correct? Fair to say? Do you remember seeing the banner?
Yes.
In the video? Okay, and
You're referring to the back of the pop-up tent?
correct, yes.
Okay, yes.
Okay. And do you remember, what do you remember about that banner?
It has some kind of an emblem on it, and it forms the back portion of the pop-up tent.
Is it opaque? Is it transparent? How would
No, you
describe
can't see through it. It's white,
Right.
and you cannot see through it, no.
And how much of the tunnel does that banner, I guess if it's opaque, obstruct?
I couldn't say. I'm assuming it's a 20 by 20 gazebo, so it would block out the area of the back of the tent that you can see. You would not be able to see through it. You would not be able to see through it from the audience side of the amphitheater.
And what about the tunnel side of that banner? Can you see through the tunnel side in the opposite direction?
You cannot, no.
Can you see Mr. Kirk on the other side of that banner?
You can't, no.
Okay. Well, we exhibited, or Ms. Nestor had you watch just, I believe, just a brief few seconds of that video. That exhibit is actually much longer than what we just looked at, or what Ms. Nestor had you look at. Is that right?
Correct.
Okay. And leading up, and again, I'm referring to that view, that tunnel view of that surveillance camera, leading up to the shot, what's going on behind that banner?
There are representatives, I believe, of TPUSA, but there are representatives of TPUSA. There are law enforcement representatives. I don't know if there's any student body, but essentially people are moving to and fro behind that area. A couple of individuals are retrieving items from a vehicle, but there's consistent movement behind and in that area.
Okay. Directly behind the banner?
Correct.
Ms. Nestor asked you about the wooded area that Mr. Robinson entered. Well, Ms. Nestor brought that up, and I believe your testimony has been, between today and yesterday, that you witnessed Mr. Robinson enter a wooded area on at least 2 occasions. Is that fair to say?
Yes, on his second visit to the campus and on the visit where the incident took place.
Okay. At least on those 2 occasions, did the wooded area that he entered, were they different parts of the wooded area, or was it the same parts of the...
They appeared to be the same.
You're aware that a rifle was eventually discovered?
Yes.
And was it your understanding that that rifle was discovered in a wooded area?
It was in the wooded area where we believe Mr. Robinson entered the wooded area, yes.
Okay. And that rifle was discovered on the 10th?
Yes.
Ms. Nestor asked you about a variety of tips including threats to Mr. Kirk, I think before the event?
Yes.
And did you follow up on those tips?
After tips have been put through a process and been analyzed and screened, anything that appeared to have relevance to either the investigation or a credible threat was managed by the various entities involved, yes.
Okay. So managed by law enforcement, so...
Correct.
Did you personally follow up on any of the tips?
I don't think I personally did, but I worked closely with people who did.
The point is, I guess, is that those tips were followed up on. Is that fair to say?
To the best of our ability, yes.
Okay. And then Ms. Nestor also asked you about tips, I believe, of people reporting to police that they felt like they knew who the shooter was.
Yes.
Okay. So identities of possible shooters.
Correct.
Did law enforcement follow up on those tips as well?
They did.
Ms. Nestor, finally, Ms. Nestor asked you, she asked you whether Mr. Robinson voluntarily went to the sheriff's office down in southern Utah. Is that right?
Yes.
Okay. And that was the Washington County Sheriff's Office?
Yes.
Okay. And you understood that he turned him, well, he showed up there voluntarily. Is that right?
Correct.
What was your understanding as to why he was showing up there voluntarily?
He had informed, I believe, his immediate family that he had been involved in the shooting and that he wanted to turn himself in.
Okay. Nothing further. Oh, sorry. In the video that we've already talked about, the video where Mr. Robinson stands up and runs across the top of the LOSI building, do you notice whether at that point, after he stood up until you see him last, at least in that part of the video, do you notice whether he's walking or running with a limp?
He is not. From the time he left after going over the railing, when we see him on the video move out to the position.
Correct.
And then leave the position, there is no longer a visible limp or gait.
Thank you.
Ms. Nestor.
No follow-up, Your Honor.
All right. May Agent Hull be excused?
Yes, Your Honor.
All right, Agent Hull, thank you.
Thank you, Your Honor.
Can we have just a minute to meet if okay.
All right, let's take a 5-minute break and allowing parties to confer. Court is in a brief recess.
Well, that's what you have to do. And I'll just say this, that, you know, you can get mad at folks all you want. It's at 5.7. How much is monthly rent, Nadia?
13 and some change. May I speak, Your Honor?
So it's going to be, you know, by the time I get back here, if nothing else is paid, this thing is going to be down near $8,000.
No, Social Security is reinstating my benefits. They're going to back pay me from April. It's just taking them a while to get to me because they have to, I'm fighting them in court for that as well. But they have reissued me papers saying they're going to reinstate it. They're going to back pay me from April, and that's $1,690 for those months.
So I'm going to dismiss the case, issue or a 30-day non-payment rent notice. Counsel. I don't know that I excused you, but you may leave. No, you may leave. Dude, go, because you are so rude. Leave. Yes, you may. Go ahead. Go ahead.
When I left the courthouse, I did my due diligence. I went and checked the unit, the AC and the heating is.
Ma'am, you don't have to go on. I'm just going to say this. That was about something else. And I've been doing this long enough to figure that all out. All right. State your names. All right, where are we on this? Let's start with the non-payment of rent case. How much are you claiming is owed?
I know.
Did you receive her answer?
You say, sir?
Did you receive her answer to the complaint?
I sent it to her attorney. They don't have an attorney.
All right. Resend a copy to her. How much are you claiming is owed?
Me?
Yes.
$929.83.
And you're claiming you don't owe that.
If I don't agree with the amount owed,
Have you put any money in escrow?
no, I have not. I'm trying to get I want the ledger from when I first moved in to now to see She said that I didn't owe.
How much do you think you owe?
So $9,900.
Say how much?
9,900.
That's what you think you owe?
Yes.
So 9,900.
Yes. Cause from
Are you prepared to just pay that to her?
in increments, yes.
All right. On this case, the non-payment of rent case, the monthly rent is still 3,300. So I'm going to order escrow. So that means on July 1st, I'm just going to start at July 1st. You need to pay $3,300 into the court. I'm going to set this for a final settlement conference. I'll set it for final settlement conference July 14th, 2026, 9 a.m. That's in-person hearing. And you need to bring a ledger and you need proof of payment. Understood? That's that case. On the next case, there is also an answer in that case, the health hazard determination case. There's currently a lease, isn't there? Then I'm not sure how you're terminating. What's the theory upon which you're terminating your tenancy?
Your Honor, the reason why I'm requesting this session is because I contend that the tenant has repeatedly failed to comply with provision for the lease, including failure to provide access for municipal inspections, failure to provide access for repairs.
Or is this just retaliatory because you keep taking it to court?
I have not been able to do it's scheduled for April 6th. We had it scheduled for May 6th. We had it scheduled for June 8th. And now again, we have it scheduled for June 29th. And she's not complying. We've had the municipal inspector.
How come you won't let them in?
I was told I can make my own inspection, but because
Make your own inspection? What do you mean?
like I can do it myself. She doesn't have to make them or be there. The last time I literally told her it wasn't a good time and she came anyway.
All right, then here's what I'm going to do. I'm going to turn this to a final settlement conference. Defendant to make appointment for premises inspection with the township. You understand that? It's adjourned out to the 14th at 9 a.m. I'm also going to indicate that at that inspection, plaintiff does not need to be present.
Sir, I have a question.
Sure.
The township is scheduled to be there on the 29th, which is Monday.
See if they can set it for the, I don't care. If they set it for the 29th, if she can you do the 29th? Okay, then you got to set it and it's got to be done before you guys come back and see me. You can tell them what I just ruled. She's to set an appointment with them. It's got to be before that date and you're not to be there.
Can I ask another question? If there are damages, am I going to be able to evaluate the damages to repair them?
If the township comes out and says something needs to be repaired, we'll deal with what needs to be repaired. Thank you. Court's going to stand in recess. Let's get the rolling now. Come back and I will gladly hear Ms. Dornbush's case. All right. Court stands in recess.
All rise. If you're involved in a dispute with
Great. Morning, Your Honor. Good morning, sir. Your Honor, I'm requesting an adjournment of this case. Your Honor, it's all appropriate. Yes, why don't we address bonding? Your Honor, I'm going to be asking that the court raise bond to an amount of $5,000 cash or surety on this case. As the court is aware, the defendant failed to appear back in February for this pre-trial, as well as a felony matter that was set for PCC. In the time between then and today, the defendant has picked up 2 new felonies for retail fraud in the first degree. I authorized these just recently. I don't think they've been sworn to, but those have been authorized are coming down the pipeline shortly. Those are, in all candor, both based on priors, not values. So it's not more than 1,000, it's between 200 and 1,000. But because it's prior retail fraud convictions, that makes those into felonies. I have concerns in these committing offenses while on bond as well due to his previous failure to appear. That PR bond is no longer appropriate, and so I'm asking for a $5,000 cash or surety, or in the alternative, if the court is not willing to grant that, a GPS tracking tether. Your Honor, may we have the offense dates for the new charges? I'm trying to make sure that they aren't covered while he was on bond for these cases.
Let me one was February and one was April 22nd, both of this year.
February 10th.
And April 22nd.
He was on bond, and one of them he allegedly would have committed while on bench warrant status in this case. So would the court consider 2,500, 10%? No, right. I think it's appropriate that it's a $5,000 bond in this case. I'll adjourn it to my next date of July 1st, 2026, 9 a.m. Bond is raised to $5,000. You were requesting cash surety?
Correct, Your Honor.
$5,000 cash surety. Have to go pending extra mandate. Gotta go with the option. Go with him. Court does call the case. People versus Nicole Henderson.
Good afternoon, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Ms. Henderson, who's making her way out. Your name?
Nicole Henderson.
All right. Your Honor, may I address bond? Well, what are we doing on the case? I'm requesting an adjournment for referral potentially to a sobriety court here in Washtenaw County. Go ahead, you can address bond. I have, first of all, information that she's written that I'd like to share with the court, if I might approach. Have the people seen? Yes.
Yes, you should.
Yeah. I gave them both. That's why I had you print it up. I had to give. Go ahead. I can read and you can talk. Yes, Your Honor. My client's mother is present in court. If she were released, she would reside with her mother and her 4-year-old daughter on Maple Lawn in Ypsilanti. She is employed by General Motors, and General Motors has an employee program where she can participate in programming. She needs to get out to get an assessment. Currently, I think her bond conditions are $50,000. I'm unsure if there's a 10% privilege. However, you also really, yes, I'm asking the court to release her so that she can get an alcohol assessment and begin the process of being screened for sobriety, Your Honor. Mr. Cook.
Your Honor, all concerns that the people stated at the last hearing I still have. I told Mr. Brown that this is not a situation where I would be agreeing to reduce the bond in this case. I wanted to get into recovery. I wanted to get into sobriety court. I don't know if I can trust her at this point to be released on her own in order to get that done. I think she would need to get screened and get something in place first.
She has to get out to get screened, not to interrupt counsel, Your Honor. You what? She needs to get out to get screened for sobriety court. She needs an alcohol screening and assessment. Well, which sobriety court, though? Well, are we talking? Because she has a Washtenaw County residence. She would have been Ypsilanti on Maplewood with her mother. I think they will screen in jail. I'm not aware that Mr. Statman, that's the screener that the court generally uses. Well, I
somebody's going to have to, we're going to have to find another way to do it, because with everything that has happened with this defendant, I'm not inclined to release her until there's a clear plan in mind of where this is headed.
Understood.
We had
just presented to the court in writing an action plan for at least an IOP, but through her an employer at General Motors. But again, we need the assessment and to get her out.
I hear that, but we're going to have to find another way to get her assessed, at least preliminarily, and start that process. I can't let this defendant out. She had a prior. She has a 0.235 alleged on this case, and she had another one that's pending she has one that's pending in Wayne County, I do believe, and then this one, and she has a prior. I mean, and she's all over the place. I mean, her alcohol levels are not low. Say what you want, damn.
I saw that that you wanted me to be released on a scram tether, or I could have made bail with that, but they said the tether people aren't gonna give me a tether because of my hold. So I was asking I talked to my attorney
Because of which hold?
Because Shelby County, or I don't know. They didn't say. They just said that they wouldn't give me a tether if I have holds. But I was asking if we can get released on the sober link or the scram tether. It's the GPS tether that I can't make bail with.
Relating to the holds, I am seeing there are numerous out-of-county holds for...
And they're just not going to tether her with that. But you can post the cash component?
Yeah. My mom talked to a bail bonds.
Actually, she has a bond denied with Shelby, as well as a 2010 for separate OWI out of Clinton, among other holds. I'm not sure if they're going to pick her up on those or not, but she does have, by my account, 7 out of county.
She traffic. Most of those are.
So she's got a no bond on one of them.
Correct. That's for malicious destruction of property. 2010% on an OWI. It looks like there's, I would say 4 traffic holds for like no proof of insurance or DWLS, things that I don't think she could picked up on.
Right.
And then a $500 hold for something it said NVOP. Frankly, I don't know what that stands for.
My problem is I'm not inclined to change it, but
will you change the tether?
If you say that you can post, I'm just concerned, are we going to get her back? That's my issue, because I don't know what's going to happen in Shelby Township. I mean, can we see, or does anybody know, is that like a post conviction, so she pled and then that's a probation violation, or what is that?
I don't know. The information that I have just says Garden City Police Department bond 500 for NVOP.
Okay, that's that one. But then there's the other one that's the bond denied.
Correct. That's for, I only have that shows it's bond denied for malicious destruction of property. It does not give me the value or the severity of the offense, and just says Shelby Township Police Department. I can try looking at court records to see if they have anything, but that might take me a second.
Yeah, no, was there a plea up there? Do you know?
No, I don't.
Right, look, I'm not gonna stab around in the dark trying to figure out what's where and what it is. Somebody has to let me know what those other warrants are. I'm not necessarily opposed to the tether, but I'd like some assurance that we're going to get her back.
Would you at least consider a silver link?
That's what I just said, Mr. Brown. I'm not opposed to that, but
Agent Hall was excused, and we are proceeding. Mr. McBride.
Yes, Your Honor. We intend to call Jennifer Falmuina, but before I do that, I'd move the admission of State's Exhibit 5.1, if I can approach the bench.
Yes. Thank you.
Your Honor, there will be an objection, and we want to be heard on the objections. And I didn't know this was coming now. It could be a lengthy call.
All right. Let me just, do you wish to identify what State's Exhibit 5.1 is?
Yes, Your Honor. Exhibit 5.1 is a self-authenticating 1102 statement issued by David Engelhardt from Turning Point USA.
All right.
And again, I say it's a self-authenticating document. As you can see there, it's got the admonition on page 1. The body of the 1102 statement is there on pages 1 and 2. I would say number 4 is kind of the foundational statement, paragraph 4, but the self-authentication portion is the notary acknowledgement on page 3.
All right. Turning to Mr. Novak.
Thank you, Your Honor. Thank you, Mr. McBride. So the court, obviously, because the court can decide how much of this we discuss in open court, how much we discuss at the bar, so to speak, sidebar. There's initially a fundamental relevance problem with this 1102. There are also there are other issues, but I think that just to help the court parse the evidentiary issues, we should start with the relevance. There are sub-issues. There's also a problem under 1102 because if the court looks at the last paragraph of this, Mr. Engelhardt, who is the purported author, refers to himself in the third person, so it's not clear to me who actually wrote this report. And as Your Honor knows, 1102 says that prosecutors are not to assist witnesses in writing their own 1102 reports. That's not my primary concern, although I think it is an important issue because that's what the rules require. But the real question is relevance. And I guess the question is, does the court want me to do the speaking objection? Because the court said no speaking objections. Should we approach sidebar? How does the court want to handle it? The people can move their exhibits into evidence whenever they wish. I wasn't aware we were going to do it at this moment. I'm ready to proceed, but the question is how the court wants to handle these objections. I'm prepared to keep going in open court, but it's what the court referred to as a speaking objection.
No, I appreciate that. As it relates to, well, so here's my question for you, Mr. Novak. As you're, and again, I appreciate your discretion in highlighting that point. Do you anticipate your argument being of the nature that would defeat the purpose of, if the court does not admit this, that you've already let the cat out of the bag with your argument, or do you feel that you can make your argument without compromising what is in the 1102, so the purpose of if excluding it is still preserved?
I'll go as far as I think we can go, and then we'll just see. I mean, I do think I am not trying to conceal from anybody in the courtroom or the public, of course, our concerns about relevance. So why don't I, taking the court's lead, go forward publicly with my concerns about relevance, and if we reach a moment where it feels like further argument may deprive Mr. Robinson of his fair trial rights, we can approach.
All right, we'll proceed.
Okay, so then what I'm going to do is I'm going to point out that this proposed exhibit, which is the 1102 statement of Mr. Engelhardt, is basically 4 paragraphs. The 4th paragraph identifies Mr. Engelhardt, although I say in the 3rd person, as a pastor and as an attorney who was a friend and a counselor to Mr. Kirk and was involved in leadership of Turning Point USA. So that identifies who the author is. Beyond that, it's not really relevant to any of the issues before this court. Paragraphs 1, 2, and 3, paragraph 1 talks about Turning Point USA's status with the Internal Revenue Service, the purposes of Turning Point USA, within the context of the Internal Revenue Code, and sort of what I'll just refer to generically as the goals and objectives of Turning Point USA. And it also then talks in the 2nd paragraph about Mr. Kirk's relationship with TPUSA. None of this is unknown information, that he was a founder, that he was the chief executive officer, that he was the president of the board until his death. So I'm still not sure what the relevance is, and I guess actually what I should say is I don't believe there is any relevance of any of this information. Paragraphs 2 and 3 are, and actually I'm going to preface this. My discussion of this is within the context of the rules of evidence, and there's nothing that I'm going to say here that is meant to derogate, criticize, question Mr. Engelhardt's beliefs, what he says were Mr. Kirk's beliefs, what Mr. Engelhardt says he believes are tenets of Christianity. That's not what we're talking about. What we're talking about is whether this document is admissible in this proceeding under the rules of evidence. Okay. So paragraphs 2 and 3 include not only Mr. Engelhardt's opinions, and now I'm going from relevance to opinion evidence. It's not clear to me whether it's lay opinion evidence, whether it's expert opinion evidence, but it's Mr. Engelhardt's opinions about a branch of Christianity, his opinions about a portion of the Bible. He quotes the Bible, and he talks about Mr. Kirk's religious beliefs. And I could go into more detail, but the court has the exhibit in front of it itself. So none of this is relevant. If the court looks at the information, that is the document which lays out the allegations against Mr. Robinson, when I use the word information, I'm talking about the court document. There are, with respect to certain counts, what Utah Code refers to as a victim targeting enhancement. That is alleged with respect to count 1. It is alleged with respect to count 2. It is alleged with respect to count 7. And may I step away just to get my laptop?
You may.
Thank you. And as the court knows, but I want the record to be clear, when I refer to the what the information calls the victim targeting enhancement, that's Utah Code Section 76-3-203.14, which the code calls the victim targeting penalty enhancement. The information alleges, and this is, I'm emphasizing this, that Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's belief or perception regarding Mr. Kirk's political expression. And I'm going to focus, if I may, the court's attention on two things. One is, whose state of mind are we talking about? Or whose state of mind is the statute talking about? And what aspect of the victim targeting enhancement is being invoked here? The latter is the state invoking Mr. Kirk's political expression, and now I'm quoting the statute, as the personal attribute that the state alleges is the gateway to this penalty enhancement. And if the court will bear with me, because there's a reason why we have these hearings in public, there are various categories for alleging, I should say, there are various categories of personal attributes, that's the phrase the legislature uses, which authorize the pursuit of a penalty enhancement. And those personal attributes are listed in the statute A through R. I'm not going to read all of them because the court knows the law, but political expression is subsection K. That is separate and distinct from the personal attribute that the legislature calls religion, which is subsection M. So what we have is an allegation that the personal attribute, which is one of the elements of this enhancement, the allegation that Mr. Robinson selected Mr. Kirk was based on his political expression. That's actually the exact same phrase, political expression, as is in the statute subsection K. The 1102 statement is predominantly about what Mr. Engelhardt describes as traditional Orthodox Christian values that he believes in, that he believes Mr. Kirk believed in. And I understand in today's world that there is a crossover between religion and politics. I think we can all acknowledge that. But the legislature and the information here are focused on political expression. So I'm concerned that the 1102 statement of Mr. Engelhardt goes far beyond the scope of what would be admissible if the state has it to prove that Mr. Robinson targeted Mr. Kirk because of Mr. Robinson's belief or perception concerning Mr. Kirk's political expression. The second element of this is that the victim targeting enhancement focuses on the allegation of what is in Mr. Robinson's state of mind, not what is in Mr. Kirk's views or deeply held beliefs, sincere religious beliefs. And so the evidence that the state needs to present is not what Mr. Kirk believed or said or what TPUSA stood for. It's what was in Mr. Robinson's head, if anything, about selecting Mr. Kirk because of Mr. Kirk's political expression, because that's the information. So why TPUSA exists, what its founding beliefs are, what its leaders' beliefs are, what Mr. Engelhardt believes Christianity is or is not relevant. And that's why we think it should not be received into evidence. There's a second level here, which is Mr. Englehart's statements about what is in the Bible, specifically Matthew chapter 9. And so I would just ask this court the hypothetical question. If the state asked the court to take judicial notice of a portion of the Bible in order to prove this enhancement, because I can't see where else it fits into this case, I think, if I may, the answer would be no, it's not relevant. So instead, what we have is the state trying to use the affidavit of Mr. Engelhardt pursuant to 1102 to get the court to essentially receive into evidence the same information. It doesn't really matter here, in this proceeding, what the book of Matthew says. It doesn't matter what Mr. Engelhardt thinks. And again, I say this with all due respect to Mr. Engelhardt, who I've never met. The book of Matthew means, or how one reconciles the book of Matthew as he sees it with other views on the topics that are there. I mean, I want to be careful and not suggest what other views are, because I shouldn't be testifying about different perspectives within the sort of the heading of religion. But it doesn't really matter for this proceeding what Mr. Engelhardt's views are, what Mr. Kirk's religious views were, what religious views TPUSA endorses, seeks to encourage others to adopt. None of that really matters. There are multiple opinions in this 1102 from Mr. Engelhardt, and it's not clear whether the state has thought about whether it's expert opinion or lay opinion. I happen to think that it's expert opinion that is not helpful to the trier of fact in this proceeding. That's your honor. There is nothing in this that helps the court resolve, with respect to the victim targeting enhancement, whether Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's beliefs or perceptions regarding Mr. Kirk's political expression. If the state comes back up here and says, no, it's lay opinion, we still have the question of whether it's helpful to this court, because the court has to decide whether there is evidence of the targeting enhancement in the way I think I've structured it. So it's not relevant. It's not admissible lay opinion. It's not admissible expert opinion. There are two aspects of Rule 403, one of which I'm prepared to talk about publicly, and one of which I think is appropriately discussed at sidebar, because it does get into undue prejudice. The 403 here is that receiving this document into evidence is going to create confusion. It's going to create chaos, not by the trier of fact, but by the future jury pool in this case. For this court to make a ruling that Mr. Engelhardt's opinions about religion, about TPUSA's views on religious matters, that Mr. Kirk's views on religious matters are in any way what this case is about, is going to create significant confusion. And even if this court doesn't show the 1102 in open court, or the reporters who are here don't get to see it, or if the public doesn't get to see it, receiving it into evidence in light of the victim targeting enhancement that the state drafted and charged is just going to create confusion. There may be, outside of this case, litigation where TPUSA's purposes and its mission and its adherence to its mission are important, and Mr. Englehart's opinions about that may be important in some other context, in litigation, in public discussions. It's not important here. And when I say important, I'm saying it's not relevant. So there's a 403 issue with respect to confusion. There's a constitutional concern that this type of evidence being sanctioned by the court is going to suggest to the jury pool that this is a case about religion. This is not a case about religion. The state doesn't even allege this is a case about religion. The state alleges one enhancement based on Mr. Robinson's perceptions of Mr. Kirk's political expression. So I'm very concerned that this document, even being sanctioned by the court as admissible for any purpose in this proceeding, is going to interfere with Mr. Robinson's constitutional right to a fair trial, which I think is a, sort of an umbrella over parts of Rule 403. If at the time, if there is a trial, if Mr. Robinson is bound over, and if there is a trial, and if the state wants to proffer Mr. Englehart for some specific evidentiary purpose that I'm missing, then we can engage in that. But it seems to me that it's, again, a mixture of lay and expert opinion, which at this stage is more prejudicial than probative. The other part of the 403 issue we can discuss at sidebar whenever the court's ready.
Thank you, Mr. Novak. Turning to the state. And so just to give an overview, what I'm intending to do is address what Mr. Novak has presented, the state respond. I may have some questions limited to what's been presented now. Of course, that doesn't preclude addressing the second portion of that in whatever means is necessary to protect constitutional rights. But we're just focused on this portion right now.
Understood.
Thank you. Mr. McBride.
Your Honor, the evidence is relevant to 2 points. One is to the defendant's motive, which is not an element of the offense, but nonetheless is powerful evidence, persuasive evidence. And 2, it is relevant to the victim targeting enhancement, which has been described and appears in the information. The statement clarifies what Turning Point USA, what Charlie Kirk's business was. And I think as you read this statement, it's clear that Charlie Kirk presented both religious and political arguments and positions in his presentations. And that is what paragraph 3 says, that he engaged others in debate, discussion of traditional family values, Orthodox Christian views on sexuality, marriage, gender, sex, America's founding principles, political doctrines, and so forth. He often spoke specifically and attempted to persuade attendees to follow a mindset rooted in Orthodox Christian and politically conservative values.
Excuse me, Your Honor, can I lodge an objection to Mr. McBride reading the exhibit which we are discussing the admissibility of? And I'd ask the court to strike his statements and admonish him.
All right. So as it relates to reading from the actual 1102, because it's not admitted into evidence, I will, well, before I do that, let me turn to you about the objection to make sure that you are heard as well.
Yes. Rule 104 requires the court to consider evidence before determining its admissibility. How can you determine whether an exhibit is admissible without knowing what is contained in that exhibit? That's what I'm putting in front of Your Honor, is explaining this is why the exhibit is admissible. because it contains this language that is relevant and probative. I don't know how I can make an argument that something's relevant and probative without saying this is what the exhibit says.
Well, Mr. Novak, and I want to make sure I do see you have a microphone. Go ahead.
Oh.
Your Honor is not a jury. Your Honor can look at the exhibit and determine for itself whether it's relevant, whether it meets other criteria for admissibility. It's not necessary for Mr. McBride to read aloud in open court an exhibit which the court has available to it. I'm not saying that the court shouldn't read it. I'm saying that it's not admissible. Okay. I understand that the court has two roles, one under 104 and one as the magistrate, but that doesn't require Mr. McBride to read in open court the exhibit which we are discussing the admissibility of, especially where I have just expressed our concern that the exhibit has a tendency to confuse the issues in this case and create fair trial risks for Mr. Robinson.
All right. Thank you, Mr. Novak. Any final thoughts before I rule on this specific issue about reading from the 1102 by Mr. McBride?
Yes, Your Honor. I have to be able to argue here. I have to be able to refer to the exhibits. I can't do my job as an attorney without being able to refer to the exhibits. If the court doesn't want this to be in public, then we've got to close this proceeding. But I have to be able to argue the exhibits. I don't know how I can make an argument without actually pointing to the language of the exhibits, unless I want to say, you know what I mean, or referring to line 13. It's just so cumbersome to do, Your Honor. And I think my job and my duty to my client, which is the state of Utah, and to their right to fairness, requires me to make a good and powerful argument, and that requires me to refer to the exhibit. And I'll submit it with that.
All right. Thank you to both of you. In looking at this, typically in court, when evidence is being taken, until it's admitted, it doesn't come in. For example, if there's a witness on the stand and one is trying to get a piece of evidence in, that witness cannot read from the document and prior to it being admitted into evidence. And so the court applies that same principle here. However, the difference is, in noting Mr. Novak was drawing points from this specifically, he mentioned Matthew, I believe, chapter 19, and talking about certain points in here specifically. There is room for it to be mentioned in argument in order for the court to fully consider what's before it. I'm going to sustain Mr. Novak's objection and simply say, if you want to talk about it conceptually, talk about the points, you certainly may, but simply reading from it exactly, saying, and I understand, I don't want to constrain either party from being able to make their full argument, but quoting from it in open court, I fear does risk issues to the constitutional rights of the parties. If the parties prefer to go into a closed evidentiary hearing on this issue in order to be unrestrained, and it appears Mr. Novak has requested that for a second portion of his argument, we certainly can do so, because I do not want to put out evidence that is not admitted in open court until the appropriate time, until the court has gone through its decision-making process on whether it should be admitted or not. So to the parties, if you feel you can move forward on this first portion of it, I'm happy to entertain that argument. If the parties feel at this point, at this juncture, that a closed evidentiary hearing is needed in order to fully explore all the issues, I will leave it to the parties, because I don't know your arguments, and I don't want to constrain you from saying, well, I don't know what you're going to say, but yeah. I can't read your minds, and the court will stay in its lane to ensure that it's in the proper judicial role. So the objection has been sustained to Mr. McBride. In regards to your response, the rebuttal to the argument by Mr. Novak, what is your request?
Yes, Your Honor. I do not believe it's necessary to close this hearing. I would argue against closing the hearing on the admissibility of this exhibit. However, the court needs to rule on that issue before I launch into the fullness of my argument, because I do not want to be admonished for discussing an item that I'm asking to be admitted into evidence in public. So I would ask the court to make a ruling on the closure of the argument about the admissibility of this hearing so that I can make that argument unconstrained. And after that time, after the court rules on that, I will make my full argument.
All right, well, what I'm trying to do is, you've heard the reasoning of the court. I don't want to constrain you. If you're saying, as you stated, that you want to best represent your client, and every attorney should be doing that, that is your duty. I don't want, if you feel that closing this hearing to the public is necessary in order for you to fulfill your duty, the court will entertain that. But I can't have it both ways. If you want me to close the hearing in order for you to be fully, be able to argue freely as you feel you need to, I will entertain that. But I don't want to say, well, I'm not going to close the hearing, and then suddenly the issue is, well, I wasn't able to make a full argument. And so do you need a closed hearing to make a full argument to best represent your client?
I think defense counsel is asking to close the hearing so that the argument can be made without the public seeing it. I do not want to close the hearing. I do not believe it's necessary to close the hearing. That's not my motion. I do, however, want to make a full argument that requires me to rely on the evidence and quote the evidence as I have done. That's my position. If I am not permitted to quote the evidence in my argument, then we need to decide whether or not this hearing should be closed. I would oppose closing it, but I do think it's necessary for me to quote the evidence.
All right. Are you able to make your full argument to the best of your ability to best represent your client by simply referring to the paragraphs and to the lines so it is clear to the court what you're talking about? There's no ambiguity without quoting it verbatim in open court.
No, I don't think so.
All right.
Your Honor, if you're going to make a closure ruling, I'd like to be heard before you do.
All right, I'll hear from you as well. If you would like to come forward, again, just, Mr. Reimer, just stating your full name for the record, for the clarity of the record.
Sure, thank you, Your Honor. David Ryman again for the news media. We have briefed this issue a couple different times so far. Sometimes there is a misconception that I think is running, particularly through what Mr. Novak argued, that suppression hearings, because the evidence may be suppressed or excluded, or in limine hearings, need to be closed unless the evidence is deemed admissible. That is the opposite of the law. That has been settled since the United States Supreme Court decided Waller versus Georgia. You can see it in Kern's Tribune, which dealt with a preliminary hearing and access to a preliminary hearing where, as you know, and as we've heard repeatedly today, all kinds of evidence is presented at the preliminary hearing that may not be admissible at trial. And so the universe of the public's right of access to proceedings is not limited just to what eventually gets admitted at trial, which, you know, if there even is a trial. And that's been, we've cited the court to, you know, numerous cases on this, and I don't have the brief in front of me, and the docket is huge, and I can find it for you if you'd like. But I just wanted to correct the misimpression that the public is not entitled to hear argument and to see evidence just because it may not be admissible. Otherwise, we would never have admissibility arguments in public. And I do want to I'll just make one other point. Kern's Tribune also speaks to this, and that is that if you do decide that there's and so let me just make two quick points. To the 403 point, just because evidence isn't admissible is not a basis to close the hearing. There may be a 403 argument. I haven't seen this document. I don't know what's in it. Maybe there is something incredibly prejudicial. You would have to make that decision. I'm at a loss. I haven't seen it. I'm happy to take a look at it and give you substantive argument, but it's the same high constitutional standard that you have to satisfy in order to close it. And then the last thing is just on the scope of any closure. Kearns Tribune speaks, and I know the court is aware of this. If you are going to close it, it needs to be as minimal as possible. And it's my experience, at least, that most of the argument about things in this context can occur in open court. And if you want to have, a closed session or a sidebar or however, you have also done it in chambers, I just ask that it be as limited as possible. Thank you.
Thank you. All right, Mr. Novak, and it appears like, would you like to respond to that before, and then I'll return to Mr. McBride for any final thoughts, and the court will make its ruling.
Well, I just wanted to mention the Utah Supreme Court decision in State versus Archuleta, 857 P. 2nd 234, where this state's Supreme Court reminds us that the First Amendment right of access is qualified, and that what needs to be carefully judged in light of the qualified right of access with respect to preliminary hearing exhibits. That was the issue in State versus Archuleta, is the defendant's right to a fair trial. So we're in this slightly twilight zone situation where counsel for the media is saying, even if the court has decided that the exhibits are not going to be made available for copying and inspection, and the court may decide that this exhibit is either not admissible or admissible for the court's eyes only, counsel for the media is counseling that the court permit Mr. McBride to read the exhibit verbatim in open court. And that basically defeats all of those principles. So I don't think that's the correct path. Counsel for the media is correct that the court's sealing or closure should be narrowly tailored. And the 403 issue, which we are prepared only to discuss because of the sequencing of things in this case, in this proceeding, we're only prepared to discuss at sidebar, has to do with potential future evidence that the court may receive in this hearing, or it may not. So I'm not going to address other 403 issues in open court. If the court wants to defer this entire exhibit and discussion of it until later in the proceeding, then it may be that part of the 403 argument doesn't need to be at sidebar. And I think we're all assuming that sidebar proceedings in this preliminary hearing are going to be part of the sealed transcript until some later point in time. In other words, it's not sidebar just for the moment. It's because the transcript's going to be sealed. So it very well may be that taking this issue up at a later point in time in this proceeding eliminates the need, from our perspective, for that 403 issue to be discussed at sidebar, or at what counsel for the media says in a closed proceeding. However, I agree with the court that Mr. McBride can't have his cake and eat it too. If he wants to make his argument and he thinks that his argument requires that he read an exhibit in court, which we in good faith are saying is not admissible, then we need to have a closed proceeding. I'm not asking for a closed proceeding. I was asking the court to caution Mr. McBride not to read into evidence exhibits that are not received into evidence, because that's the same as Mr. McBride testifying.
All right. Thank you. Anything further, Mr. McBride?
Just a note, I have not made my full argument on admissibility, that's all.
All right. All right, I appreciate the arguments by the parties. This is clearly something that's very important to you all and is important for this case, as is every piece of potential evidence. I note that Mr. Novak indicated that receiving this could create confusion for future potential jurors. And that he mentioned that it could suggest to a potential jury pool that this case is about religion. However, what is happening at a preliminary hearing is far different than what happens at a jury trial. The magistrate, myself, is the fact finder, and whether something becomes admissible at trial is far different than what is admissible at a preliminary hearing. The purposes are different, the standards are different, and different steps need to be followed. Something could become admissible at a jury trial, but given the nature of a jury trial, more steps are necessary. Under Rule 1102, one of the major differences is that reliable hearsay is allowed in a preliminary hearing under the Utah Constitution and under the Rules of Evidence 1102. That is far different than what would happen at a jury trial. Taking this into consideration, I look to the information going to the very beginning, whether this is relevant. And as noted by counsel, looking to count 1, which is squarely before the court, to determine probable cause at the end of this proceeding. And the court is not weighing in whether it will reach that or not. It's not predetermining anything. But what is before this court under count 1, aggravated murder, which is a capital offense, victim targeting enhancement, in violation of Utah Code Annotated 76-3-203.14 sub 2, Tyler James Robinson intentionally selected Charlie Kirk because of Tyler James Robinson's belief or perception regarding Charlie Kirk's political expression. And so, if that was not here, this enhancement, and it also goes to count 2, felony discharge of a firearm causing serious bodily injury. And I'm just reviewing. And then finally, count 7, violent offense committed in the presence of a child, where the victim targeting enhancement also is in play. Because that is part of the information that's squarely before the court, this becomes relevant. Now, trying to determine what is political expression versus religious expression, that goes into different grounds, but at this point, the court finds it is relevant for consideration, and for the very least for argument. What the court is going to rule is that now the need for a closed hearing is not been met at this point, because what needs to be shown is prejudice, or that the exhibit contains inflammatory information that would prejudice the jury pool. That begins the path where we can consider closing the hearing from the public. However, that's not what's before the court, nor has the court heard that. And so the ruling of the court is, previously I sustained Mr. Novak's objection, and the court will expound upon that Mr. McBride in his argument cannot read the entirety of State's Exhibit 5.1. Can he reference points of it and specifically quote certain points? The court rules that he can, just as Mr. Novak pulled from this, and it was broad, but he quoted Matthew chapter 19. He stated that this came from the Bible. He talked about the going from paragraph 1 where he quoted, or at least drew from, about the Internal Revenue Service and the type of business. And so there is grounds for that to occur in order for the court to consider the argument fully and making the determination whether it is relevant and should be admissible. Therefore, the court rules that Mr. McBride can continue in his arguments in order that the court can make its determination whether State's Exhibit 5.1 is admissible or not.
Thank you. 5.1 is a general explanation of what Turning Point USA, Charlie Kirk's organization, is and was on September 10th. The exhibit describes the events that Turning Point USA holds, talking about at least 200 plus of these events featuring Charlie Kirk as a headline speaker had taken place by that time. that's in paragraph 3, that these events discussed political issues as well as religious issues. Those political issues in the portion I previously quoted talked about gender issues in particular, gender, sexuality issues, the difference, or the Christian and political view regarding marriage and families and gender identity. And that information is relevant to the motive that we are alleging in this case. And it's also relevant to the victim targeting enhancement, which is in part a motive type enhancement. And the evidence will be introduced through, or we will offer evidence through other witnesses that talks about some of the defendant's statements that indicate his gender persuasion and that he falls into some of these political and gender views that Charlie Kirk argued against. That's the relevance of this statement, is it shows Charlie Kirk publicly in front of large gatherings of people debated and presented his views, his political views, which were tied to his religious views about gender identity, LGBTQ rights type issues. And the relevance to that is the defendant's motive is that he was on the other side of those views. And you'll see evidence that talks about that through other witnesses, that talks about that being the inference and the motive that he had, or the inference from that evidence supports that motive, which supports the victim targeting enhancement, and frankly, motive in general, which goes to identity. For that reason, Your Honor, this exhibit is relevant. I don't see the prejudicial effect, unfair prejudicial effect this would have on the fact finder. Whether or not it has, some capability of prejudicing the potential jury pool, I think that's a completely different question. I don't think it does. I think this case has already highlighted the political issues that we're talking about here, but my job here is to present this case to the court, to you, Your Honor, for you to make a decision. This evidence is admissible for that purpose. Whether or not it's public or published for the public to see is a different question, which I'll submit. The media is very capably represented, and I'll let them make the argument on that point. But I would ask the court to admit this exhibit.
Mr. Novak.
Thank you, Your Honor. For the state to argue that this exhibit says anything about Mr. Robinson's state of mind should be rejected out of hand. This exhibit does not say anything about Mr. Robinson's state of mind, and that's what motive is, and that's what the victim targeting enhancement adopted by the legislature focuses on, is the defendant's perception. If Mr. McBride wants to propose significant redactions to this exhibit so that Your Honor, acting as a magistrate, can consider things that are narrowly tailored to what the information alleges, which is the allegation is that Mr. Robinson perceived that Mr. Kirk had certain political views, that's one thing. But this document talks, and now Mr. McBride, not to be colloquial, has sort of thrown down the gauntlet. This document talks about foreign affairs, political doctrines, America's founding principles, cultural trends, and what Mr. Engelhardt refers to as Orthodox Christian views on sexuality, marriage, and gender/sex. So this document goes way beyond what the state just flagged for the entire world is their view of Mr. Robinson's motive, which has something to do with gender identity, gender ideology, and sexuality. That's what Mr. McBride has just said this case is all about. This document goes way beyond that, and that's why it's not admissible. There may, as I said, be other evidence which Mr. McBride and the state want to rely upon, which they haven't presented yet, and Mr. McBride hinted at that. So I think that it's not admissible at this point in time. I don't think it's relevant in the sense of has a tendency to make a fact of consequence more or less true. That's the definition of relevance. So how does this court go from what the state has to establish, which is motive, or well, actually, the state doesn't have to establish motive. Motive is not an element of the offense. But at least with respect to the victim enhancement, according to the legislature, the question is, what is in Mr. Robinson's state of mind? The other thing I want to say is that Mr. McBride did not address the admissibility of these opinions. Now, the court talked about 1102, but 1102 doesn't resolve all of the other rules of evidence. It's just a gateway for an affidavit. So what we have in this document are what I think are purport to be untested expert opinions or at least lay opinions. And the question is, under the rules of evidence, is whether this document is helpful to the court when it makes a determination about whether Mr. Robinson perceived that Mr. Kirk had certain political views. So where is the evidence that Mr. Robinson, in this document, that Mr. Robinson was aware of Mr. Kirk's political views? Where is the evidence in this document that Mr. Robinson had disagreement with Mr. Kirk's political expression? None of that appears in this document. There may be other evidence of that we'll have to see. But there's nothing in this document which connects up with Mr. Robinson's state of mind, which is the question in the enhancement. And Mr. Engelhardt cannot, of course, express any opinion about Mr. Robinson's state of mind because he doesn't know him, and because that would be improper opinion evidence under any rule of law. So for a document to be received into evidence that quotes one very narrow piece of religious doctrine and that involves Mr. Engelhardt's interpretation of what that means. I mean, Mr. Engelhardt at the top of page 2 is basically telling this court what he thinks Chapter 19 means. How could that possibly be admissible in this proceeding? And how could it possibly be admissible for the purpose of this court concluding what Mr. Kirk thought Chapter 19 of Matthew means? So it's not relevant. It's improper opinion evidence. It's definitely overbroad in terms of the evidence that the state is proffering to prove a very narrow point, and it actually doesn't get to that point, which is what was Mr. Robinson's state of mind. It also doesn't say anything that Mr. Kirk specifically said on September 10th that Mr. Robinson may or may not have heard, or anything that Mr. Kirk said before September 10th, specifically, that Mr. Robinson may or may not have heard. Nor has the state presented any evidence, and as an officer of the court, I would say I don't think the state can present any evidence that Mr. Robinson specifically heard Mr. Kirk say a specific thing at a specific time. There are some statements, which I think that the state will say are admissions by Mr. Robinson, which reference Mr. Kirk, which we will get to later. But none of those reference specific statements by Mr. Robinson about specific statements by Mr. Kirk on any specific issue that would even make a piece of this relevant. So I'm pretty sure that I've reached that point where anything more I say, I'm going to be repeating myself, and so I'm just going to stop unless the court has questions.
I don't. Thank you. Well, I do have a question as it relates to political expressions. Does religion or gender intersect with political expressions?
I think that's a great question, but probably not a question to be answered by me in this proceeding. That's actually a really, really complicated question that the state wants the court to say is a simple yes.
Okay. All right.
Because I don't want to be the expert. I mean, the court's basically asking me to testify. I'm not trying to be flippant. The court is asking me to testify about where religion and politics intersect. And that's a fascinating question. The question here is whether this document, the way it's presented, the way it was written, is admissible under relevance and expert 701, 702 rules of evidence to prove what Mr. McBride says the state, what he acknowledges the state has to prove, which is that Mr. Robinson had a state of mind which was, let's just say, hostile to Mr. Kirk's political expression. And I don't think that this court should be deciding, based on the record before it, where, if at all, politics and religion intersect. I mean, if the court needs to resolve that issue, then the court also needs to resolve the question of which religious philosophy are we talking about?
Well, Mr. Novak, I bring that up because you mentioned it, and you said you cited directly to the enhancement. You said political expression, and then you went to the Bible itself. And so it appeared to the court that you put it into play. So I just wanted to get a little bit of guidance from your position. And so that's the reason for the question.
No, I totally appreciate the question. I'm not suggesting, Your Honor, that there's a problem with the question. Any question that the court asks is a question that counsel should take seriously. Sure. The legislature separates in the statute religion and political expression. The state selected the victim targeting enhancement based on political expression only. Now the state wants to I didn't bring Matthew in. The state is bringing Matthew in through Mr. Engelhardt.
Sure.
I didn't bring the Bible to this courtroom, the state brought it. And that concerns me greatly because the state is turning this into a question of whether Mr. Robinson's views, identity, life are anti-Christian. And that's a huge problem. And the state has created that problem. And this hearing is being broadcast to the entire jury pool. And that's what Mr. McBride just did, is he turned this case into whether Mr. Robinson's life is inconsistent with what Mr. Engelhardt calls Orthodox Christian views. I'm going to just stop right here because I think the court knows what the problem is.
Thank you. All right, anything further before the court makes its ruling? I appreciate the in-depth argument and the passion behind the argument. You are advocating for your clients, and I respect that.
Yeah, Your Honor, I'd just say it provides context for the defendant's state of mind.
All right.
That's all.
All right, in making this determination whether it's admissible or not, I'm going to start at the beginning, which is this. This is a preliminary hearing. The purpose is to determine whether the state has established probable cause to believe a crime was committed and that Mr. Robinson committed it. As it relates to this case, as I turn to relevance, I turn to the information as previously stated, and is this relevant, what is before me? And without indicating my decision on probable cause, because I am not at that point, I'm withholding all decision-making until all evidence is properly before me. And so in this ruling, it is not indicating either direction that the court is heading. However, the court finds that it is relevant as it relates to the victim targeting enhancement, as it relates to Charlie Kirk's political expression, and the court recognizes the argument made by defense in regards to state of mind. And it is because of both arguments that the court finds that the court is ruling that it is provisionally admitted into evidence. And at such point when it becomes relevant based off what Mr. Novak has talked about Mr. Robinson's state of mind about Mr. Kirk's political beliefs, then at that point, whether it is admitted or not into evidence will be decided upon. So as of right now, it is provisionally admitted. Because of that stance, it will not be published to the courtroom or media, but both parties can weigh in on that when this is brought up again and the request for it to be fully admitted is made by either party. Then the court will re-examine whether it should be published at that time to those in the courtroom and to whether that is displayed or filmed by the camera. All right, let us proceed. Well, let us proceed to lunch because it is now 12:40. It seems like a natural place to stop. I believe everyone looks like they need a lunch break. So let's go ahead and break for lunch. Let's come back at 1:15. Well, I need to give you a full lunch here. I need to do my lawyer math and see what that would bring us to. So it's 12:40. Let's come back at 1:45 for lunch. All right. Any party need the benefit of the record before we break for lunch?
Not from the state, Judge.
No, Your Honor.
All right. Court is in recess until 1:45.
All right.
Going to do that now.
Okay.
I need to know what those other things are.
I don't have lien.
So I'm going to adjourn it to July 1st, 2026, 9 a.m. If you get information before then that the court can look at, I don't have a problem looking at it, but I'm not going to sit here today and run and see what it really has.
May I approach and get the paperwork? Understood. Thank you.
Court calls the case, People versus.
I was auditioning for it.
For what?
New Tyler Perry movie,
And what is that?
Stranger Things, and also Stranger 7. I got the emails if you want to see them.
Oh, yeah, I would love to see the emails for this. And I'll deduct the remaining 90 if you actually are in the Tyler Perry series or someone series.
Don't sign this.
You don't have to sign it. Pass it here, please.
Your Honor, I don't want to anger you.
Oh, no. See, this is why you all shouldn't be checking the boxes because the box checked is the incorrect box to check.
I didn't check that box out.
Well, I checked it. It's different by each county.
No.
Judge Boyd, I am not
Yes.
making excuses for what I've done. I stand in front of the court asking to please have mercy on me.
Fine, you're coming back here because you're graduating and you want me up here at your graduation, which I will do. The court will grant the motion, revoke, sentence you to 2 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. Right, your attorney is here asking that a bond be set or that bond be reinstated. A judge's warrant was issued on November 18th, 2024 at 10:20 a.m. because the defendant did not appear. And defense, you have some information in regards to your client's non-appearance on that day?
Yeah, sure did. He had sent a package to the court indicating he was in a medical study, was going to pay him money. He needed to stay afloat financially. I spoke to Jason Garahan, said I sort of can excuse him from coming to court, but he made sure to verify where he's actually at. He was in a study group getting that money raised. He did miss that court date. As soon as he was out of the study, as ordered, he came to court and volunteered to turn himself right back into custody.
All right. And
I
I know
spoke to Jason. I didn't mean to cut you off.
No
I
problem.
apologize.
No problem. I know you had brought some documents with you the other day. Did you bring those today?
I showed him to Jason Garahan. Those are the documentation on all the days of action in the program. And let me see if I have a copy that was with me. I'll have to get them out of my, I did show them all to Jason Garahan as an officer of the court.
Yes.
I will tell the court I showed all the documentation to Jason. He was satisfied that swore he actually was, where he stated he was, showed his release date. And immediately after that, he came to this court voluntarily and turned himself in. Did you not?
All right. And you're stating that the bail bonds company wish to be placed back upon the bonds?
They have no problem being put back on the bond. And I spoke to Jason Garahan yesterday, said if they cowboy bail bonds were going to go back to the bond, he had no objection to it.
All right. And if you were to review, see if that's possible for a reinstatement of the bond, it's going to depend on the time when the warrant was issued, whether or not.
You know, we'll let the court at the time. James Ross won that program. He was down to his last pennies. He was just completely out of money. He really needed the money from that program.
All right. We'll restate the bond. I'll reinstate the bond. And then my understanding, all discovery had been received and there was a plea deadline date set. And on that date, he did not appear. So is there an agreement on this case or are you all requesting jury trial?
Right now, there's an offer on the table. I need to sit down and really discuss it with my client over the weekend. I think we can avoid a trial.
Did you understand you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams. Normally, the range of punishment for that is 2 to 20 years in prison and up to $10,000 fine. If the state proves the repeat offender enhancement allegation beyond a reasonable doubt to the court, then your range of punishment will be anywhere from 5 to 99 years or life in prison and up to $10,000 fine. Do you understand?
Yes.
All right. If you have a plea, all right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge, I just asked that you follow the plea agreement.
All right. Are you employed?
Not yet, Your Honor.
When's the last time you had employment?
Right before I was arrested on the 13th.
Doing what?
Modeling, acting.
I'm sorry, what?
Modeling, acting.
I understood also that he was participating in research studies as well. Is that right?
All right. You say modeling and acting. Where might I have seen you? And in what might I have seen you?
In catalog modeling.
All right. What catalogs?
JCPenney's.
JCPenney still has a catalog? What year would that have been?
23, 22.
All right. I'm going to look that up. What were you modeling in 23 in the catalog?
Here in San Antonio.
I had a client, Judge, who actually was a model as well. He was modeling, I think, JCPenney's Hager pants and such.
Was his name James Ross?
It was not, but.
So you say modeling and then you say acting?
Well, acting hadn't taken off yet. I just started the classes.
Oh, so you were in classes for acting? Because I will tell you, I watch a lot. So
They were.
I would have seen you if you say, name what you were in.
I was auditioning for it.
For what?
New Tyler Perry movie,
And what is that?
Stranger Things. And also Scream 7. I got the emails if you want to see them.
Oh, yeah, I would love to see the emails for this. Michelle, maybe we could be in a Tyler Perry movie. I knew there was something about him because his name is actually the name of J.R. Ewing's son in Dallas, James Ross Jr., J.R. Ewing.
Never watched the show.
Oh my gosh.
I work on that.
And you're in Texas? Okay.
I watched Knight Rider.
Knight Rider, but not Stingray. Well, the Knight Rider you watched, was it the new version?
Oh, no.
Or the old one?
With the Ha.
Oh, who used to be in Young and the Restless as Snapper Foster. But okay, enough about that. And he was also the second Snapper Foster, not the original one.
I was more of a General Hospital person myself, Judge.
Oh, wow. Huh. The Quartermains?
I don't remember because I was watched it with my aunt. So
Okay. He's like, what are they talking about?
Uh-oh.
All right. So here's my question for you. In the past, what have you used drug-wise?
Marijuana, codeine, promethazine.
Mm-hmm.
Marijuana, codeine, promethazine,
Okay.
Xanax.
That will mess up your face if you want to be an actor.
No,
You know,
I'm done with the drugs all the way.
all right. They say acting is for the young. And do you have any children? Age? When's the last time you saw your 2-year-old? Mhm. All right. This is what the court is going to do. Court is going to sentence you to 8 years in the prison, suspended and probated for 9 years, $2,000 fine that will be probated, restitution to SAPD for laboratory testing. There's to be 200 hours of community service restitution. 100 hours will be deducted. For parenting classes, I'm going to order parenting classes. And I tell you what, this is some incentive to improve acting skills. You may be acting right now, which is great acting. If you provide proof that you were actually in the JCPenney catalog in 2023, not 22, but 2023, I'll deduct 10 hours of community service restitution, and I'll deduct the remaining 90 if you actually are in the Tyler Perry series or someone series. Not as an extra, because those are just people in the background. You understand? If you have speaking lines, I'll weigh the remaining of the hours, and that will give you incentive to work on your acting skills. All right. Here's the thing. You're going to be tested on a regular basis. I can keep you in jail for the 2 weeks for the TAP evaluation, or I can let the TAP evaluation be out of custody.
But I know he wants to be out of custody, Judge, and that's part of the reason we were here is to address that. But we were able to resolve this case, and so I believe that he's motivated to be released. And so, if there's other conditions,
Here's the thing: your attorney is not going to be the one on probation; it's you. So we can do the TAP evaluation in custody or out of custody. But I'm telling you, if you end up testing positive for drugs while you're out of custody, they're going to bring to me a motion to revoke or tell me what's happening with you. Then you and I are going to have another conversation. And that conversation may or may not result in you doing a TAP evaluation in custody.
Out of custody.
All right. TAP evaluation out of custody, follow recommendations. There's to be 90 sober meetings in 90 days, proof of employment within 30 days, no employment as a home health care provider or with minors.
Understand, you said 90.
Sober meetings in 90 days. So every day you need to do a sober meeting for 90 days. Those are your AA meetings or NA meetings. You can either do AA meetings or NA meetings, but they're called sober support meetings now. If you go online, you can find one that is near you.
And to get a job too.
Yes. Anything else?
Yeah.
Or we can go off the record. I know I sentenced you to 9 months probation. I'm sorry, 9 years probation. You're like, yay, 9 months. If you complete everything early, you can always come back and ask for early termination. You understand? All right, and this court, to be successful, you need to stay in communication with your probation officer. If you have an issue, let them know. If you feel they're not addressing it, you can always come back to court and speak to me. You understand? All right, good luck to you. They'll go over your conditions with you. Thank you.
We should have condition number 2 on or about the first day of May 2025 in Bear County, Texas. The defendant, James Ross Jr., did then and there illegally use amphetamines and violence.
How do you plead to that? True or not true?
True, Your Honor.
Violation of condition number 2 on or about the first day of May 2025 in Bear County, Texas. The defendant, James Ross Jr., did then and there illegal use cocaine in violation of condition number 2.
How do you plead to that? True or not true?
True, Your Honor.
And then violation of condition number 4 in Bear County, Texas. The defendant, James Ross Jr., did then and there fail to report to the supervision officer as directed for the months of May and June 2025. Violation of condition number 4.
How do you plead to that?
Not true, Your Honor. To one of them.
All right,
I
not
did not.
true to which one?
I did not.
Well,
you know what?
And sentence you up to 8 years in the prison and up to $2,000 fine? Knowing that, do you still wish to plead true to violations 2 and 2?
That the court's only option.
No, I'm telling you what you're looking at. What you're looking at for any violation, it could be for littering. Any violation that is presented by pleading true, the court could sentence you to 8 years in the prison. Will I sentence you to 8 years in the prison? I don't know. I haven't heard anything with regards to that. But that is what you're looking at. And what I can tell you, whatever agreement you worked out with the state, if you have worked out an agreement, the court doesn't have to follow that agreement because this is a contract with the court. It's not a contract with your attorney. It's not a contract with the state. So by pleading true to 2 and 2, you are looking at a potentially 8 years in the prison and a $2,000 fine. Knowing that, do you still wish to plead true to violations of 2 and 2? That's either yes or no.
Yes.
Court will find, right, defense, what are you requesting?
We're asking for drug treatment, Your Honor. I mean, he's on probation. He tested positive for some substances. It was obviously consistent with use. We all make mistakes. We all have relapses. He was on probation for a drug offense. And he made note to me. He said, the judge told me when I pled that if I ever have problems, to contact the probation department, to let them know, to work with them. And that reflects well on me if I ever came back.
Did he do that?
I did.
Probation?
There would have to have a moment to on charge.
All right. Any objections to that witness being by Zoom at 1:30?
None.
All right. So, Ms. Abrams, if you'll let her know, we'll be back at 1:30, and if she can look through her files between now and then.
Ms. Dixon, how are you currently employed?
I'm employed as an adult probation officer.
Okay. And in your duties as an adult probation officer, were you assigned to supervise James Ross Jr. as part of your case?
Yes.
Okay. And while supervising him, are you aware of who read him his terms of probation?
Yes, me. Not hear from him until June 9th, 2025.
Okay. And regarding the conversation on June 9th, 2025, without getting into the specifics of it, were you made aware of a warrant for his arrest?
Yes.
Okay. And what did you instruct him to do when you spoke with him on June 9th, 2025?
Once I spoke with the detective and he verified that the warrant was active, I instructed him to turn himself in and handle the warrant to clear it.
Okay. And to your knowledge, was that done? Well, actually, let me rephrase the question. Did you speak with the defendant again on June 12th, 2025?
June 12th. No, I do not have record of that conversation, no.
Do you recall ever speaking with him again after June 9th, 2025?
After June 9th. I talked to the detective, I talked to him. I didn't document it, so no.
Okay. Now, regarding the reporting that was supposed to be monthly, was that to be in person?
Yes, we were to report, he was to meet here in this office once a month on a date that I gave him.
Okay. And so any communication that you had with him via telephone, that would not satisfy the requirement for him to report to you in person. Is that correct?
That's correct. Unless I told him something like, oh, this can count, or we could reschedule, or anything of that nature, but that was not done.
Okay. Now, were you made aware of any positive drug test regarding this defendant?
On May 1st, 2025, he did result positive for amphetamines and cocaine.
Okay. And so since you said the last time that you spoke with him in person was April 25th of 2025, between that date and the date that he tested positive and then the date that you spoke with him on June 9th of 2025, did the defendant ever report to you having a substance abuse issue which would require him to go inpatient or anything like that?
No.
Okay. Did he ever ask for any help specifically regarding substance abuse?
No.
Okay. And as far as the conditions that were in place for him, were you ever provided with any proof of completion of a parenting course?
Let me check. I'm checking right now. No, I was not given a certificate of completion.
Okay. And then regarding any community service hours, did the defendant provide any proof that he completed any of the 200 hours that were assessed?
No, no completion was submitted.
Okay.
I just wanted to get some clarification. You said there was a positive drug test on May 1st?
It was May 1st, yes.
And where does that drug test take place at?
He goes to either recovery downtown, or he can come here on Mondays and Thursdays here at Bandera location.
Could you please tell us where that May 1st test was taken at?
It tells me RMS, but I'm unaware if it's Bandera location or downtown. I just know that it's RMS.
And what does RMS stand for?
Recovery Medical Services or something like that. Yeah.
Is that the test provider?
Yes, that is. That's where they go and submit their drug test.
Okay. And so what you're saying is that your notes are inconclusive as to whether or not he came into your office in the month of May.
In the month of May, yes. I am unaware if he came here or downtown.
Okay. And when he comes to your office, I imagine he doesn't direct himself as to what to do when he arrives.
When he comes for a drug test, he's not to check in with me. He's only to check in with the drug test providers when they're here. So regardless, I wouldn't have known if he was here or not, because he does not check in with me when doing drug tests.
Okay. Were you available that day when he showed up?
I'm not sure if I was available or not. I wasn't, he didn't ask for me or anything. I probably was in a meeting.
Okay, fair enough. Now, my next question is, did you receive a call from him on June 1st?
June 1st. No.
Are you aware of the offense date of the alleged, I think it's new number 1 in the MTR allegations?
Let me check the MTR. I have it pulled up. The alleged date is June 1st, 2025.
You recall speaking to James Ross about that new number 1, the day that it happened? Did he call you or speak to someone at your office?
No, not on June 1st.
So my question to you is, do you document any and all communication with the client, or just those that you deem to be relevant?
All of them.
And it's your testimony that you did not speak with James Ross regarding his new number 1 allegation?
Not on June 1st.
When did you do that? When did you have that conversation, I should say?
On the 6th, the same day that I talked to the attorney about the case. It would be on the 6th, because that's the same day I talked to the detective,
So then you talked to James Ross on the 6th, and then you also talked to him again on the 9th, is what you testified to previously.
So I talked to I talked to him and the detective on the same day, not the 6th, on the 9th.
Thank you for clarifying. And what you're saying is between June 1st and June 9th, you had no contact with James Ross?
No.
Did James Ross send you any documentation from his most recent number one allegation that the state is alleged in the MTR?
No, the last email I received from James Ross was April 2nd, 2022.
Did he ever send?
I'm sorry, 2025.
No worries. So it's your testimony that he never sent you a Cash App receipt dealing with the new allegations that he was facing?
Judge, I'm going to object as to outside of the scope. We've waived that, and she's not like a fact witness or anything, so.
Well, in response, Judge, we're here trying to establish whether or not he stayed in contact with probation, and that's the only line of questioning I'm trying to pursue.
All right, the objection will be overruled.
Again, did you receive a receipt from James Ross regarding his new allegation that was, I believe, a Cash App receipt?
Okay, it shows here. Actually, I have an email. After the 2nd, I received the email on 6/17/2025. Payment, please call the probation. It was a payment from Bexar County. He submitted a payment towards his financial obligation on the 16th of 2025, and that was forwarded to me.
And what month was that again?
That was June 16th, 2025, and it was a payment of $34 towards his financial obligation.
Okay. So you spoke with him on the 9th, and then he made a payment on his probation fees and costs on the 16th?
On the 16th, yes.
And and you said that, and just to be clear, you said that the positive urine screen was May 1st?
May 1st, yes.
Thank you. No further questions.
Nothing further, Judge.
All right, is this witness excused?
Yes, Your Honor.
Subject to recall.
All right, does anyone have another witness?
Judge.
The defense would like to call Mr. Ross.
All right, could you rate, you're still under oath. All right, you may proceed.
Just one more. Mr. Ross, on the date of the new alleged number one against you, did you call the probation department or Miss Dixon that day that it happened?
I did.
Who was with you when you made that call?
Twanya Monday.
Who was Twanya Monday to you?
All right, first of all, for the record, if you could spell the first name.
TWONYA.
All right.
And what date do you recall speaking to Miss Dixon?
It was the date of the alleged robbery. I believe it to be the first.
The first of what month?
June.
Is that a 2025?
Yes.
When you called her, did you reach her directly or were you rerouted to her when you called a general number? How did that work?
I reached her directly. I called to the office.
Okay. When you spoke with her, did you identify yourself?
I did.
Did you communicate to her about your circumstances and what had just happened to you?
I did. Told her I was worried. Said I was going to get in some trouble with this woman who was not trying to pay me for the work I'd done.
Okay. Now, without getting into the facts and circumstances of the case, why did you feel compelled to call Miss Dixon on the date that this incident happened?
Because after me and my girlfriend left, I saw police shooting past us in the opposite direction from which we came. So I felt like she'd called the police.
Okay. And you wanted to, as a result, make sure that you talked to probation and let them know about this alleged incident.
Right, I did.
Now, after June 1st, when is the next time you spoke to Miss Dixon?
When the detective contacted me to come to an interview with him.
And what day was that?
I don't remember the exact date.
Was it the same week as the incident?
I believe it to be, yes.
She's testified, I believe, that it was June 9th. Would you dispute that date?
No, I wouldn't dispute it.
Okay, sounds familiar to you?
It does.
Okay, and as a term and condition of your probation, you know you're not supposed to have police contact, correct?
Right.
And the detective would qualify as police contact. Is that fair to say?
It is.
And as a result, you wouldn't contact the probation and let them know about that contact.
I did.
Now, on June 16th, Ms. Dixon has indicated you sent her an email. Do you recall doing that?
June 16th?
Or whatever day you recall sending an email.
I do. That sounds familiar because I sent the detective the same copy of the receipt from the Cash App transaction. And then I also sent it to my probation officer so someone else would have it besides just a detective.
And again, we're not getting to the facts and circumstances of the case. We're just talking about communication.
Right.
And that email was sent around the 16th of June, 2025?
Yes.
Okay. Now, there was also some mention that you paid a fee. You recall doing that?
I do. I was trying to stay current on my probation fees.
Did you contact anyone at probation before you made the payment or after?
Mr. Ross, you're here because you're on probation for possession of a controlled substance, PG 4 to 200 grams. Is that correct?
That's correct.
Okay. And so I want to take you back to May 20th of 2024 when you were placed under arrest for the offense that you're on probation for. Do you recall that day?
No.
Okay. And so that day you were traveling in a motor vehicle. Is that correct?
Yes, it was not mine.
Okay. But you were in the driver's seat, correct?
Correct.
Okay. And you were with another person on that day that was in the passenger seat, correct?
Correct.
Okay. And so the officer pulled you over for a defective headlight. Is that correct?
Allegedly.
Okay, well, you understand that this was stipulated to, correct? When you took the plea, you said it was true and correct. You remember that?
Well, Your Honor, I'm going to object at this point
Okay,
for the simple fact that if he pled no contest, the court simply establishes a record. There's a basis to prove the case beyond a reasonable doubt. That doesn't mean he's agreeing necessarily with everything in the report.
Well, Judge, and I can ask him about it because it's part of the stipulations in the court's record, and it's going to whether he's actually a user, as they're claiming, or whether he had other intentions with the Controlled Substances Act.
All right, the objection is overruled.
Okay.
Just really quick, I'm just trying to clarify so we understand. This line of questioning is about whether or not he's a user of drugs versus a seller of drugs, and he's on probation for using.
His estate waived the first count. So if I'm getting to blame my predicate as to what was found on him.
Okay, and he tested positive for drugs while on probation, which is used as well.
All right,
Users can.
the objection is overruled. The court will hear the question and the answer.
Okay. And so you understand that the officer stated that when he approached the vehicle that he smelled an odor of marijuana, right?
Understand that to be so.
Okay. And so when the officers searched your person, in your pocket, you were in possession of a scale. Is that correct?
Allegedly.
Okay, if that's in the stipulations, are you now disputing or contesting that?
I don't recall.
Okay.
That day it was lights blinded me in my face. I was snatched out the car and everything happened so fast. I really don't remember.
Okay. And then after that, you were in possession of 13 grams of methamphetamine. Is that correct?
That's not correct.
Well, I guess let me rephrase it. It was actually 17, but by the time it got to the lab, it was 13, correct?
Well, I'm going to object to that line of questioning because there's a field test and there's admitted labs through a state certified crime lab. Which one are we going off of? But there's a reason.
Well,
there's a state certified crime lab.
Is he going to answer truthfully or not?
Well, we're trying to figure out what the question is: the 17 grams or 13 grams. We're just going with whatever the
Objection
stipulation.
is overruled.
So how much methamphetamine were you in possession of?
I wasn't in possession of any
So then why are you on probation for possession?
because I didn't want to lose my apartment that I just got and I wanted to be free. So I signed for something.
Okay, so help me understand this then. You're here asking the court for help because you have a drug problem. Is that what you're asking the court for?
I wasn't aware that I was asking the court for anything.
So you understand that you were here on a motion to revoke probation. You were present earlier before the lunch break, correct? And you heard the state asking the court to revoke you for 8 years. Is that correct? Okay. And you don't want to go to prison for 8 years. Isn't that true?
That's correct.
Okay. So what are you asking the court to do then?
To understand, like, hoping not to get revoked.
On what basis?
You're charging me with, you're saying that I violated 2 things only out of the pen that you put on there saying that I was charged with this frivolous crime because I was panicked.
I'm very confused right now. So are you saying that on the date of the offense that you're on probation for, that you had been under the influence of a controlled substance, but you weren't possessing it? Is that what you're saying?
Yes.
Okay. Moving on. So you were smoking marijuana then?
I think we need to, just for clarification, Your Honor, the word possession has a lay meaning and a legal meaning. And I think maybe that clarification of where the question.
No, I mean, you can recross, or I should say redirect.
Okay, and so it's your testimony. I mean, are you disputing that Miss Dixon testified that the last time that she saw you, that she personally observed you in her office, was in April of 2025? Are you disputing that?
No.
Okay, so to be fair, you never made contact with Miss Dixon in person after April of 2025. Is that correct?
That's correct.
Okay, but it's your testimony that you had called and made contact with some different people at adult
No,
probation.
that's not my testimony.
Okay, well, explain to me. Go ahead.
I called Miss Dixon and tried to reschedule my appointment for the end of May, June. So I went in May and took a drug test to her office, but I didn't see her. So I made the payment and took the drug test.
So that's the drug test that came up positive, right? The one that was May 1st. Okay, and so you didn't report to Miss Dixon that day. You reported to the person that administered the urinalysis to you.
I actually did call her that day. And when I called her, I told her that, you know, I'm going to come take this test. I'm running late. So can I take it on the second half of the day? And I made it right before they left. So I was the very last person in there at like 5 o'clock. So when I showed up and they allowed me to take the test.
Okay. And then you heard Miss Dixon testify that on June 16th of 2025, you submitted a payment of $34 to probation, correct?
Right.
Okay, and you stated that that's because you wanted to stay current on your fees. Is that correct?
To show the court that I'm actually trying and I'm taking it serious.
Okay. And so $34 was the highest amount of payment that you could make at the time?
Because I wasn't employed.
So then how do you have money to test positive for cocaine and amphetamine?
I have money, excuse me, to test. It was $11.
No, to buy
I didn't
controlled
buy.
substances and invest them. How did you?
I just told you that a friend came and smoked with me.
So it's your testimony that your friend came to your home and bought methamphetamine and cocaine. Y'all smoked it.
I didn't know about there being any cocaine, but I smoked meth then.
You smoked meth.
So it could have been in it. I wasn't aware of it because I didn't snort no cocaine.
Okay, but you didn't financially compensate this person for the narcotics. Is that correct?
No.
Okay.
Didn't.
You understand that as a term of your probation, you're not to hang around with people that engage in drug use and have criminal records, correct? Okay.
No, it's not my intention to be there where I was under the stress of catching a whole aggravated robbery. That's the point.
But you didn't reach out to probation and tell them, hey, I'm feeling so stressed. I'm about to use. Can you please help me? You didn't do that, right?
I called and let them know I called that I was worried about a case.
Did you specifically going to ingest narcotics is the question.
No, but I went to.
Thank you. And then regarding Tanya Monday, you stated that's your girlfriend?
Yes.
Okay, and she was with you on June 1st of 2025, correct? When you went to the alteration shop, she was with you?
Yeah, she took me. She asked her to bring me back.
Okay. We have to witness, Your Honor.
Just for some clarification, and this is an important question. You're saying on May 1st, when you went in for your drug test, you did speak to Ms. Dixon?
Yes.
Okay. And you're sure of this because you were running late that day, and you ended up having to take your drug test later than usual.
Right. I was supposed to take the first half of the day because they come and they leave at 1:30 and then they come back second half until 4:30.
And if you miss your appointment or you don't reschedule, that's a violation. You understand that?
I do.
And so you weren't violated that day, were you?
I was not.
So someone had to have allowed you to take it in the second half of the day rather than the first half of the day. Is that fair to say?
Yeah, they're only there on Mondays and Thursdays.
My question is, the day that you came late, you had to have permission to do that. Is that correct?
Yes.
Because otherwise, if you had not taken that test, you would have been violated, correct?
Correct.
Okay, so somebody gave you that permission. Is that correct?
Correct.
And you're saying that somebody is Ms. Dixon.
She told me that I could come in and take it before they leave, but I must make it before they leave.
No further questions.
I don't have anything further, Your Honor.
All right. Are you asking to recall Ms. Dixon? All right. Thank you, Officer Dixon. Court will hear argument.
Judge, so I'm re-urging the court to grant the state's motion, revoke the defendant, and sentence him to 8 years in the prison because this is clearly a person that has no intention of being on probation or doing good on probation. Essentially, we've called Ms. Dixon here to just call her a liar and say that she doesn't document correctly and that what he is saying to the court is true, that he did reach out on all these days that are not documented. And then I take issue with the fact that he's not even taking responsibility for the case that he's on probation for. He stipulates that the stips are true and correct, and then he wants to come in here and say, I don't remember, it wasn't that much meth. It wasn't mine when it was found exactly where he was sitting. Like, notwithstanding all of the testimony that's come today, the fact remains the same that probation has not heard from him or Ms. Dixon herself when he's supposed to be reporting monthly. Ms. Dixon has not seen him since April 25th of 2025. And that's an important fact for the court to consider because what is the purpose of defendants reporting to their probation officer? And so their probation officer can offer them assistance. So their probation officer can see, are they under the influence of narcotics? Are they being tempted? Do they need help? And he can't even do something as simple as that. And so, Your Honor, we are asking that you revoke him and sentence him to the 8 years.
Your Honor, and the court is privy to its own record and also access to probation. He was never required to report in person. He was reporting by Zoom. And so this idea that him going in person versus not in person, the bigger question is, was he reporting? He has this missed report date in May. Now, I am just speaking, I guess maybe in, I don't want to say realistic, but just maybe everyday ways of doing business, right? You establish a relationship with someone, and as things happen or unfold, you document, or whatever the case may be. I do imagine that there are conversations that happen that are not documented. And that's okay to the extent that it's, I'm running late. Okay. And what I'm trying to draw out is that on this particular day, when he's supposed to test on May 1st, he's testified that I was supposed to be there in the morning. I was running late. I was allowed to come in the afternoon. The court is very well known. If you're running late for a test, that can be used against you. You can be denied a reason to test, and that can be a violation. So someone gave him permission to do that. He's saying my probation officer did that. So if he's having contact with her on May 1st and there's no documentation of that, I get it if it's just simply a call of, I'm running late. And that's fair. Those things happen, but that shouldn't be used against him to say he didn't have contact. I don't know if that amounts to a formal meeting, right? A formal sit down or a formal Zoom call. But I think the idea of what we're trying to portray to the court is that he is trying to stay in compliance with probation. He's showing up for the test, and he did have contact in May.
So here's my question. My understanding is that this witness was being called because he said that I told him if there were any issues to reach out to probation. And so maybe my assumption isn't correct, but I assumed that this witness was going to be called to testify whether or not he reached out to her saying, hey, I have a problem maintaining my sobriety. I thought that's what her testimony was about or is supposed to be about. So that's what I'm looking for from this witness.
Just to clarify that, Judge, I think something got lost in the translation there.
Mhm.
What we're communicating to the court, just for clarity, is that when he got in trouble on June 1st, he called his probation officer.
But I mean, if you, and correct me if I'm wrong, but if you are charged with a new offense, according to the conditions of probation, you're supposed to reach out to your probation officer and say, I'm picking up a new case. He has pled true, and what he pled true to was the use of drugs. And then my recollection, if I'm wrong, please correct me. I don't hold it against anybody for correcting me. Sometimes I can be wrong, but he pled true to violations 2 and 2. And then he said, Judge, you told me if I ever needed any help to reach out to probation, and that's what I did. So I'm waiting for this witness to testify about his reaching out to her that, hey, I'm having problems maintaining my sobriety. If I am wrong in what I thought this witness was being called for, somebody please correct me. But that was my understanding.
If I may.
Yes.
Your Honor, I wasn't having any problems until this alleged robbery took place. When this alleged robbery took place, that's when I reached out to my probation officer, because to that point, I hadn't had any problems at all.
But the alleged, and I'm not taking this robbery as true, right? But the positive UA that you've pled true to happened in May. The alleged new case is on or about June 1st, 2025. Is the alleged new case on or about in May as opposed to June?
No, it's June.
No, that drug test is not on the correct day. That drug test was taken before I had the interview with the detective. I wanted to hurry up and get that done because I knew that it was possible that this detective could put a warrant out for my arrest. And I knew that once that I went up there and went to report with my probation officer that if I got a warrant for my arrest, I'd be arrested. So as soon as this happened, I went up there to take that drug test. So that date, it must be in question, Your Honor.
So you're saying you didn't take a UA on May 1st, 2025?
I don't remember that date specifically. But I do remember running up there to take it because I asked my probation officer, or she instructed me to take the drug test several times, and I kept missing the appointment. And so this one I refused to miss. So I drove up there as fast as I could, got there right as they were closing. And
So you're saying they put the wrong date down. It didn't happen on May 1st.
so
Okay.
Judge, and if I could just address one thing, I specifically asked him the question if he ever reached out to probation regarding sobriety issues and letting them know that he was under so much stress that he was going to ingest narcotics, and the answer was no.
that is so, Your Honor. When I
think the inference from this is, Judge, I'm being looked at, I'm under stress, so I use some drugs. I reported and took my drug test. That's been documented. I spoke to my probation officer that day. I don't know if that amounts to a meeting or not. And in June, I also made contact, right? And also submitted to a test and made a payment. Those facts can't be disputed.
But here's the thing, for the court, it's not even, of course, you shouldn't be testing positive while you're on probation. But my understanding is that the whole reason for this witness testimony was not whether he reported on this day or that day. It was about whether or not he reached out to his probation officer to say, I'm under stress, I'm having trouble maintaining my sobriety, help me. Because he told me, and if I'm wrong, again, somebody correct me, we can have the court reporter read it back. He said, Judge, you told us we could reach out to probation for help. And I did that. And I haven't heard any evidence that he reached out to probation saying, hey, I need help. I'm about to use, or I'm struggling maintaining my sobriety.
And just to pick up on the court's point, I think the miscommunication comes because he has a different recollection of the timeline for the test. And what I'm trying to draw out is that when he got implicated in this new situation, he did call. That the timeline.
Did he call and say, I'm having trouble maintaining my sobriety?
He called and said, I'm being looked at.
No. Did he call and say, I'm having problems maintaining my sobriety?
He didn't handle the stress of that well. And he did use drugs, but he did show up for the test. Knowing that he was dirty, he still showed up.
But no, did he, because I'm trying to figure this out, because he said that he reached out to probation because I told him if he ever needed any help to reach out for probation. And that's what he told me after he pled true to violations 2 and 2. So my question, and if it's yes or if it's no, it's just something for me to consider. My question is, did he reach out to probation and say, somebody help me, I am having problems maintaining my sobriety? That's what I need to know.
I would say the judge, you're correct that he did not communicate that. I'm just simply saying the reasons for that is I think the timeline was misunderstood. He committed this new offense, which he did communicate. After that, he said he spiraled a little bit and started using drugs, but still showed up for his drug test, even though he knew he was dirty.
But isn't the drug test before the alleged new number one?
There was one before and one after. I think the second was around June 16th or something like that.
No, both of these positive UAs are on or about May 1st.
So those, I don't believe that they could be correct, Your Honor. And you are correct, Your Honor. I did not reach out for the purpose of help with sobriety at that point. When I found myself in trouble and I wanted to make record that this is what's going on, I needed some help. I didn't know who else to call about this situation that I was in. So I called my attorney. I called my probation officer and said, hey, I've been working for this lady. This thing is not seeming right. I feel like I'm about to get in trouble. I want to make record with you. Can you tell me what to do? And she did. That's the help that I called for initially. And I didn't make a call after that for help with the drugs.
And drugs are tough, Judge. They're highly addictive, and once you're on it, it's hard to get off.
I'm serious about my sobriety, Your Honor, and I've been going to AA classes and NA classes the whole time I was on probation, and the whole time since I've been here, I've still been participating in these classes on a weekly basis.
Okay. All right. Is there anything else from either side?
Nothing further.
All right. So the court is going to grant the motion. States you're asking for 8. How much time are you requesting?
It's a drug offense, Judge. We would ask for the minimum so he can get the help that he needs. I know TDC also provides some drug treatment programs. He's been participating in them in the jail since he's been arrested. And as he indicated, he was going to AA and NA while on probation. So I think he could benefit from some treatment. I believe that, again, a minimum sentence would allow him to get the treatment he needs in jail and come out and get on the right foot.
All right. If you'll go over the trial court certification with him, please.
This is not a plea bargain case.
No, you all just have to fill out. I'll make the decision on. No,
And don't sign this.
you don't have to sign it. Pass it here, please.
Your Honor, I don't want to anger you. I've been.
Oh no, here's the thing. I'm not angry. I don't get angry.
I mean, not anger, but I want to cooperate with you, Your Honor.
No, you don't have to sign it if you don't want to sign it. What I can tell you, that document tells you whether or not you have a right to appeal. And I'm the person who makes the decision on whether or not you have a right to appeal. And so once you sign that, I will let you know.
He's put his mark on there.
All right, thank you. So this is what the court is going to do. See, this is why you all shouldn't be checking the boxes, because the box checked is the incorrect box to check.
I didn't check that box, Your Honor.
Oh, I checked it. It's different by each county.
No, that's the incorrect box to check. So to attorneys going forth, the trial court certification of defendant's rights to appeal, you don't get to decide whether or not your client has a right to appeal. That's the court. So the court should be checking boxes, and you all sometimes check wrong boxes. All right, this is what the court is going to do. Court is finding violations 2 and 2 true. The court is going to grant the motion to revoke. The court is going to sentence you to 4 years in the prison, give you credit for any time served. The therapeutic community, there's to be no contact with Mark Daniel Lewis. There's a $2,000 fine. There's to be no residing in households with minors and no unsupervised contact with minors. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yeah.
All right, good luck to you, Mr. Ross.
Yeah, that's the question.
Sure.
So, been sentenced to 4 years CDC,
Yes.
and what about the aggravated robbery charge?
Need an expedited trial date.
All right, that's still pending. And just one moment with regards to that. Counsel, have you received discovery in that case?
I would need to check with my investigator and make sure we have it all.
All right, let me just look and see what the cause number is for that. All right, so it's set for December 9th. So we'll see you back on December 9th. All right, defense?
Thank you, Judge. I'll call Ms. Ayala as a witness. Ma'am, please state your full name for the judge.
Adriana Ayala.
All right. Now, since we last had our court hearing, is it true that you expressed to me that you wanted to use this whole incident and criminal issue to better your life?
Yes, sir. I already have.
All right. What have you done since you were released about a month ago?
Okay, I'm going to get my folder real quick. Give me a second. Judge Boyd, I am not making excuses for what I've done. I stand in front of the court asking to please have mercy on me and please allow me to accept probation as my option. My case today has to do with an assault, and I voluntarily have joined an anger management class to help me teach me how to improve my temper. In the meantime, I am also staying busy by working 2 jobs. My first job, I'm a full-time chef. My second job, I help manage a small rental property where I live. I brought 2 employment letters to support my character and my well-being at both jobs. Please give me a chance to not to return to prison. I know I can successfully complete my probation if given a chance. All of this has been done within 30 days of my release. I'm staying positive. I'm staying away from certain people. I've made better choices. I'm scared. It's a wake-up call. I don't want to return to prison. I'm 44, and I think it's about time for some change, and I feel like I'm making change. I'm also going to AA classes. I know it's not none of the requirements, but I did this voluntarily because I need it. I recently drank, not before this, but I have recently had a problem, and then I stopped and I pick up and stop. And, I know I can't do this alone. So I did the class for me, not because it was required from you, but because there's certain things that I know that, lead to other things. So that had also something to do with my temper and my anger. So it's helping me take care of a lot of things. And I found a support group. I also have a sponsor. Again, I did all of this on my own, and it makes me feel like I'm not alone. I know there's strangers in my class, but it's a support group, and I feel very welcomed. I've actually attended maybe like 13 or 14 classes within the last 30 days. And in that program, it's also parenting, because my children are grown, but I also have grandchildren. So I'm learning how to become a grandmother. And it's a really good support group because it's anger management, AA, and parenting. And I feel like I belong somewhere and I'm not alone. So I know I can successfully complete my probation, successfully. And I want a second chance, please.
Ms. Ayala, I have another question for you. This incident involved a victim named Caesar, correct?
Yes.
Now, do you have any problem staying away from Caesar during your probation?
No, sir, I do not.
All right. That's all I have, Judge.
Okay. Ms. Ayala, if you're drug tested today, what are the results going to be?
None. Good. I'm good.
All right. When's the last time you used any substance?
A few months ago. Before this, way a few months ago.
All right. What's the cause of your anger issues? Do you know?
I don't know. Frustration. I don't know.
But I mean, what are you frustrated about? Because I've read the PSI report. I read everything that comes before me, right?
Yes.
So what are your issues?
I don't know, stress. I was a single parent for a long time, and I've been abused.
I mean, your priors have to do with
Child.
anger. Your priors have to do with anger issues too. And I will tell you, you're very lucky that the complainant in your case says that he doesn't want you to go to prison. He said that that would be too harsh. But this is what people have to understand. The way that women come before the court and say that they've been abused, men can be abused as well. So no adult should be putting their hands on anyone in anger. You understand?
Yes, ma'am.
So it doesn't matter if you're female, if you're male, you shouldn't use words, not hands, right?
Yes, ma'am.
All right, this is what the court is going to do. As previously stated, the court found you guilty. The court will sentence you to 2 years in prison, suspended and probated for 2 years. Ayala, what is the tattoo on your arm?
This.
Yes.
It's a Dia de las Muertes.
Oh, okay. Was it painful?
No, ma'am.
Wow, I'm always interested in the tattoos that people have. And sometimes they tell me it's very painful, but they continue. So you're the first person that I've spoken to who said it wasn't painful. But then I think women may have a higher threshold for pain than men. I don't know. I guess we could take a poll of that. Are you the same Adriana Ayala who's placed on community supervision for the offense of assault, family second offense on October 11, 2021 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state. How do you plead to that? True or not true? Any objections to the waiver?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, sentence you up to 2 years in prison? Did you understand that? Okay, you're whispering.
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am, I do.
Court will find violation of condition number 1 true. Is there an agreement? Is that the agreement?
It is, Your Honor.
All right, are you asking the court to follow that agreement?
Yes, ma'am, I am.
Are you waiving your right to appeal?
Yes, ma'am, I am.
Do you want Esperanza Court?
Yes, ma'am, I do.
All right. All right. Do you have any children?
I do.
And what are their ages?
28 and 22.
Okay. So who are you going to be staying with? Do you live by yourself? Do you live with someone else?
If I come out within a reasonable time, I still have my home waiting for me and my job waiting for me as well.
All right. So I'm going to deny and alter and amend to Esperanza Court. All right. So she's going to remain in custody and they will meet with you and screen you. Okay.
Yes, ma'am.
If you're accepted into Esperanza Court, what will end up happening is case will actually be transferred to Esperanza Court. The only time you will come back here is for one of 2 reasons. 1, you're coming back here because you're graduating and you want me to appear at your graduation, which I will do. Or 2, because you didn't follow through and they're saying that they can't help you and you don't want the help and they're removing you from the program. Okay.
Yes, ma'am.
All right. So she's to remain in custody and probation. If for any reason she's not accepted into Esperanza Court, let me know and we'll take that up. Is there anything else?
No, right, sir.
All right. Thank you. Have a good one. Are you the same Adriana Ayala who was placed on community supervision in 2020 CR 10020 for the offense of assault, family second offense on October 11, 2021 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state, you may proceed.
Thank you, Your Honor. Violation condition number 41. On or about the 30th day of May.
Excuse me, I don't have a violation of 41. Is that a supplemental?
No.
Thank you, Ms. Abrams. Oh, I have the incorrect one.
Oh,
All right, you may proceed.
yes, Your Honor. Violation condition number 41. On or about the 30th day of May, 2024 in Bexar County, Texas, the defendant, Adriana Ayala, did then and there fail to comply with the rules and regulations of the Esperanza Court and that the defendant absconded from the women's sober homes in violation of condition number 41.
How do you plead to that, true or not true?
State will waive the other violation, Your Honor.
Any objections to the waivers? Did you understand by pleading true to violation of condition 41, the court could find it true, grant the motion and sentence you up to 2 years in the prison?
So he's supposed to be against me. She's supposed to be for me. Why did you just give him some paperwork to be against me? If he didn't have the paperwork, shouldn't it be thrown out? Was it not complete? Was his record not complete? I just pointed something out to him on his paperwork. Because his paperwork was in your hand, because that was in his hand. No, I didn't get anything. I thought he was doing it now. Because he didn't have it earlier.
All right, so this is what the state is accusing you of. They're accusing you of not following the requirements of Esperanza Court. Do you understand that? All right, you just pled true to that allegation, which is number 41. Do you understand that? And do you understand that the state is not proceeding on any other violations in the motion to revoke? They're only proceeding on violation of 41. Do you understand?
Yes, I am.
All right, so do you still wish to plead true to violation of condition number 41?
I do, yes, ma'am.
All right, by pleading true to violation of condition number 41, the court could sentence you up to 2 years in the prison. Do you understand?
Yes, ma'am, I do.
All right, the court is going to find violation of condition number 41 true. Is there a proposed agreement?
There is, Your Honor. That is to revoke the defendant's community supervision and sentence the defendants to 2 years TDC.
That is the agreement, Judge.
All right, the court will sentence you, the court will grant the motion, revoke, sentence you to 2 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. Did she pay the $100 to the approved Family Violence Center? Raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Correct.
All right, you can lower your hand, state your name for the record.
Adriana Ayala.
Yes, did you pay the $100 to the approved Family Violence Center?
I don't remember. I did pay my $1,000
For the court?
Yes, ma'am. But I don't know what else was included. So my dollars. But he said I didn't know. Mr. Patrick said and Thorpe said I didn't know any fines. So I'm thinking that might have been included.
Okay, let me ask.
But I'm not.
If I may, Your Honor, the court summary reflects that she did pay the $100.
All right, thank you.
Thank you.
All right. So the court then, as previously stated, will give you credit for any time served. There's a affirmative finding of family violence. There's to be no unsupervised contact with minors, and the court will request the therapeutic community. Did you agree to that sentence?
Yes,
Are you waiving your right to appeal?
Yes, I am. You know that.
Yes, there was something you want to say?
I have an idea of how much credit time served I have. Do you have an idea of how much credit time served I have?
I can.
They will be able to tell. No. They'll be able to tell your attorney. The clerk will be able to tell your attorney how much time you actually have in. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
I did.
All right, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak with an attorney. Do you understand?
Yes, ma'am, I do.
And I'm sorry, also, as previously ordered in the agreement for probation, there's to be no contact with Cesar Rodriguez.
Okay, thank you.
All right, good luck to you.
Thank you. And Judge, just for the record, I did let Ms. Ayala know that she does have credit for 578 days.
Okay. All right, thank you. See, I don't understand what people don't understand. When you're in a relationship and you break up, even if you have children, that person can date whomever they want to date. If you think that person is not an appropriate person, that's what the court systems are for.
Give consent for him to take a picture of me or to send it to anybody, which he sent it to at least a minimum of 8 people.
It's not for you to go in breaking windows, injuring yourself. So he sent a photo of himself on the couch with her to the new boyfriend. Is that what I'm to understand? Well, protective orders in place. You know, this person is a narcissist and a manipulator, and you still won't let them go even though they've broken up with you. Explain that to me.
He told me that if I didn't do what she said, he was gonna kill both of my grandmas and leave me alive to suffer.
What the court doesn't understand is I know on the document sheet, which I wrote, I said, no contact with Savannah Hernandez. And I know when I place people on probation and there's no contact, I always tell them that relationship is over. What part did your client not understand when I said that relationship is over? That's what I don't understand, because I tell people your relationship is over. Get an orchid because you're not ready for a relationship. So I'm trying to figure out what part of my order that he was not to have contact with her did he not understand?
I think the part he did not understand, Judge, is when she invites him to her house, when she says she's not ready to get a divorce, when she responds to communications that is not an exception to the orders of the court. And the reason we're set for contested hearing today, the reason we reset this matter a couple of times, is me going through all of the history and explaining all that to him, that none of that is a legal significance to this court. And thus his decision that I'm going to plead truth, because I get it.
Well, somebody probably, if there should be a witness that's called before the court so that I can discover why there is being contact when I order no contact. And the court would like to know if both, if the complainant, and I don't have any jurisdiction over the complainant, but I would like to know if the complainant was okay with this defendant violating this court's orders by, you said, being in the car with him, trying to make their marriage work. I would like to know this before I make my ruling.
I certainly can't speak for her, Judge. All I can tell you.
Well, someone needs to call a witness so I can make an informed decision.
I would be happy to do that, Judge.
She's here,
All right.
so she can testify.
Yeah, I would like to know what's going on and why the court's orders are not being followed and why adults can't understand what I mean when I say a relationship is over and there should be no contact.
I apologize that I might lose my composure. The entire marriage was him making the decisions and me submitting to everything and anything that he said. So the meeting may have been okay. Let's go sign the divorce papers so we can get this over. But when I asked him to leave, he wouldn't leave. And almost every encounter was just for his gratification.
Did you, after he was placed on probation, did you intend or did you wish to have further communications with him?
No.
And were there times or periods of time where he would repeatedly call you?
Yes.
And just by example, how many times in a row would he call you and you wouldn't answer?
A minimum of 30 if I was at work or driving.
And would he continue to call you until you answered the phone?
Yes.
And again, this is all after he was placed on probation in this court.
Correct.
And the contacts that you had with him, whether that be via text message, social media, in person, or by phone, did you feel that you had a choice in whether you had to communicate with him or not?
No.
And why is that?
Because even if I said no, he was still going to come. His threats to me were real.
I'll pass it.
Defense.
Ms. Jimenez, you're aware that the allegation is that he made contact on February the 9th of this year. Is that correct?
Yes.
Isn't it true that what caused that to come to light was that he had a picture of himself sitting in your living room in your apartment?
I did not see any picture.
Okay. And he sent that picture to a person that you were in a relationship with, and that's what caused the fuss. Is that fair or no?
No.
So you had to have reported the violation, or we wouldn't know about it, correct?
Correct.
Okay. So on February the 8th this year was Mr. Hernandez sitting in your living room, and he has a picture of the two of you sitting in your living room.
The picture I did not know was taken. I did not give consent for him to take a picture of me or to send it to anybody, which he sent it to at least a minimum of 8 people. And it was because he had already finished his gratification. And he was sitting there, and I had asked him to leave repeatedly, and he wouldn't. I have to threaten him every time with calling the cops. I did not want him to go to jail, but he doesn't comprehend it. That's the only thing that I can think of. And his mindset is I was just property. And I'm not going to.
Now, Ms. Jimenez, we're talking about your apartment, correct?
Yes.
So he can only get in there if you let him in, correct?
Yes. Every time he came, it was just banging until he came. And the only time that he did leave was when I called the cops, because he saw me calling 911 and I was standing in front of the window when he left.
But we don't have a police report from this incident you claim occurred.
That happened on the same day.
So you're saying that you can't, while he's locked out and can't get inside the apartment, you can't call the police and have them remove him?
I did. That's why he left. That's the only time that he left.
Now, in reference to the text messages, we've shared with the state, and the state shared with you printouts of text messages, very many text messages.
Court is now in session, noting the presence of all counsel and all parties. All right, Mr. McBride, turning to the state.
Yes, Your Honor. Just by way of preview, we are going to call Jen Falmuina, Sergeant with the SBI, but how we're going to proceed is we're going to call her for a very limited purpose. We're going to pause her testimony. Defense is not going to cross at that time, and we're going to call an FBI DNA analyst out of order. It's a defense witness, but that's to accommodate that witness's schedule. State calls Sergeant Jen Falmuina.
I'd like to come forward and be sworn in.
Do you solemnly swear that the testimony you are about to give now before the court will be the truth and the whole truth and nothing but the truth, so help you God? Yes.
All right. After you're situated, there should be a bottle of water to your left, maybe behind the monitor. And if you wouldn't mind just bringing that microphone just a little bit closer to you so it picks up your voice for the recording. Mr. McBride, your witness.
Will you please state your name?
Yes, Jennifer Famuina.
Where do you work?
I work for the Utah Department of Public Safety.
What position do you hold there?
I am currently a sergeant within the State Bureau of Investigation.
What was your assignment September 10th, 2025?
I was assigned to oversee the crime scenes as well as the physical evidence.
And were you sergeant with the State Bureau of Investigation at that time as well?
Yes.
And do you have any kind of specialty in your assignment there?
Yes, I do. I am currently overseeing, or I am the lead over our evidence response team within our division. That includes not only conducting training, but also attending training and whatnot.
Okay. So if we hear ERT, it means evidence response team?
Yes.
Were you called to the crime scene at Utah Valley University on September 10th of 2025?
Yes, I was.
And were there multiple scenes that you oversaw or helped to process?
Yes.
We've had some testimony about the rooftop of the Low C Center. Did you oversee or are you aware of evidence that was collected in that area?
Yes, I am.
Was there a screwdriver that was collected from that rooftop?
Yes.
And do you know how that was collected and what happened to that screwdriver?
Yes, that was collected by the Utah Bureau of Forensic Services Crime Scene Response Team, or also known as our State Crime Lab.
And do you know what happened to that?
Yes, it was packaged, and then that evening there was discussion on who would take custody of the evidence, and I was there along with FBI. Then it was decided that FBI would take custody.
And did that evidence actually go to the FBI?
Yes, it did.
And was it sent for testing?
Yes, it was.
Where was it sent, do you know?
It was sent back to their, I guess, their equivalent of our crime lab.
Okay. Are there other areas there at Utah Valley University that were also processed for the presence of evidence?
Yes, there was.
Is there a wooded area that's northeast of campus?
Yes.
What was found in that wooded area?
What was found there was a long gun that was wrapped in a dark colored towel.
And you say a long gun. What does that mean, a long gun?
Sorry, that would be a rifle. So for to be more specific, it was a Mauser 98 rifle.
Do you know what caliber that was?
It was retrofitted to a 30-06 barrel.
And do you know what kind of action that had? Was that a semi-automatic, automatic, bolt action?
It was a bolt action.
What is a bolt action rifle?
I'm not too familiar with guns, but I just know there's a bolt and you have to pull it back.
Okay. And what was done with that weapon and that towel?
That was documented in place, and then eventually pictures were taken. It was documented in place, and then afterwards we rendered that gun safe, and then packaged the gun as well as the towel.
What was done with the towel after it was packaged?
The towel was also provided to the FBI.
And those two items. Well, let me tie up that thread. The gun, what was done with the gun?
The gun was packaged. It was taken to FBI custody, then eventually it was provided to the ATF lab.
Okay, so the gun went to the ATF lab. Is that correct?
Yes.
The towel went to the FBI lab.
Yes.
And the screwdriver went to the FBI lab.
Yes.
Did you receive reports back from testing that had been done on those items?
Yes, I did.
I'd like to show you State's Exhibit 31. I think that's connected to the defense computer right now. Is there any way to switch it? Thank you. Okay, I'm showing you here on the screen State's Exhibit 31. Do you recognize that?
Yes, I do.
What is that?
This is the FBI report that was provided to me by the FBI that documents DNA testing.
And does that include testing that was done on the screwdriver that we've spoken about and the towel that we have spoken about?
Yes, it does.
Okay, what I'd like you to do, Kimberly, if you'd please just scroll down so that Sergeant Falmuina can observe this exhibit. If I can have just a moment. And can you see who that report is signed by?
Yes.
Who's that?
Amanda Baker, I'm assuming is how you pronounce your last name.
Is that, in fact, the report that you received documenting the testing results on these items and some other items from the FBI?
Sorry, yes.
And does it appear to be in an accurate condition as to how you received it?
Yes.
I'd move the admission of State's Exhibit 31.
Defense?
No additional objections.
All right, so I'll note the standing objection, and as it relates to admission, what is your request as to publication?
I'd move this admission and its publication both to the court and to the public.
All right. Anything further, Mr. Burke?
No.
All right. The court will admit State's Exhibit 31 into evidence and allow publication of this exhibit to the gallery and to the monitor on screen in the courtroom and for the camera to broadcast.
Okay, if you'll go to, Kimberly, if you'll scroll down to, still on page 1, where the screen will show items 7 and 8. Sergeant Falmuina, do you see the lines there that say item 7, that line?
Yes.
And will you read that portion of the report that describes what item 7 is?
Item 7, towel from around Mauser rifle, serial number 8863.
And there's also some other identification numbers. Is that the towel that you found with the rifle that day?
Yes, it
On
is.
September 10th?
Yes.
Item 8, will you read what that says is a description of item 8?
Item 8, screwdriver from perch.
And is that the screwdriver that you described that was collected from the rooftop?
Yes.
Okay. If we can go to page 3 of 6, please. Will you, item 7, sub 1, will you please read the result there from the title item 7 until the word contributors?
Really, I object to that. It's cumulative. We have the analysts here who can describe what the report is. Not sure it assists the court to be having her read from a report that's already in evidence.
And would you mind repeating that, but with the microphone? I want to make sure that the record picks up your objection. All right. Either way, if you want to come up, that's fine, Mr. Burke.
Judge, the objection is that her reading to the court what's in the report is cumulative, since we have the analysts here who will be testifying to what the report says and what it means. So you've got the report in evidence. We don't need this witness's reading the report to the court. So it's a 403 cumulative objection.
Mr. McBride, do you wish to respond?
My point is only to draw your attention, Your Honor, to the relevant results that will be discussed by the other expert, as well as the results of the items we've discussed, the towel and the screwdriver. That's all.
All right. The court will overrule the objection and allow a brief overview of it, not going line by line, page by page. So if it is brief, I'll allow that.
Thank you. So if you'll read item 7.1 to the word contributors at the top of that page, if you will.
Yes. Male DNA was obtained from item 7, sub 1. Item 7, sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 7, sub 1 are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Thank you. Let's skip down to item 8.1. Do you see that bolded and underlined line there?
Yes.
And this is relating to swabs of the handle area of the screwdriver. Is that right?
Yes.
Will you read those same two paragraphs there? Male DNA ending with contributors.
Male DNA was obtained from item 8, sub 1. Item 8, sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 8, sub 1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Okay, thank you. A couple of foundational questions before we finish for now. First off, do you know who Twiggs is?
Yes.
Who is Twiggs?
Twigs is Lance Twiggs. He was a roommate of Mr. Tyler Robinson.
And do you know if Lance Twiggs's DNA was obtained for comparison in this test?
Yes, it was.
And how was that DNA obtained?
It was obtained by law enforcement officers.
And was that by a buccal swab?
Yes.
What is a buccal swab?
A buccal swab is basically like a Q-tip or a swab that we'll just place in someone's mouth and just scrub the inside of their mouth to obtain the cells.
And then that Q-tip is then packaged and sent to the lab for testing and comparison?
Yes.
And was the defendant, Tyler Robinson's DNA, also collected in the same manner?
Yes, it was.
Okay. Thank you. Nothing else.
All right. Mr. Burt, cross-examination.
Your Honor, I'd like to reserve the right to cross-examine after the witness completes her testimony after the following.
Oh, would you mind grabbing the microphone? I just want to make sure what you say is on the record.
With the court's permission, I'd like to reserve the right to cross-examine on the area she testified about until she's completed her testimony.
Okay, okay, I see what you're saying. Any input, Mr. McBride?
Your Honor, that's what we expected to happen. We discussed this beforehand. We stipulate.
All right, that's fine. And so should I have the sergeant step down or?
Yes.
Okay. Sergeant, if you'd like to step down, you're still under oath, and so please don't discuss your testimony with anyone. And is she being asked to exit the courtroom, or what's the request of the party?
Yes, to exit the courtroom at this time.
All right, Agent, if you wouldn't mind exiting the courtroom, and then we'll come get you when we're ready for you. All right? Thank you. All right, Mr. Burt, turning to you.
Your Honor, out of order, the defense would be calling Amanda Baker.
All right, Ms. Baker. All right, Ms. Baker, if you wouldn't mind coming forward right up here by the bailiff and being sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, Ms. Baker, if you wouldn't mind being seated at the witness stand. Once you're situated, there should be a water bottle for you if you'd like behind the monitor. And after you're seated, if you wouldn't mind just pulling that microphone close to you so it picks up your voice, okay?
Okay.
Mr. Burt, your witness.
Your Honor, we're going to need the monitor switched over to our side if we could. While we're doing that, good afternoon.
Good afternoon.
Tell us your name, please.
Hi, good afternoon. My name is Amanda Baker. My last name is spelled B-A-K-K-E-R.
Ms. Baker, what do you do for a living?
I am a forensic examiner in the DNA casework unit of the FBI laboratory located in Quantico, Virginia.
And how long have you been a DNA analyst at that location?
A little more than 10 years.
And just in general, what are your duties?
My duties are to manage a case. When a case comes into DNA casework unit, I will review any information associated with that case. I will review any evidence that is submitted for that case, determine which items of evidence need to be tested and which tests need to be performed. I will then create something called an exam plan. You can think of this like a to-do list to let the biologist know which items I need tested. Once that testing is complete, I will review all the data, draw conclusions in the form of a report, and then testify if needed.
Ms. Baker, in this case, were you requested by the state of Utah to do certain testing?
Yes, I was.
And when were you called upon to do that testing?
That was September of 2025.
And do you recall when the case first came into your lab?
I believe we received evidence the first time was September 11th of 2025.
And just in general, when the FBI, your unit receives evidence for analysis, is it true that the turnaround time is about 200 days?
It depends. We've wavered between 90 days and over 200 days. I would say on average, it's somewhere between 180 and 200 days.
However, did this case come in on what's called a priority one level?
Yes, it did. And what that means is we worked 24 hours a day, 7 days a week until examinations were complete.
And is it true that you were conducting the analysis as the evidence was being inventoried?
That is true. Because of the high-profile nature of this case, an item of evidence would be submitted to the lab. It would be inventoried by our evidence management group and then sent to the various units for testing, for example, the DNA casework unit. We would begin testing as additional evidence was being delivered to the FBI lab.
Now, as a result of your analysis, do you produce case files?
Yes, I do.
And document your examination in other ways?
Yes.
Do you have your case file with you?
Yes, I do.
Okay. And in your case file, are there notes of conversations that you have with people that are relevant to your testing?
Yes, that's called our communication log.
Now, do you have your case file there in front of you?
Yes, I do.
I think the pages are numbered. So I'll ask you to go to page 22 of your case file notes.
Okay.
And if I could direct your attention to the bottom of that page, there is a communication log entry dated September 13th. Do you see what I'm referring to?
Yes, I do.
And would you read to the court what your entry is for that date?
Yes. This is my communication communication entry on September 13th, 2025. All. Spoke with FBI Special Agent Folger and Utah SBI SA Dave Hull. Gave technically reviewed results that Robinson was included as a possible contributor to the DNA from the towel and the screwdriver. We discussed the additional examinations conducted by DCU, and they both agreed that no additional immediate comparisons are needed at this time. All remaining comparisons will be in the laboratory report.
Is that an accurate reflection of what you told the agents at that time?
Yes, it is.
And you told them that, quote, Robinson was included as a possible contributor to the DNA from the towel and the screwdriver, correct?
Yes.
Was the language that you used in conformity with requirements that you have for reporting out test results?
Yes.
All right. I'd now like to direct your attention, if I could, to exhibit number, State's Exhibit 31, which is in evidence, and I think it's our tab 2. And that's in evidence, so if you could display that on the screen.
And Mr. Bird, are you requesting it to be displayed to just your screens or to all screens?
No, since it's in evidence, Your Honor, I'd like it displayed to the public.
Okay, let's go ahead and put it on the main monitor as well.
Okay, could you go to page 6, please? And highlight the third paragraph. This is your report dated September 15th, 2025, correct?
Yes, that is correct.
So this is 2 days after you had the conversation with the agents as to what your results were.
That is correct, yes.
And in your report that you wrote 2 days later, you included this language that's highlighted there, correct?
That is correct.
This report conforms to the Department of Justice uniform language for testimony and reports for forensic DNA examinations. Correct?
Yes.
Okay. Now, I'd like you, if you could, to take a look at that standard that you referenced. And then I believe is that, and this will be just to the witness, not to the public.
Okay.
Calling up tab 7. Do you see that on your screen?
Yes, I do.
Do you recognize this document?
Yes, I do.
And tell the court what this is.
This document is the approved standards for scientific testimony and reports for autosomal DNA testing.
And is this the document that you were referencing in your report?
One of them, yes.
And is it a true and accurate statement of what the policy of the FBI is in regard to reporting DNA in a case of this type?
Yes.
I move that document into evidence, Your Honor.
So is it just this page or all the pages? Because it says one of 6.
Yes, so this would be the entire document.
Mr. McBride?
Your Honor, I don't see the relevance of this document. I object on relevance grounds.
Mr. Burt?
Your Honor, the document is referenced in a report, and it defines the parameters of what her opinion means. So I think it's very important for the court to understand the limitations of the opinions being expressed.
And just for my understanding, when you say in her report, are you referring to State's Exhibit 31?
That's correct.
All right, Mr. McBride, any further thoughts?
No, I'll submit it.
All right, so State's Exhibit, well, I'm sorry, how am I labeling this exhibit for the defense?
Your Honor, we have our exhibits organized by witness, and we would be submitting to the court electronic copies of these under named witnesses. So this would be Baker 7.
All right, Defense Exhibit Baker 7 is admitted into evidence, and as it relates to publication, what is your request, Mr. Burt?
Your Honor, I would ask that this be published since the report is published, and this is important to understanding the limitations of the report.
And so published in the courtroom and on the monitor for the meeting?
Yes,
Okay.
correct.
Any thoughts, Mr. McBride?
No objection.
All right, it will be admitted and published both in the courtroom and on the monitor for the video camera.
Okay, so this document has various subjects, correct?
That is correct, yes.
And it, in the beginning, tells you how to frame your testimony in terms of inclusions or exclusions, mixtures, sex determination, et cetera.
Correct, yes.
And then there's a section called Statements Not Approved for FBI Autosomal DNA Testimony in Our Laboratory Reports.
That is correct, yes.
Okay, so if we could go to page 5 for that statement. Okay. Under the topic absolute identification, is it the policy of the FBI when you're reporting out results that an examiner may not state or imply that a match provides an absolute identification of the individual from whom the biological material originated?
That is correct.
And you were following that policy in this case when you told the investigators that this was a possible match, correct?
That is correct, yes.
You never said it was an absolute identification of Mr. Robinson, did you?
Correct, no, I did not.
Now, the second guidance under that policy is an examiner shall not use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony unless required to do so by a judge or applicable law. You're not, in your report, did not use any language that suggested you were giving an opinion to a reasonable degree of scientific certainty.
That is correct, it was not.
Okay. And then the next one, not that one, one more down. I'm not going to talk about race, ethnicity. That doesn't apply to this case, right? But 5.4 says, an examiner may not state or imply that forensic autosomal DNA examinations have a 0 error rate or are infallible.
That is correct.
And you followed that policy in this case, correct?
Yes, I did.
You're not in your report stating to the court that your testing has a 0 error rate correct?
Correct.
You're not saying that the test is infallible.
I am not, no.
What is the source of error rates in DNA testing?
I'm
You can
sorry.
take that down.
Can you clarify your question?
Yeah. When it refers to don't state that there is a zero error rate, what in general are the sources of error in DNA, in the kind of DNA testing that you do?
Human error could be an error.
Mhm. Anything else?
Not that I can think of off the top of my head. One of the big things is potential human error. I guess you could also associate the DNA testing itself and how items are collected or how those items are tested.
Now, to your knowledge, that policy statement that we just read in Exhibit 7, Baker 7, was based on a more general Department of Justice policy, correct?
Correct, yes.
And that policy is called the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examinations using probabilistic genotyping systems, correct?
That is correct, yes.
And could you display 8 for us, please, to the witness? Let me know when it's on. No, not on the big screen.
Okay, so not to go onto this main big
Correct,
screen.
this is
Thank
just
you.
for the witness. And you're familiar with that policy, correct?
Yes, I am.
Okay. And does it contain a statement that support for inclusion is an examiner's conclusion that there is evidentiary support for the inclusion of a known individual as a possible contributor to the DNA typing results obtained from an evidentiary sample?
I believe it does, yes.
And did you follow that procedure in this case?
Yes, I did.
All right. Does this same policy state at page 4 fourth down, one more. No, next one. An examiner, does the policy state, an examiner shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample?
That is correct, yes. It does state that.
And you followed that procedure in this case, did you not?
Yes, I did.
You're not implying that those numbers that a previous witness quoted and are stated in your report provides an absolute identification of Mr. Robinson or Mr. Twiggs?
No, I'm not.
Okay. Thank you. You can take that down. Are you also familiar with a concept called formal activity level?
Yes, I am.
Tell the court what that is.
Formal activity level is determining an activity that causes DNA to be left behind on an object.
And does your laboratory have a policy about whether you can express opinions about formal activity level?
We do have a policy, and I cannot give an opinion as far as activity level goes.
And why is that?
That is because DNA can be left behind on an object for numerous different reasons. So just because DNA is on an item doesn't necessarily mean that an individual touched it or utilized that item. So because of that, we do not opine on what activity may have occurred.
And consistent with that policy, you cannot tell, if you interpret a piece of DNA as being present on an item, you can't tell when that DNA was deposited, correct?
I can't give an exact time, but there are some situations, if a piece of evidence has been buried for a long time or is in a river for a long time, it would be my expectation, based on my experience, that I probably won't get DNA off of an item that's been buried for 10 years, for example. However, I cannot give exact timing as to when DNA was deposited on an item.
And I was talking more about a situation where you actually find DNA on an object, be it a gun or anything else. You can't say when that DNA was deposited, correct?
Sure, that's correct.
And how long, in general, does DNA persist on an item? Once you've made contact, how does DNA get deposited on an item in general?
In general, DNA can be deposited a few different ways, via body fluids such as saliva or blood, or skin cells. So touching an item or wearing an item, DNA could be deposited. Once DNA is on an item, if it's subjected to ideal conditions, it's out of heat and high UV, it's not subjected to any kind of cleaning or chemicals, it can persist on an item rather indefinitely. It can degrade slowly over time, but we've certainly worked items of evidence that are 40 and 50 years old, and we've been able to recover DNA.
Now, could you explain to the court the concept of degradation of DNA samples, what that means and what it suggests with your testing?
Sure. So degradation of DNA is breaking up the DNA. So if you think of DNA like a long rope, it's essentially taking that rope and cutting it up into pieces. Seeing degradation in a sample could lend me to believe that there may be, that sample may have been subjected to cleaning or high heat, an extended period of time. So I can't tell why an item is degraded, but looking at my data, I can tell if that sample is potentially degraded or broken down.
And two of the items that you examined were referred to as items 7 and 8, correct?
That is correct, yes.
One was a towel and one was a screwdriver.
That is correct, yes.
Were both those samples degraded to a certain extent?
May I refer to my
Certainly.
data? So item 8 was the screwdriver from the perch. I would say that there was some degradation. As I look at the DNA peaks or the DNA data, in an ideal world, if there's no degradation, I would expect all the peaks to be at the same height. Here I see a ski slope type effect, meaning that the data on the left is a little bit taller than the data on the right. As far as item 7, item 7 was the towel. There was a slight amount of degradation, but not as much as item 8.
Okay. And what is the effect of degradation on production of the allele? First of all, what's an allele?
An allele is an individual's DNA type. So we inherit half of our DNA from our mom and half of our DNA from our dad. We're looking at something called short tandem repeats, or STRs. These are small segments of DNA that repeat themselves over and over again. We all have those same sections of DNA, but what might differ amongst us is how many times it repeats, and that's actually what we inherit from our parents. So for example, at one particular location, my mom may give me 14 repeats and my dad may give me 15. So when I'm looking at the DNA types, I would say that I have 2 alleles at that location, a 14 and a 15. As far as degradation goes, it could cause some of those alleles to do something called drop out, meaning when I'm looking at the DNA chart or the DNA data, I do not see information, I do not obtain numbers at that particular section of DNA.
And is it true that in the testing that you were doing in this case, STR testing, what you were looking at is the length of the, what I'll call, have you ever heard the boxcar analogy?
I have, yes.
tell the court what that is.
So the boxcar analogy is how many times that section of DNA repeats. So that section is essentially letters. So for example, A, C, T, G. So you may have A, C, T, G repeated 10 times or 12 times. Each of those sections of H, C, T, G would be considered one boxcar.
And so when you're looking for alleles, you're essentially counting the boxcars. Could be 7 boxcars, and that person would be a 7.
That is correct, yes.
And from the mom and from the dad, he may have inherited 10 boxcars.
That is correct, yes.
And so that person at that particular location would be a 710.
Yes.
And what you're doing in your testing is comparing those numbers to what you get from a known sample to see if they match.
That is correct, yes.
Is that true?
Yes.
Now, is it true that what you mentioned the A, C, T, and G, correct?
Correct, yes.
Is it true that you are not measuring the sequence within the boxcars? You're just measuring the length of the boxcars?
That is correct. So the sequence would be equivalent to letters in a word. What I'm looking at is the number of words versus the letters that make up that word.
And we'll talk about this a little later, but people can vary not only in the length of the boxcars, but in the sequence within the boxcars, right?
And that is correct, yes.
And what your testing looks at is just the length?
Correct, yes.
Okay. Now, for the, and is it also true that you're looking across many different locations?
Yes. So at the FBI laboratory, we use a kit called Global Filer, and this is looking at 21 different locations on a human's DNA, in addition to 3 sex-determining locations. That lets me know if an individual is biologically a male or a female.
As between 2 individuals, 99% of their DNA is exactly the same, right?
That is correct, and that makes sense. We're all humans. We all have arms, legs, and a head. Less than 1% of our DNA is what differs amongst us, with the exception of identical twins.
But with the within that 1%, you're looking at these length differences, correct?
Correct, yes.
And you're looking at what you called short tandem repeats.
Yes.
How many, you said you looked at 25 locations?
We're looking at 21 and 3 sex type determining, so 24 total.
What are the sex determining? They're called the locus, correct?
Correct. So locus is that individual section of DNA.
All right, and they typically have names or numbers associated with them, correct?
Yes, they do.
So what are the sex determining loci?
So there is amylogenin, and that lets me know if an individual is male or female. And then there's 2 specific male sex-determining locations. One is Y-indel, and one is DYS 385. Those just let me know that those are specific to male individuals.
Okay, and then for the other locations you're looking at, those, you're just looking for 2 types at each location, correct?
Correct, yes.
Okay. Now, for the samples that you looked at, the 7A and the 8A, did you get a full, what's called a full profile would be a profile where you have all 23 locations present?
That is correct. So a full profile means I have DNA at every single location. It is above our threshold, and I'm seeing 1 or 2 pieces of information at each location. For item 7, I did develop a full profile.
For item 8, you developed a full profile?
Item 8 was a partial profile, so I did not develop DNA at every single location.
Okay, so what that means in your comparisons is you have certain information in the question sample that for whatever reason doesn't appear, correct?
Correct, yes.
So you can't make a comparison at those locations?
That is correct.
All right. What makes it not appear at certain locations?
So it could be that there's degradation. So those larger locations could be broken up so that it wasn't detected during the DNA process. It could be a low-level amount of cellular material to begin with. So if I only have a few cells, I may not have enough to detect at every single location.
Okay. And for the 8-1 sample, did you measure Mr. Robinson and Mr. Twiggs's DNA at the 23 locations?
For item 8, I did not have a full profile, so I did not have data at all 23 locations to compare to either Mr. Robinson or Mr. Twiggs.
Right, but you had full profiles for Mr. Twiggs and for Mr. Robinson, right?
For their known sample?
Yes.
Yes. So for their known sample, that was a sample that was taken directly from those individuals, and I did develop a full DNA profile.
Okay. And just to illustrate how this works, is one of the loci that you looked at called the DYS 391 loci?
Yes, it is.
And what type was Mr. Robinson at that loci?
At that location, Mr. Robinson was an 11.
And I think you said you inherit one from your mother, one from your father. But when you say he's an 11, technically he's what's called an 11-11, correct?
So for this, so DYS 391 is actually that male location, so he would not have, or anybody would not have inherited anything from their mother. So at this location, I would only expect to see one piece of information, and I did see an 11 here.
Okay. And for the D3S loci, what was his type?
His type was a 17.
Now for that loci, you'd expect two types, correct?
That is correct.
And when you say he's a 17, do you mean he's actually a 17-17?
That is correct. He inherited 17 repeats of that location from mom and 17 from dad.
Other locations, for instance, the VWA, he's type 18-19, correct?
That is correct, yes.
So you're looking at those, and what the machine produces are peaks, correct?
Correct, yes. They're just spikes on a graph, similar to like spikes on a heart monitor.
And you said for 8A, you had certain locations where the test sample didn't have any results.
That is correct.
So at the TPOX location, Mr. Robinson is a type 8-9, correct?
That is correct.
Mr. Twiggs is a type 8-11.
That is correct.
But when you looked at the sample, 8A, it didn't have any of those types.
That is correct. So I could not compare at that location.
Now, are there certain rules for when you exclude someone? In other words, when you're comparing two samples, are there rules which say, here's where I would conclude that he could not possibly have contributed this sample?
Yes.
Your field has a lot of literature written about it, correct?
That is correct, yes.
And do you generally like to keep up with that literature?
I do, yes.
And across time, there have been several books, publications that attempt to educate you and courts and lawyers on the technical aspects of DNA testing, right?
Correct, yes.
One of the books, the early one, DNA Technology and Forensic Science by the National Research Council.
I'm familiar with that, yes.
That's an authoritative book that was really one of the first books on DNA testing.
Yes.
All right. And then by the same organization, National Research Council, the Evaluation of Forensic DNA Evidence.
Correct, yes.
Published in 1996. So you're familiar with that as well.
Yes, I am.
And then there's an author, I believe, who did his research work at the FBI named Dr. John Butler.
Yes, I'm familiar with him.
And you have studied his work both in your training and your continuing education.
That is correct, yes.
And he's got 3 current textbooks on the topic that we're talking about, right?
I'm not familiar with how many textbooks he has. I know at least the one.
Fundamentals of Forensic DNA Typing.
Yes.
Familiar with that? Forensic DNA Typing Methodology.
Yes, I'm familiar with that one as well.
And Forensic DNA Typing Interpretation.
Yes.
Everybody in your field relies on these publications and use them as teaching tools.
Yes, I would agree with that.
And then in addition to those books, there have been studies that have been done on particular topics, correct?
Yes.
This case, we're dealing with mixtures, correct?
Yes.
And mixtures present certain challenges that are not present when the samples are not mixed, correct?
Not necessarily. So first, to define a mixture, that simply means DNA from more than one individual in a sample. So if I were to take a sip from a coffee cup and my husband were to also take a sip, if I were to swab that coffee cup, I would get a mixture, his DNA and my DNA together. As far as it being difficult, you can have some mixtures where there's one contributor that donates a lot of DNA and the second contributor donates a little bit. For DNA interpretation, that is not challenging for me. Where it can become challenging is if you have 4 or 5 individuals within that sample all donating roughly around the same amount, it may be challenging for me to determine if a person is included or not.
And would you also agree that challenge exists in situations where you have what are called low quantities of DNA?
Again, that could be possible. So I could have low quantities of multiple individuals, which is simply just saying that I can't determine which piece of DNA goes with which individual. So that's possible.
What is drop-in?
Drop-in is where you have environmental DNA that's not inherent to that sample that's detected during our DNA process. DNA testing is very sensitive, so it could be that we have a peak that's detected, like I said, from the environment.
And what is drop-out?
Dropout is when you have an allele that is not detected or a piece of DNA information that is not detected. So in the DNA chart, there is no number associated with that particular location.
And degradation can cause dropout?
Yes.
So if you have a person at a particular location that is a type 1415, and because of degradation, that 15 drops out, what you're seeing on your chart is just the 14, right?
That is possible, yes.
And that presents a certain challenge, does it not? Because if the 15 is not there, you could misinterpret that as a type 1414, correct?
Not necessarily. So we have thresholds. We have something called the stochastic threshold. If that 14 is above that stochastic threshold, I'm confident, based on our validation, our testing, and my training, that the DNA type there is only a 14. If that 14 falls below that stochastic threshold, that could be indication that there is another peak. So when I'm interpreting, when I'm comparing, if that 14 is below threshold and someone is a 14-15, I will not automatically exclude them.
What is stochastic effects?
Stochastic effects.
I'm going to object at this point. I think we've gone beyond the scope of preliminary hearing. I think this is getting into 702 material that's not necessary for the probable cause determination.
All right. Mr. Burt?
I think it goes directly to the reliability of the testing results that the state introduced. I think the court has to understand the limitations and the potential sources of error in order to assess whether these results are reliable.
And in regards to this line of questioning, how far are you going to go on this line of questioning?
I have this one question and then I'm moving on.
All right, Mr. McBride.
I'll hold them to that.
All right, well, Mr. Burt, so the objection is overruled. You may proceed with that question.
You can answer.
Could you repeat your question, please?
Tell the court about stochastic effects.
Stochastic effects, when you have low-level samples during the DNA copying process, based on how the DNA is copied, you could have alleles that are copied better than other alleles.
Okay. Now, on another topic, I mentioned studies before. One of the studies that you're familiar with is called the PCAST report. Are you familiar with that report?
Yes, I am.
And tell the court what that is.
PCAST report is, PCAST stands for the President's Council of Advisors on Science and Technology. And this was a committee that was found, I believe, under the Obama administration that gave guidance on different areas of forensics.
Including how to deal with mixed samples and how to deal with samples that have low quantity of DNA.
I don't know that I would agree that it's how to deal with them. They gave some of their concerns on low-level samples and mixtures.
Right. And they also did a follow-up report to assess whether using the kind of software that you used in this case had been established as reliable, correct?
That is correct.
And what was the software that you used in this case to reach your statistical results?
The software is called StarMix, STRMIX.
And the PCAST report specifically addresses whether reliability has been established with respect to StarMix, correct?
I don't believe reliability came into question. I think PCAST thought that there needed to be additional testing as far as mixtures and low-level samples go.
Mixtures and low-level samples that had certain characteristics, right?
And that is correct, yes.
Including mixtures where what's called the minor contributor was in the sample below 20%.
That is correct. So the minor contributor would be an individual that donated less DNA to that sample. So PCAST called into question mixtures of 3 or more individuals with that minor or that low-level contributor making up 20% or less.
7 and 8 samples in this case were both mixtures, correct?
Yes, that is correct.
And did you determine what the proportion of mixture was between what I'll call the major contributor and the minor contributor?
So I did not calculate that personally. Part of the StarMix software, it does a couple different things. One, it takes a mixture and it uses math and biological modeling to try to break that mixture into its individual contributors. And then it also calculates a likelihood ratio, which is the statistic that I report. During that process, it does give an estimate of the breakdown of those potential contributors.
And what was, first of all, for the 7 sample, was the minor in there at less than 20%, according to StarMix?
Yes, it was. For one of the runs, when I compared to Mr. Robinson conditioning on Mr. Twiggs, it was a 5% to 95%.
Okay. And how about for the other sample?
For item 8, one of the contributors was 11% and the other was approximately 89%.
So,
Correct, yes.
and the concern expressed in this report, which was written by experts in your field, correct?
No, that is not correct. The PCAST report was written by individuals that were not practitioners or any type of laboratory personnel.
Right, but they list the experts who provided
Okay,
input
guys, I gotta stop this
into
for
that
just a
report, do
minute.
they not?
My
Yes,
live
they
stream
did.
makes me shut
One of them
down
was Bruce
every
Badoli.
6 hours and start
Correct?
over. As you
Correct,
can
yes.
see, we're
Who's
at
Bruce
5 minutes,
Badoli?
56 seconds.
He
So I'm
is
gonna pause it.
a
I'm gonna
DNA
restart.
expert within the field.
Everybody but on Rumble will have to
Well,
go
he
to the new
was
stream,
the
but
head of
Rumble,
your
you can
unit
stay on
for
the
a number
stream,
of years
and we'll be
before
right
you
back.
came on
So,
board, wasn't
just
it?
a heads
He
up.
was, yes.
Look for the new one
And
coming
he's
up
written
and watch- you
extensively
can watch
on
me do it in
forensic DNA
broadcast.
testing, has he not?
He has, yes.
We're gonna start
The report also